Okay. ಹೌದು ಹೌದು even once a contract permission to register the case. ನೋಡ್ರಿ ಇಲ್ಲಿ ನೋಡ್ತಾ ಇದ್ದಾರೆ ಟೈಮಲ್ಲಿ ಇದು ಸೋಮವಾರಕ್ಕೆ ಇದು ಬುಧವಾರ ಡೇಟ್ ಕೊಟ್ಟರು ಆರ್ ಎಸ್ ಮೂರಕ್ಕೂ ರಜಾ
ಯಾವುದು ಆರ್ ಎಸ್ ಡೇಟ್
11 ರಜಾ ನಮಗೆ ಸೆಕೆಂಡ್ ಸ್ಯಾಟರ್ಡೆ
11ರಿಂದ 14 ಗಂಟೆ ರಜೆ.
ಯಾಕೆ 13
ಅದು ಕ್ಯಾನ್ಸಲ್.
18 ರಜೆ
25 ಮಾಡ್ತಾರೆ.
ಹಂಗಾರೆ 1 2 3 11 ದಿನ ಅಷ್ಟೇ 11 ವರ್ಕಿಂಗ್ ಡೇಸ್.
This pertaining to GM police matter, my lordships, wherein an unlawful assembly has been assembled in my property, and they are creating havoc as well as unlawful interference.
Fish
my lordships.
matter?
Fish matter.
This court has no roster for the fresh matters. You have to mention before the other court.
GM police, my lord.
It's only till 2023.
ಇದು
Alright.
ಹೋಟೆಲ್ ನಂಬರ್ 11 go.
Yes, next.
My lords, it's a GM DRT matter, my lords. The petitioners have obtained an interim order from this court and they have not made any subsequent payment.
Take that.
I've filed an IA for vacating stay, my lords.
Yes,
Reporting settlement tomorrow.
tomorrow.
Memo for posting in pending matter ಮೇಲೆ
Pending what? MFA?
MFA arising out of workman compensation. This honorable court was pleased to permit the claimants to withdraw entire amount. Due to technical reason, my lord, that is the petitioner, appellants, not amended the caste title. Therefore, he is not
Yes, tomorrow. Yes,
much obliged.
yes,
One matter for return of TCR, my lord, to
yes,
withdraw the
tomorrow,
amount.
tomorrow.
That's made.
Yes,
That's your lordship disposed of on GMFC matter, my lords, directing the trial court to dispose of the recovery petition filed by the wife, my lords, within 2 months. It is 1 year, my lords, nothing has happened, my lords. We have been taking steps there. The trial court is adjourning for months together. I have filed an interim application in the disposed matter, my lords, seeking further action in the matter. That purpose. Please, my lords.
My lord, GM DRT matter.
that's tomorrow or something.
Lord, GM DRT matter, my lord, there is interim order, but it's not complied by the petitioner. my lord.
This also someday, as per the court.
I appear for the respondent bank loss. Interim orders complied. Subsequently, no payments have been made for
Take that also somewhere.
any day
Next
week.
Yes. Yes.
GM rest, my lords. I filed a IA for vacating stay. So,
Which year is the writ petition?
2019, my lords.
What is the matter about?
My lords, this matter is, I'm not aware of it, but
You get know the facts and come
my
back
lords,
tomorrow.
another memo, my lords.
Only one memo. Yes, next.
My lords, this matter was never posted before the lordships from 2023. This matter was previously posted and respondent seeks time for 3 weeks
You'll
to
see
file
there is-
objections.
There are so many matters which have not seen the light of the day from 2019 also. At the fag end, we can't take up the matters. Yes, call the list.
Serial number 18. May I request on 15th, my lord?
My lord, it's an Arakanate
But
matter.
Arakanate matter, which we have
Heard
argued.
in length.
Only one synopsis ಮಾಡ್ತೀನಿ.
Written agreement we
Complete
have to
I
file.
will file it on 15th and I will finish.
My lord, kindly.
Without taking much time of the court.
You should have done it because he has filed a vacate and I have already heard so many times.
Yes, otherwise may kindly be posted
Matter
for
finally on
judgment.
15th,
Yes.
no further time. Yes,
Okay.
interim order in that if there's interim order extended. Yes.
Serial number 30, my lord. I am for the petitioner. I have informed the other side. It may be taken on Friday, my lord.
Why?
Senior has inconvenient today. He is not in station. Henceforth, short.
2026 matter and you seek time.
Please, my lord.
No interim order. That means no urgency. We'll have it after
No,
vacation.
my lord. Friday it may be taken, my lord.
This is matter on Friday. If you ask for time on Friday, I'll dismiss it on that ground. Yes.
Serial number 33 and 34, which Umesh for some time. He is not in station.
Any, all these matters to be admitted, I'll admit it. I'll admit all these matters and post it for final hearing. We'll see. Yes.
Serial number 45, I am the petitioner in this matter. I seek time in this matter to file affidavit, my lords. The client has met with an accident, so hence he cannot come to sign the affidavit, my lords. 2 weeks, my lords, or maybe a week.
Yes, this matter on 22nd.
Grateful, my lords.
Yes.
My ladyship, serial number 46, kindly adjourn for 2 weeks. I've engaged a senior counsel, Mr. Srivas sir. So kindly,
This petition is not maintainable. Hindu Leyland Finance Limited.
serial number 46.
That's what I'm saying.
Yes.
Respondent is Mrs. Induja Leyland Finance Limited.
My ladyship, the senior counsel will argue on this. Kindly. Or anything
When this
after.
matter has come up, it has already come up before the court. On that day, time is sought. Now again it's coming up. And again you seek time today.
My ladyship, last opportunity.
If these matters are not there, another 2 matters would have come in the list. This is matter on 16th, no further adjournment.
Ladyship, 17th.
17th, no further adjournment. Yes. All these final hearing matters of MFAs give the date. Second list.
Serial number 4.
In list number 2.
List number 2, serial number 4.
Mm.
File has been requested my land friend to get Xerox.
Last time also they sought argument on this ground.
Today only I will get the papers.
But he has no file.
15th period. Today only I will.
You don't have the file. Let us pass orders in this.
I will have to get the instructions from the
Only to
party.
consider their representations and complaints. my lord.
I will do
No
that,
such
my lord.
complaint.
Kindly have it on 15th itself.
This matter also list on 15th, no further adjournment.
Please. My lord, serial number 10, party has taken away the file, my lord, taken back the file. It is now dismissal for dismissal. I have contacted the party, he is not responding, my lord.
Then what you're supposed to do?
It
You have
has
to
to
file
be-
your retirement memo.
Please, my lord, I will issue notice and I will issue notice to him and.
This is matter on 28th. By the time whatever should be done, you
Please,
should
ma'am,
do.
please.
Otherwise, I'll dismiss it.
Please, my lord.
Yes, under the same caption on 10th, on 22nd. Yes.
Appearing with petition, Your Lordship. I was awaiting mediation report. It's listed for awaiting mediation report.
What is this awaiting mediation report?
Yes, Your Lordship. PLCG. With proxy.
What happened to the mediation?
No, Your Lordship. It's not been. It's not been instructed.
It is not settled.
Not.
Huh?
It's not instructed.
Not settlement.
Yes.
For article.
TCR is there. TCR is also awaited. This is matter 2014 matter. List this matter on 25th of April. By the time the registry shall call for the TCR. What is this office note? Where is that office note? As per the office note, the writ petition was ordered to be listed on 24/9/2025. The same was sent to board branch on 22/9/2025. Thereafter, the file is misplaced. The registry has made all efforts to search the file in concerned branch, but the file is not yet traced. The counsel for the respondent has placed the given the copy and also the order sheet is taken from the official website, considering the fact that the file is misplaced and the registry is searching for that. The registry is permitted to rebuild the entire file. This is matter on 24th.
Interim order restrict.
Interim order earlier granted is extended till then. Petitioner, both the petition and the respondent has furnished the entire file. Yes. Highly obliged.
I appeal for the petition. My lord, this petition has become infructuous. I'll withdraw this.
I appeal for the respondent bank.
Give the file.
This is yesterday's matter, my lords, where sale has not
It
taken
is
place.
submitted, the petition is filed questioning the sale notice. When counsel appearing for the respondent submits that pursuant to the said notice, no sale has taken place. In the view of the matter, nothing survives for consideration in this petition. Accordingly,
My lords,
dismissed.
one submission, my lords, they had challenged the demand notice, my lords. By way of an IA, they were challenging sale notice. Originally, they have challenged the demand notice.
Petition is filed questioning the notice that is issued under section 13(2) and also filed an IA questioning the sale notice. When a 13(2) notice is issued by the bank, the remedy available to the petitioner is to reply to the same, but he cannot file a writ petition questioning the same. Then coming to the IA, coming to the sale notice, as the sale has not taken place, there is nothing to be considered. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to respond to the notice under section 13(2). Yes, accordingly disposed of.
But for the petitioner, my lord, in this matter, my lord, I'm neither the borrower nor the guarantor. The asset in question is also not a secured asset. There is an ambiguity in the impugned order which is being exploited by the bank to take possession of my property. My lord, the impugned order is Annexure A, page number 27, my lord. There is the scheduled property, there is the description.
No, why did you come before this court? Why not before the trial judge?
Because the matter falls outside the ambit of SARFAESI, my lord. Section 17, my lord, references section 13, subsection 4. Now, my lord, section 13(4), in case the borrower fails to discharge his liability, I'm not the borrower.
17.
No, 17.
To look at is 17.
Yes, my
Please
lord.
come to 17.
17 references section 13,
To
and hence
anyone.
I'm jumping, but I'll go to section 17,
Yes.
my lord.
Any person.
Any person, including borrower,
Yes.
aggrieved by any of the measures referred to in subsection 4 of section 13. So we have to go to section 13, subsection 4, to see what the measures are, whether I'm aggrieved by a measure taken under section 13(4).
No, it is settled law that anybody who is not a borrower also can go before the DRT. There is no ambiguity on that. It is already interpreted by the courts.
My lord, I am relying on several judgments, one judgment of the Honorable Apex Court and one judgment of a coordinate bench.
Pass on the judgment. Yes.
My lord,
Which
the first
paragraph?
one is a 2020 judgment. It's paragraph 12 on page number running page number 8, my lord. Going by the law laid down by this court in Axis Bank, the secured creditor would be entitled to proceed only against the secured assets mentioned in the notice under section 13D, 13(2) of the SURFACE Act. In that case, the deposit was made to maintain an appeal before, those are specific to that case. Here, even the section 13(2) notice, that ambiguity continues, which is being exploited. It excludes my property because my property was purchased prior to creation of the mortgage.
No, still I'm not convinced on that point.
Yes, my lord. The next judgment, my lord, is a coordinate bench judgment,
Yes.
paragraphs 23 and 24, in writ petition number 17494 of 2025, MN Kumar. 23, 24
Yes, please read.
is on running page 37, my lord. The expression secured assets of the borrower used in clause A of section 3(4), subsection 4, leaves no manner of doubt that the secured creditor can proceed to recover the secured debt only by taking possession of the secured assets. The asset in question is not secured.
No,
They are
that
trying
will
to
be-
take
that-
over
that
possession.
That issue will be decided by the DRT. Now we are on the point whether the DRT has jurisdiction to decide your dispute or not. That's what is your dispute?
Yes, my lord.
Submission. For
My
that-
lord,
for that-
section 13(4) again is very clear. I can make use of section 17. I can invoke jurisdiction of DRT if it is a secured asset under section 13(4), but it's not a secured asset. That's my primary submission, my lord.
Yes. So no other judgments on that.
There are two other judgments that I'm relying on. BSFC versus Chota Nagpur Minerals and others. It's a 2009 judgment, paragraph 20
Yes.
of the judgment.
That is
This
Bihar
is
State Financial Corporation.
yes, my lord, but this is under a different act. But then that provision is in peri materia, section 13(4).
Para number?
Para number 20, running page 47. A bare perusal of the aforementioned provisions would clearly go to show that the statutory power vested in the corporation must be exercised only in respect of the properties which were mortgaged. This property was not mortgaged. There is no charge created in the property. I have produced the encumbrance certificate along with the petition. So hence it is not a secured asset and it would not come under the ambit of SURFACE. SURFACE cannot be invoked against my property, my lord. That's my humble submission.
Next, Bank of India, which para?
Then citation 4, paragraphs 10 and 11. This is in connection with the creation of a charge. When a charge is not created, paragraph 10, that is the last page, running page 52. As far as the land is concerned, we agree with the learned judge that a mere undertaking to create a mortgage is not sufficient to create any interest in any immovable property. There is no interest created because I have neither borrowed nor have I guaranteed. And my purchase antedates the creation of the charge. And hence it does not come under SURFACE. My lord, the whole, the nub of the matter is the ambiguity that is there in the order of in the impugned order. My lord, and that's on page number.
We'll hear him on that.
Yes, my lord. Yes, my lord.
My lord, the property is already mortgaged 21/2017, my lord. 2017.
On the aspect which he has already argued about, that he can't go before the DRT under section 17 and all these issues cannot be decided by the DRT. What is your submission on that?
My lord, there are 4 writ petitions filed by the subsequent purchasing challenging the section 14 order. In that, 2 writ petition number 20073 of 22 and 8298 of 25 disposed by this honorable court and directed to the petitioner to approach the DRT. The same.
So those numbers.
Yes, my lord. Sorry, my
So
lord.
the numbers?
WP 20073/22 and 8298 of 25.
Right. Who are they?
Pardon, my lord.
Who are the petitioners?
That's the same lane council only.
Same
lane council.
Any other submission
My
on the
lord, there is a
maintainability?
fundamental difference between those petitions and the petition in question here.
Forget about what orders are passed in the earlier writ petition, but what are your, any further submissions on the
There is-
maintainability?
Submitting the copy, order copy.
Yes.
There's just one submission, my lord. In the instant case, I obtained an encumbrance certificate prior to my purchase. So I have exercised due diligence that any person of ordinary prudence would do. Based on that, there was no charge created on the property. I have purchased it. I'm a bona fide purchaser for value. Hence, my lord, it does not come under SURFACE at all. The problem is the scheduled property describes the property and it goes on to state property standing in the name of respondent number 3, who is the borrower. Now, conveniently, the bank is excluding that from the interpretation, trying to take over possession of all properties in this. There are 12 apartments there. So even those apartments that were sold prior to creation of security interest, they are looking to possess.
Please come. The present writ petition is filed. Seeking the following prayer. Yes.
Incidentally, my lord, there is also an FIR that has been filed and a charge sheet has been registered against the bank officials and the borrower. And the proceedings are ongoing. It's in crime number 41 of 22. Crime number 41 of 2022, my lord.
Yes, sir. The present writ petition is filed. Seeking the following prayer. The petitioner has purchased a property by way of a registered sale deed on what is the date of your purchase?
19/9/2019. I purchased it from my predecessor in interest, who had purchased it in 2013, prior to the creation of mortgage.
2019. And the predecessor entitled to the petitioner has purchased the property in the year 2013. It is stated that after selling the property to various purchasers, respondent number 3 applied on 13/2/2017 for a loan and borrowed ₹3 crores on 21/2/2017 from respondent number 2 bank by mortgaging the property fraudulently by concealing the factum of sale. Thereafter, respondent number 6, the daughter of respondent number 3, and a 17-year-old minor at that time, too applied for a loan and borrowed ₹67 lakhs on 31/3/2018 from respondent number 2 bank by again mortgaging the property fraudulently by concealing the factum of sale/conveyance of the flats. Even the BBMP has issued a kata in favor of the petitioner. Petitioner has paid the property tax on the immobile property. He's been paying the property tax on the immobile property till date. Thereafter, without informing the petitioner, respondent number 2 bank served the notice dated 18/10/2021 on respondent number 3, 4, 5, and 6, recalling both the said loans and demanding forthwith the payment of a total sum of ₹4 crores 1,36,152. The petitioner was not served a copy of the said notice. Thereafter, the bank has filed an application before the magistrate under section 14 of the Surface Act by filing criminal miscellaneous number 202 of 2022. for the enforcement of the security interest and praying that the respondent number 2 bank be put in possession of the said property mortgaged by respondent number 3 and 6. Then an order was passed on 28/2/2022. When a possession notice dated 2/3/2022 was issued, when the petitioner has come to know about the pending proceedings, petitioner has also approached the DRT by filing an application on 7/3/2022 under Section 17 of the Surfacer Act, praying that the respondent bank be restrained from taking possession of the property. However, there is an apprehension that respondent number 1 officer and respondent number 2 bank can forcibly take over lawful possession of the petitioner's property. Hence, the petitioner has come before this court. Land counsel for the petitioner submitted that there is fraud, there is a collusion and fraud between the borrower and the bank. The property which is sold in the year 2013, the bank has granted the loan, and it is a contention that the property is not the secured asset. The property is not mortgaged to the bank. Petitioner is neither a borrower. Petitioner is not the borrower or not the guarantor. In those circumstances, the respondent bank has no authority to initiate the proceedings under the Surfacer Act. Next para. When this court has specifically on a specific query from this court with regard to the maintainability of this appeal and this writ petition before this court, when there is an effective alternative remedy before the DRT, and particularly when the petitioner has already approached the DRT by filing a essay, land counsel for the petitioner has submitted that the DRT has no jurisdiction to deal with the issue, in the present case. It is submitted that Section 17 of the Act says any person, including the borrower, aggrieved by any of the measures referred to in subsection 4 of Section 13, taken by the secured creditor or his authorized officer under this chapter, can approach the debt recovery tribunal having jurisdiction, relying on Section 13(4). He submits that it refers to in case the borrower fails to discharge his liability in full within the period specified in subsection 2, the secured creditor may take recourse to one or more of the following measures. Even a reading of Section 13(4) makes it clear that our action can be against the borrower, and any subsequent actions that emanate from that, then the application under Section 17 of the party can approach under Section 17. A reading of Section 13(4) along with Section 17 makes it, it is a submission that makes it clear that only the borrower can approach the DRT. He had relied on the judgment of the Apex Court in KUT Energy Private Limited and others versus authorized officer, Punjab National Bank, paragraph number 12, extract. He relied on another judgment of the coordinate bench of this court, Mr. M.N. Kumar versus ARC and another, arising out of WP number 17494 of 2025. He relied on paragraph number 23 and 24, extract. Then he was also relied on BSFC versus Chota Nagar Minerals and others, reported in 2009 to SCC 471, paragraph number 20. He also relied on BOI versus Abhay T. Narottam and others, reported in 2005-11 FCC 520, para number 10 to 11. Relying on these judgments, land counsel submits that the borrower cannot, a third party cannot go before the DRT under Section 17 of the Surfacer Act. Next para. Land counsel appearing for the bank submits that The, the other flat owners in the very same apartment had filed WP number 20073 of 2022 and WP number 8298 of 2022, and by order dated 5th January 2026 and 20th November 2025 respectively, a coordinate bench of this court, having considered the respective contention, has observed that the aggrieved party has an effective alternative remedy under section 17 of the Act, and also the petitioner is given liberty to avail the alternative remedy. Basing on this, it is submitted that the petitioner can avail the alternative remedy before the DRT. Next para. Having heard the counsel from either side, there is a material on the record. The first submission of the then counsel to the petitioner with regard to the jurisdiction of the DRT and whether the petitioner can approach the DRT, who is the third party, is concerned. The section 17 of the Act, the Surfacer Act, reads thus: extract. As per the same, any person, including the borrower, aggrieved by any of the measures referred to in subsection 13(4), can approach the DRT. There is no ambiguity in the said section, and it is the consciously the word any person and within the brackets including borrower is incorporated in section 17 of the Act. Hence, in none of the judgments which the petitioner is relying on, it has never dealt with the issue with regard to whether the third party can approach the DRT and whether the DRT has got the jurisdiction or not. A plain reading of section 17 makes it clear that any person, including the borrower, aggrieved by any of the actions, measures taken by the bank, can approach the DRT. All the questions that are raised before this court, or all the submissions that are made before this court can as well decided by the DRT. The petitioner could not make out an exceptional case where on a question of law, the issue that cannot be decided by the DRT and that has to be exclusively decided by this court. In those circumstances, the Honorable Apex Court time and again has deprecated the practice of the High Court in entertaining the writ petitions. In that view of the writ petitions, and apart from that, similarly situated persons were relegated to the DRT by orders passed in the writ petitions referred supra by the coordinate benches of this court. In that view of the matter, this court do not find any reasons to entertain this writ petition. Accordingly, the writ petition is disposed of, giving liberty to the petitioners to avail the. You had a stay in this?
We had a stay in this, my lord.
When is that?
Stay in this. 2024.
When is the interim order?
No stay. There is a stay.
No, I think there is no interim order.
No precipitative action should be taken. I think there is that order. Not in an IA, but direction is issued. My lord, there would also be the issue of limitation, my lord.
That's what.
Yes.
On 27/11/2024, no, it should not be in the order in the discussion. 27/11/2024, the coordinate bench of this court has passed an order restraining respondent 1 and 2 from auctioning or bringing the property to the sale till the next date of hearing. That interim order has continued from time to time. Hence, this court has passed the following order. The petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy before the DRT. The petition shall have the benefit of Section 14 of the Limitation Act. Number 3, the interim order that is granted by this court on so and so shall remain in force for a period of 4 weeks.
Profusely obliged, my lord.
Lord, so I'm for a respondent number 1. My lord, the matter may be taken up tomorrow or Wednesday, my lord. There is some personal inconvenience for today. That's a limitation matter, my lord. Supreme Court judge.
You only, yesterday you made a
There's a
mention.
death, my lord. That's the reason. Today morning.
Is this matter on, when are the other matters coming? Post it on that.
We are ready for tomorrow itself.
21st. Yes, next.
For the respondent, my lord. I have complied the interim order.
Argue the matter.
Now he undertakes to file affidavit or 3 months stamp is
Could your
required.
lordships kindly take the previous order, my lord? Last occasion also same submission was made and interim order was extended.
This is matter in the next week as parted along with, by that time, the petition shall file an undertaking affidavit before this court as submitted that he will pay the amount within 3 months or else the writ petition will be dismissed on the next
Tomorrow,
day of
Lord,
the
and
tomorrow,
what is,
one day.
Lord, what is
tomorrow.
challenged?
tomorrow, doesn't matter. Yes, finally, is this matter tomorrow? If the undertaking affidavit is not filed, the writ petition will be dismissed.
Please, oblige.
Kindly pass over the matter.
Is pass over. Yes.
May I please, please. Judge, I beg to appear for the petitioner in this matter, my lords. This writ petition raises the issue, my lords, of non-compliance of, my lords, the RBI Prudential Framework for Resolution of Stressed Assets, my lords, circular, dated 7th June 2019, and, my lords, impugns the consequential action, my lords, taken, my lords, by the financial institutions, banks. Because what is most relevant, my lords, is now the regulator himself, the Reserve Bank of India, has filed an affidavit before your ladyship, my lords, indicating the correct construct, my lords, and, my lords, the intent, my lords, of its own circular. The controversy arose like this. If your lordship just permits me 2 minutes to give the background, and then, my lords, I'll come, my lords, to the circular itself. My lords, there are 5 lenders in all. There is State Bank of India, Canara Bank. Your lordship will just note from the array of respondents. Respondent number 1 is the Reserve Bank of India. Respondent number 2 is the Union of India through the Ministry of Finance. 3 is, my lords, Deutsche Bank. 4, 5, 6, and 7, State Bank, Canara Bank, ICICI Bank, and Kotak Mahindra Bank, are part of a consortium who lent certain, my lords, facilities, my lords, to, my lords, the petitioner before your lordships. Now, respondent number 3, Deutsche Bank, my lords, was not part of this consortium. My lords, when, my lords, the account, your lordships are aware, under the RBI circular of 2019, once an account, my lords, shows incipient, my lords, indications of stress, the lenders have to, my lords, proactively, my lords, take measures to alleviate that stress. So, my lords, under the circular, there are, my lords, provisions by which a joint lender, my lords, lenders meeting a review meeting has to be conducted. And in that meeting, my lords, all the lenders, in our respectful submission, have to participate and, my lords, take measures, my lords, to alleviate the signs of stress in the account or take such other decisions as they may deem fit. Now, my lords, our respectful submission here was, my lords, that no such review meeting as, my lords, mandated and, my lords, directed by that circular of the Reserve Bank of India was ever held, my lords, between all the lenders, my lords, including respondent number 3. This fact, my lords, is not disputed. That's very important. Because respondent number 3 acknowledges that it was not part, my lords, of any joint review meeting. The stand taken was, and that's where, my lords, the RBI affidavit assumes significance. The stand taken was, my lords, since respondent number 3, Deutsche Bank, was not part of the consortium, therefore it was not incumbent upon respondent number 3 to participate in a joint review meeting with the other lenders who are respondents 4 to 7. That was the stand taken. In view of that stand, and to, my lords, seek clarity on how, my lords, this circular is intended to operate, your lordships asked RBI to file an affidavit who, my lords, is the regulator as well as the issuer of, my lords, that circular, and therefore, my lords, is ideally and perfectly situated, my lords, to explain how, my lords, the circular was intended to operate in a situation such as this. In consequence of that, my lords, RBI files an affidavit, and, my lords, your lordships will have that affidavit with me, which, my lords, in our respectful submission, clarifies the position and really, my lords,
By the RBI. Filed on which day?
just permit me a minute.
Who represents RBI? Who's the counsel?
10th March 2026, my lords, I'm told they handed over the affidavit to your ladyship, to your lordships, my lords. I don't know if it's on your lordship's record or not.
It's there.
It's there. I'm grateful. Lordship will have paragraph 2 with me.
Yes.
I submit that answering the issue raised by this honorable court, this respondent humbly submits that in order to understand the terms, all lenders, the footnote 1 at page 2 of the Prudential Framework for Resolution of Stressed Assets dated 7th June 2019 needs to be read too, which is as follows. For the purposes of these directions, lenders shall mean all entities mentioned in paragraph 3 unless specified otherwise. Now, this paragraph 3 reads as follows. 3. The provisions of these directions shall apply to the following entities: scheduled commercial banks, all India term financial institutions, small finance banks, and systemically important non-deposit taking, non-deposit taking infrastructure. We are really concerned with 3A because, my lords, all our lenders fall under 3A. Now, let's please see the next line. It's very important. Hence, in the instant case, all lenders used in para 9 of that circular, which I'll presently place before your ladyship, used in para 9 would refer to all the banks who have exposure to the borrower. In other words, it is irrelevant as to whether that bank is a member of a lending consortium or not. Now, 3. I humbly submit that Clause 9 of the said Prudential Framework of Stressed Assets would mean that once a borrower is reported to be in default by any of the lenders, all lenders, and that's what is important, shall undertake a prima facie review of the borrower account within 30 days of such default. Because here the default is stated to be in 2024. I'll show the dates of default indicated by each lender. During this review period, lenders may decide on the resolution strategy, including the nature of the resolution plan, the approach for implementation of the plan.
I've gone through the entire affidavit.
I'm so very grateful. So, my lords, now the issue falls in the narrow compass. Because admittedly, this joint review meeting, which is contemplated by the circular, has not been held, my lords, with all, my lords, participation of all the lenders. That's an admitted position. Because Deutsche Bank respondent number 3, who has not filed an affidavit here, my lords, has indicated to us in communications that they have not participated because they're not part of the consortium. Now, please have a look, my lords, at the circular itself with me, the Prudential Circular. That your lordship finds, my lords, at my lords Annexure H, Ink page, my lords, 128 of your lordship's, my lords, paper book.
Yes.
My lords, your lordships have, my lords. It is introduction, the first line itself, in exercise of the powers conferred by the Banking Regulation Act and the Reserve Bank of India Act 1934. The Reserve Bank, being satisfied that it is necessary and expedient in the public interest to so do, issues the directions. Therefore, this circular carries statutory force. Then, Millards, para 3, which your ladyship has already seen, Millards, from Millards, the circular of the Reserve Bank of India. 3A is, Millards, what is relevant for us. Now, Millards, your lordship will see 6 over the page. 6 with me. Lenders shall recognize incipient stress in loan accounts, etc. and classifying such assets as special mention accounts as per the following categories. Now, Millards, please have at page, Millards, 130, Millards, paragraph 9, clause 9 of the circular. All lenders must put in place board-approved policies for resolution of stressed assets, including the timelines for resolution. Since default with any lender is a lagging indicator of financial stress, it is expected that the lenders initiate the process of implementation of a resolution plan even before a default. In any case, once a borrower is reported to be in default by any of the lenders mentioned at 3A, which is, Millards, the line explained by the Reserve Bank of India and its affidavit, lenders, which term is also explained in that affidavit, shall undertake a prima facie review of the borrower account within 30 days from such default. During this review period of 30 days, lenders may decide on the resolution strategy. That's their discretion, including the nature of the resolution plan, the approach for implementation, etc. The lenders may also choose to initiate legal proceedings for insolvency or for recovery. But these decisions, in our respectful submission, conjoint reading of the circular as well as the affidavit, can only be taken by all the lenders in, Millards, a joint review meeting, and, Millards, within the timeline stipulated, Millards, by, Millards, the RBI circular. That meeting in our case, Millards, has, Millards, never happened. Why do I say that, Millards? Please, Millards, have a look at 1 or 2 letters with me, Millards, written, Millards, by the Deutsche Bank respondent number 3. I don't know, Millards, if they are present in court today. Then, Millards, we could straight away, Millards, I could, Millards, place, Millards, before your lordship the fact that they have not. But, Millards, please see. Your lordship will see with me only 1 letter. 23rd of August 2024. The letter of 23rd of August 2024 at Millards, annexure number KK, ink page 375. And this, Millards, your lordship will see, it's not readable.
This another volume. Yes.
Is it, Millards, legible? Because I find that my copy is not particularly legible.
Yes.
I don't know if your ladyship's copy is any better.
No, I think this copy is also in the same state. This thing, not legible at all. Anyhow, please read.
Then, Millards, let me draw your ladyship's kind attention to another document. Please have with me, Millards, again, respondent number 3.
Page number?
Millards, page number 425. Oh my goodness.
Yes.
Millards, your lordships will have. No.
Yes,
No, Millards, I'm sorry. No, Millards, please have with me page 422. I'm so sorry.
Yes.
Please have with me page 422.
Yes.
Though, Millards, it is, Millards, a letter written by the State Bank of India. please have at page 424,
Yes.
please have page 424, para 5 at the top of the page. As per June 7 RBI circular, this is the SBI writing, which is, my lords, the lead consortium member, of which, my lords, respond number 3 is not a party. As per June 7 RBI circular, in case where the resolution plan is to be implemented, provided any decision agreed by the lenders, etc., that is, my lords, in the instant case, the next paragraph, the resolution plan was discussed in detail in the consortium meeting. In the consortium meeting held on 20th of September 2024, all the lenders have unanimously rejected the resolution plan. Hence, as per June 7 RBI circular, your resolution plan cannot be considered. So, my lords, what has been held and what has been discussed is in a consortium meeting, not, my lords, in a meeting of all the lenders. And, my lords, your ladyship, my lords, will also see at page 422, just 2 pages before, my lords, paragraph, my lords, Roman 1, my lords, the sub-paragraph to that.
Yes.
All the working capital consortium agreements executed between the company and the banks was executed between SBI, Syndicate Bank, which is now Canara Bank, ICICI Bank, and Kotak Mahindra Bank only. No agreement was signed with Deutsche Bank by any of the above lenders. As such, consortium lenders are SBI, Kotak, Canara, and ICICI. Hence, it is evident that Deutsche Bank is not part of the consortium and reiterate you to settle their dues separately.
Para 6 of SBI reply.
Now, my lords, your lordships will also have with me, so the stand is clear. Deutsche Bank, even though it is admittedly a lender, simply because it is not part of the consortium, they have, my lords, not chosen to include Deutsche Bank in a joint review meeting, which, my lords, is mandated, my lords, by that circular. And this position is also crystallized, my lords, in the counter affidavit filed by the State Bank of India, the statement of objections, my lords, filed by the State Bank of India, my lords, at paragraph 6 of that, my lords, reply. Now, Deutsche Bank hasn't filed a reply, my lords, or a statement of objections, despite directions.
What is the date?
I can therefore, my lords, the copy I have, unfortunately, my lords, is 1st September 2025. 1st September 2025.
SBI objections.
SBI objections. I'm grateful.
Filed on 3rd September.
3rd September.
3/9/25.
3rd September 25.
And paragraph 3 of
Okay. How come is here? You have a copy of it?
Yeah.
Take that. Yes.
This is paragraph 6. Just one paragraph.
Yes.
It is submitted that the respondent number 3 is not part of the consortium and the petitioner has to clear the dues of the respondent number 3 independently. This fact is very well within the knowledge of the petitioners. in the entire petition, the petitioner has raised the voice mainly on respondent number 3, who, as I indicated, my lords, has not yet even filed a statement of objection. Now, my lords, what has happened is, and we have consistently written, and I can show those letters to your ladyship, that, my lords, our proposals should be jointly considered in a joint review meeting in the presence of all the lenders, not just the consortium lenders, but, my lords, also respondent number 3, Deutsche Bank. Respondent number 3 doesn't take a stand. Now, my lords, what happens is, my lords, they then, without complying with the circular, and my lords, as I indicated, the regulator is now clearly, my lords, indicated how the circular is to be interpreted. Without compliance with that circular, which has statutory force, my lords, they start recovery proceedings. They issue 13-2 notices, they issue, my lords, 13-4 notices, my lords, and in respect of, my lords, the several assets given as collateral have also taken physical possession, my lords, of one asset. That, my lords, again is undisputed. In respect of the others, my lords, Section 14 proceedings are pending. Now, my lords, our entire writ, therefore, is, my lords, predicated on non-compliance. Our writ application is predicated on non-compliance. There are 3 limbs of my challenge in the writ. The first is non-compliance, my lords, of this RBI circular.
Yes.
And therefore, my lords, the RBI circular itself mandates that it is only in a meeting of all the lenders that you will decide the future course of action in relation to an account which is showing signs of stress. Whether it is rehabilitation, whether it is revival, whether it is restructuring, whether it is recovery.
Yes.
But, my lords, no decision can be taken unilaterally on either of these 4 aspects without, my lords, holding a joint review meeting, admittedly, which has not been held in the present case. Now, therefore, my lords, and that was the first limb of my submissions. Now, therefore, my lords, your ladyship will kindly have turned with me, my lords, to page 70 of my writ application. Those are my reliefs, my lords, prayers in this writ application. There are 2 other facets, my lords, which I'll indicate briefly of my writ application. But, my lords, in the first instance, please have a look, my lords, at page 70. Our first writ relief sought, my lords, is, my lords, seeking a writ of mandamus, etc., directing respondents number 3 to 7 to comply with the prudential framework dated 7th June 2019 and convene a review meeting. My lords, that period is indicated of 30 days of all the lenders, respondents number 3 to 7, such that a joint decision can be taken with respect to the resolution settlement, including, my lords, we had given a certain proposal, my lords, in 2025, with respect to the debt of the petitioners, and consequently, and that's the consequential prayer, my lords, consequently quash and set aside the impugned demand notices dated 2nd May 2024 and 30th November 2022, should be 24, which and all subsequent recovery actions against the petitioners, security providers, and the secured assets. And then, my lords, issue a writ of certiorari or any other appropriate writ declaring that the classification of debt by the petitioners by respondent number 4 is illegal. That's, my lords, now, my lords, the second aspect. My prayer A, my lords, is my relief A is relatable, my lords, to the submissions, my lords, I have made so far. Now, my lords, the second aspect, my lords, of the writ, and I'll explain that, my lords, in 2 minutes. There are 3 aspects. And, my lords, very frankly, my lords, if the respondents are directed to consider, my lords, my proposals within the framework of the RBI circular, the second and third aspect, my lords, in fact, can be left open to be, my lords, considered in that, my lords, review meeting itself. I will, my lords, just briefly indicate for your ladyship's kind consideration what is the second and the third issue. The second issue is, my lords, that the declaration of NPA, the declaration of NPA itself, my lords, is, my lords, contrary, my lords, to the prudential restructuring framework norms issued by the RBI. My lords, why do I say that? Very, very briefly, without drawing your ladyship's attention to any of the State Bank of India, my lords, classifies my account as NPA, and in respect of which, my lords, I have made a petition to the State Bank of India, my lords, for a writ of mandamus. Now, my lords, the second aspect, my lords, of the writ, and that's the consequential prayer, my lords, on 30th of April 2024. Because that, my lords, fact is not in dispute. There is the document, my lords, the section 13, subsection 2 notice itself indicates the date. That ladyship may just note the page, because for the time being, my lords, I'll just indicate broadly what the point is. Page 96, my lords, ink page 96, annexure number C, the notice under 13.2 issued, my lords, by the State Bank of India. My lords, itself indicates, my lords, when, my lords, the account was, my lords, declared by as NPA by the State Bank of India. Now, my lords, why this date is relevant is, your ladyship knows, my lords, that there has to be a clear period of 30 days, 90 days, I'm so sorry, 90 days from the first date of default to the date on which, my lords, my account can be declared as non-performing asset. Your ladyship saw in that circular, my lord, which I had placed before your ladyship, my lords, SMA 0, SMA 1, SMA 2. There are 3 phases. Now, my lords, in this case, what is relevant is, my lords, by a letter of 8th of February 2024, 8th of February 2024, which is at page 255, annexure number AA. And again, and I'm saying, please don't turn to it for the moment. SBI itself, my lords, indicates that my account is regular. As on that date, which is, my lords, 8th of February 2024. The rest is, my lords, 90 days, my lords, from 8th of February 2024. Certainly, my lords, don't lapse, my lords, by 30th of April 2024, when, my lords, my account is declared as NPA. Admittedly, 90 days would, my lords, elapse only, my lords, on 7th of May, my lords, 2024. That's another aspect of the matter. But as I said, my lords, these aspects, my lords, can also be considered. Ultimately, my lords, we are, my lords, a age-old institution. We are, my lords, we have run into financial difficulties due to COVID, and we are extremely clean. My lords, we have assets, my lords, we have collaterals, we have securities, which will be adequate, my lords, for the purposes of, my lords, uh, restructuring of the loan. We are extremely keen, my lords, that, my lords, in the presence of, my lords, all the lenders, my lords, a joint review meeting be held, my lords. We are, my lords, happy to give a proposal, and, my lords, we are only requesting, my lords, if, my lords, in compliance with the RBI direction, such a meeting is, my lords, directed to be called to consider that proposal, my lords. And, my lords, we would, my lords, please take it from us. We are, my lords, an old institution, my lords, in the state. My lords, we have been running this business for many, many years now. And, my lords, we are extremely keen, my lords, to, my lords, ensure that, my lords, the company doesn't slip into, my lords, any, my lords, litigation, and, my lords, the debt is resolved.
Yes.
My lords, there is a third aspect of the matter. And I'm just again indicating that without getting into the document. As I said, my lords, issues number 2 and 3 can be taken care of during the course of a joint review meeting itself. The third issue is, my lords, in relation to, my lords, what is, my lords, a scheme, my lords, which was taken out, my lords, by, my lords, the respondents at the time, my lords, when COVID struck the country, my lords, in fact, the entire world. This, my lords, was a scheme nomenclatured, my lords, as the Emergency Credit Line Guarantee Scheme. In short, my lords, ECLGS scheme. It was taken out, my lords, by all the banks. Again, my lords, pursuant to, my lords, directions given, my lords, by the regulator. Under the ECLGS scheme, my lords, to tide over the period of financial crisis, which, my lords, every business in the country faced as a consequence of COVID and its aftermath, my lords, an emergency credit line was, my lords, mandated to be advanced. What happened in this case, my lords, and this is, my lords, slightly peculiar, is that, my lords, while, my lords, sanction letters were issued, sanctioning that line of credit by the financial institutions, namely respondents 3, 4, and 5, and those are all on record. My lords, what happened was that, my lords, the credit line which was to be disbursed to the company was actually never disbursed to the company. What happened was, my lords, the the credit line was disbursed literally from one pocket of the bank and Millards pocketed in the other pocket of the bank. It never reached Millards, the hands Millards of the company, which it would have utilized Millards in those times, Millards of financial distress, to tide over the financial distress. Now, in this context, Millards, just have a look at the scheme. And I'm just indicating this is something which the banks can consider while considering Millards, my proposal for Millards restructuring, Millards or
regard, you
revival.
have already,
Please have a
in this
look.
regard, 1 minute. In this regard, you have already given a representation to the Ministry of Finance to consider your case.
Yes. I've already done that.
Yes.
And I just wanted to show one aspect of the scheme. The scheme, Millards, your ladyship will find at annexure number P in ink page, Millards, 184 of your ladyship's paper book. That's where the scheme starts. And Millards, just have page 199 to indicate, Millards, how the scheme is meant to work.
Yes.
Please have a look at Millards clause 10.
Yes.
Nature of the account and tenor of credit under the scheme. Please see Roman 1, and Millards, that's very important. A separate loan account should be opened for the borrower, distinct from the existing loan accounts for coverage under the scheme. And then, Millards, the other terms and conditions, Millards, are indicated. Now, Millards, just have one more page with me of this scheme. Just permit me a moment, Millards. I'm just looking for that clause. I'll come back to it. I'll come back to it. A representation, as your ladyship correctly points out. Let's please have page 1. So
Page
194, 194. What is that? Lending institutions.
Yes.
And just have a look, Millards, at Roman 10. MLIs. MLI, the term MLI refers to member lending institutions. Would be required to open a separate account for the credit facility extended through the scheme. So it has to go to an independent account, which will be accessible, Millards, by Millards, the corporate debtor, by the company, in this case, the petitioner before your ladyships, and would be utilized, Millards, for the purposes. Here, as I indicated, Millards, we have already written letters, Millards, to respondents. Please just note the dates. I am not, Millards, for your, at the moment, drawing your ladyship's kind attention. 4th June 2024 is a letter written, Millards, by us to all the lenders, highlighting the illegality in the disbursement of, Millards, the ECLGS scheme. And, Millards, as I indicated, Millards, a separate representation, Millards, was issued, Millards, to respondent number 2, Millards, in the writ application before your ladyship. So therefore, Millards, coming back, Millards, to the reliefs which I was placing, these are the other two aspects of the matter, Millards. I haven't gone into the documents or the law because I believe, Millards, these can be, Millards, aspects which can be considered during, Millards, a joint review meeting. If not, of course, Millards, I'll elaborate further on the legal aspects. Now, Millards, therefore, turning your ladyship's attention back, Millards, to the prayer clause at ink page 70, Millards. Prayer B. Prayer B, Millards, is in relation to ink page 70, 70, Millards, of the writ application. Prayer A, I have already placed before your ladyships. Prayer B is issue a writ in the nature of certiorari or any other appropriate writ, declaring that the classification of debt by of the petitioner by R4, acting for respondents 4 to 7, which is the consortium members, is illegal and honest on the ground that the accounts of the petitioner were regularized on 8th February 2024 and minimum 90 days period as per the IRAC norms, which I indicated to your ladyship, dated 2nd April 2024, which is also filed on record, was not expired, and consequently declare illegal, quash and set aside the impugned demand notice dated 2nd May, because the demand notice itself is, Millards, issued before the 90-day period, Millards, expire.
Yes.
Declaring the accounts of the petitioner as non-performing asset then my lords, alternative prayers are sought. So, my lords, at the end of the day, my lords, a action for recovery has to be preceded mandatorily. That's one aspect is, my lords, this 90-day period. The second aspect is the ECLGS scheme, the benefit of which was not given to the petitioners. I'm not going into the details or the legalities for the time being. All I'm indicating is that, my lords, in terms of the RBI circular, which the RBI has explained, my lords, any action for recovery, and that's the primary point, had to be preceded by a joint lender review of the account within a specified time period. That never took place. Therefore, my lords, your ladyship is aware, my lords, if the foundation itself is weak, my lords, that the entire building must collapse. There is no foundation to the recovery action undertaken, my lords, by respondents 3 to 7. Since it is not in compliance with the norms. And, my lords, surprisingly, my lords, respondent, my lords, 3, RBI's affidavit your ladyship has seen. I have indicated to your ladyship, my lords, the affidavit of, my lords, respondent number 4. Respondent number 3, Deutsche Bank, has not filed an affidavit. Of the others?
Yes, yes.
And only SBI has filed an affidavit. That's, my lords, the situation where we are today.
Of course, RBI.
And, my lords, parallelly, there is, my lords, enforcement proceedings going on in relation, my lords, to the assets, my lords, which have been offered as collateral, my lords, by, my lords, the borrower, as well as, my lords, by the security providers. That's where we are at today. Therefore, my respectful submission is, my lords, those actions must fall in my respectful submission.
Yes.
And, my lords, we are entitled to, my lords, relief in terms of prayer rape immediately. That's, my lords, my respectful submission.
Yes, Mr. Singh. Where is the RBI counsel? You're representing RBI?
No, ma'am, I appear for my learned. Come.
I appear for the RBI this month. We have filed the affidavit of
No,
the
you have filed the affidavit, you have to submit also. In support of that.
My lords, if I may actually seek instructions, my senior would appear in this matter.
Ask him to come. Yes, Mr. Singh. Yes. Who are the respondents?
Yes, ma'am. I'm for respondent number 4.
Respondent number?
SBI.
I am for respondent 7. Possibly he is the lead of the consortium.
Lead consortium, my lords, I'll submit.
Yes.
Now, my lords, as the learned senior pointed out, my lords, essentially his argument was divided into 3 limbs. First one was possibly the meat of the argument, wherein the allegation is that the SBI-led consortium,
All the lenders.
all the lenders. I don't answer for Deutsche Bank, my lords. I'm not sure whether the Deutsche Bank, I think, is represented, but I'll answer for SBI and the consortium, has not complied with this prudential framework guidelines. And therefore, since the foundation itself falls, the entire edifice falls with it. Now, I'll take my lords through the objections filed by the Reserve Bank of India. Point out that the reading by the learned senior for the petitioners is selective and rather self-serving. In fact, the RBI has never said what the learned senior was trying to advance before your lordship. That's point number 1. Point number 2, my lords, assuming there is a flagrant violation, assuming, my lords, let's assume without admitting that, yes, the lenders have not complied with those guidelines. Those guidelines, my lords, are issued by the regulator, that is the RBI, to the banks. If there is any violation, the RBI can take action against the banks, whether it's a commercial bank, scheduled bank, or otherwise. But, my lords, to take it as far as saying that that forms the foundation for my initiation for SARFAESI proceedings would, in my respectful submission, be taking it too far. Otherwise, my lords, for a regulatory default, assuming, my lords, that there is a regulatory default by the bank, to whose can the petitioner, my lords, take advantage of it, or in other words, does it inure to the benefit of the
Statutory
petitioner?
force.
Now that, my lords, in my respectful submission, would be taking it too far. If the regulator, my lords, if there are several regulations, SEBI has issued several regulations, RBI has issued several regulations. Now, my lords, let us say I have violated one of those regulations. That is a matter between the regulator and me. The consequence would be essentially, in paraphrasing what the petitioners advanced is, my statutory rights under the SARFAESI Act are constrained by my having complied with certain regulatory requirements. Now that, my lords, cannot, in my respectful submission, be a correct interpretation. My statutory rights under SARFAESI, no one disputes that this is a secured asset. No one disputes that my actions under the SARFAESI Act are protected by the statutory provision of the SARFAESI Act. These regulations do not predicate that any action under the SARFAESI Act must be preceded by this. It doesn't say that. If that was the case, my lords, then possibly I'll have to answer to that.
No. In every case, you say that the banks are bound by the circulars issued by the Reserve Bank of India from time to time. No, even in cases of declaring a particular, if a person is holding two accounts,
Correct.
one account is
I'll come to that.
So in that case, the banks cannot take two different stands.
Correct. It's not a question of, I'll just paraphrase what I'm trying to say, my lords. I'll come to that. In fact, my lords, possibly if your lordships sees the RBI, there's a statement of objections, then an affidavit.
No, let's not look at the RBI objections at all. We'll only look at the
very well. If my lords could kindly come to the guidelines themselves, which are in the petition at page 128.
Yes.
That's, my lords, has that June 7th of 2019. Now kindly see, my lords, the introduction.
Because these are the particular framework for resolution of stressed assets.
Correct. Stressed assets, correct. Your lordship rightly pointed. Stressed assets.
Don't have any other mechanism, and either under the Act or the rules with regard to this.
So what the RBI, I'll point it out, what the RBI, why these regulations were issued by the RBI, simply this. That if I'm also to see instead of my trying to explain, the RBI itself speaks through its regulations.
Yes.
In exercise of the powers confirmed the Banking Regulation Act, so and so, and the RBI Act, being satisfied that it necessary expedient hereby issues the following directions. The direction shall be called so and so. The provision of the direction shall apply to, undoubtedly, I'm in one of 3 A, B, C, or D. Kindly see the purpose, my lords. The purpose is these directions are issued with a view to providing a framework for early recognition, reporting, and time-bound resolution of, kindly mark this, my lords, stressed assets. So therefore, my lords, if there is any asset which is not yet reached or crossed the threshold of turning into a non-performing asset, these regulations are for early recognition, reporting, and time-bound resolution of those stressed assets. That was the purpose. Now these directions are issued so and so. Now kindly come to us. The crux of really what the petitioner was trying to submit is from paragraph 9. Now what paragraph 9 essentially says is this: all lenders. Now, my lords, I will respectfully submit that this is the word all lenders must be all lenders. Yes. If there are 5 lenders, all lenders must put in place a board approved, kindly see, policies. Therefore, it's not as if all lenders must come together and have one policy. All lenders, so the plural must be read with the plural. So essentially what the petitioner is saying is all lenders must come together and have one policy. But the wording itself is to the contrary, which is I must also point out the RBI's. I can't speak for the RBI. But these regulations, my lords, the language used, all lenders must put in place board-approved policies for resolution of stressed assets, including the timelines for resolution, since default with any lender is a lagging indicator of financial stress faced by the borrower. It is expected that the lenders initiate the process of implementing a resolution plan even before a default. It is expected. In any case, once a borrower is reported to be in default, that is when it has crossed that threshold, by any of the lenders mentioned at 3A, 3B, or 3C, lenders shall undertake a prima facie review of the borrower account within 30 days from such default. During this review period of 30 days, lenders may decide on the resolution strategy, including the nature of the resolution plan, the approach for the implementation of the resolution plan, etc. And this also is important. The lenders may also choose to initiate legal proceedings for insolvency or recovery. I'll pause here, then I'll come to paragraph 10.
Paragraph?
I'll come to paragraph 10. I'll just explain what paragraph 9 essentially states. Paragraph 9 essentially states is, if there's one lender, of course, there's no question of coming together or any meeting of minds. There may be 2 lenders, there may be 5 lenders, or as in this case, there may be one lender who stands apart and 4 or 5 banks who come together to form a consortium. What this essentially says is, all of you lenders, please have a plan in place. If there is any default that is going to happen, if there is any stressed asset, please come up with a plan as to how you're going to resolve it. That resolution may also include taking action under SARFAESI, IBC, and so on. That is what paragraph 9 says. Now, what paragraph 10 says, once that...
No, you were submitting as per paragraph number 9. all of you need not come together. You can do it independently.
That is what the mandate is. Each of us should have separate plans. Now, assuming, well, we are not a consortium. Kotak Mahindra Bank, Canara Bank, all of us were not a part of the consortium. This regulation mandates that each one of us should have a resolution plan, which is why, and it's board approved. Each of the boards of the respective banks must approve what resolution. Let us say Kotak Mahindra Bank separately, my lords, maintained a separate account with the petitioner, or the petitioner maintained a separate account with Kotak Mahindra. It is mandatory for Kotak Mahindra to have a board approved policy as per this, to have what is the resolution plan. But since we are part of the consortium, at least as far as the consortium is concerned, we met and we had a plan. Now, to say that even before any of this is triggered, that Deutsche Bank should sit with the consortium and have a joint meeting and say, this is how we are going to approach this, would be doing violence to the language. Second part, I agree with the petitioner. Now, let us say that threshold is crossed and there is a resolution plan that has been put forward. Then what paragraph 10 says is, in cases where RP is to be implemented, now, so implementation comes after the plan is drawn up, all lenders shall enter into an inter-creditor agreement, which is where, my lords, if we have reached that stage, then, my lords, there is Deutsche Bank and the consortium. Then Deutsche Bank and the consortium must enter into an inter-creditor agreement during the above said review period to provide for ground. There is, again, kindly maximum, during the above said review period to provide for ground rules for finalization and implementation of the resolution plan in respect of borrowers with credit facilities from more than one lender. That is where, my lords, this meeting of minds is required. Only at the time of entering into this inter-creditor agreement, the ICA shall provide that any decision agreed by the lenders representing 75%. Of course, we haven't reached that stage yet. There's also, my lords, a possible, I'm not advancing this, my lords, but your lordships may consider this. If my lords were to see paragraph 11 and 12, I'll just point out why I'm reading this out. Now, the applicability of these regulations itself is a question mark. Possibly the RBI can throw more light on it. Paragraph 11 says, in respect of accounts with aggregate exposure above a threshold with the lenders as indicated above, as indicated below, on or after the reference date, resolution plan shall be implemented within 80 days from the end of the review period. The review period shall commence not later than the reference date. Now, my lords, reference date is given in paragraph 12, the table. Now, this is what the bank's instructions are, my lords, but I'll put it for your lordship's consideration, even though our objections don't specifically state so. Kindly see, my lords, the table has three rows. First is 20 billion rupees and above, which doesn't fall under that. 15 billion, which is 1,500 crores and above, this doesn't fall under that. Less than 15 billion, I'm told, my lords, the RBI hasn't even announced when this RP is to be implemented. So therefore, even assuming I go through the entire process, RBI hasn't told a bank or any of the banks with regard to exposure less than 1,500 crores. Here, Malas, there's about 80 odd crores.
Amount is above 15 billion.
No, it's less than 15 billion. It's less than 1,500 crores. So, Malas, it says to be announced in due course. And I'm also told, Malas, and in fact, the RBI itself has come on record saying these guidelines have now been withdrawn. There's new 2025 guidelines. So I'm on instruction I'm submitting, Malas, till these guidelines are withdrawn. There is not even a date that has been announced. So even assuming all of us come together and so there is no reference date at all which has been announced for accounts which are below a certain threshold. And admittedly, Malas, this is less than 1,500 crores. It's not more than 1,500 crores. So that also is the question, Malas, the futility of the entire exercise. Now, if I'm supposed to implement it, there's no reference date at all. So that's just another aspect. Now, could I request my lords to kindly see the statement of objections filed by the RBI. There is an affidavit, that 2-page affidavit, my lords, not that. There is another statement of objections that was filed.
Earlier.
Yes, my lords, that would have been filed. Again, the copy I have is only the objections without the annexures. Yes. It's undated. If my lords can...
yes.
It starts with, I think there are about annexures A to H, if my lords has that. Mine is undated, so I'm not able to point out the date.
Yes, annexures are there.
Yes. If my lords could kindly see, I won't trouble my lords reading the entirety of the objections. At page number 8, paragraph 15, the RBI, what I was submitting earlier, explains the objective of these regulations. Then, my lords, what I was submitting at paragraph 17, it's clarified that it is submitted, my lords, has that paragraph 17, it is submitted that the inter-creditor agreement is mandatory only in cases where lenders decide to implement a resolution plan. In all other cases, signing of ICA is not mandatory. My lords, has that? I'm so sorry.
You are referring to paragraph number?
17. My lords. I'm sorry if there's a mismatch. This was the copy that was electronically served. Paragraph 17. You have that?
17 reads like.
1 second.
This is the respondent number 4.
Respondent number 1, my lords.
This is respondent number 4. Page 9.
This is the respondent number 1's statement of objections. Like I said, my lords, I don't have a date. It has annexures A to H. That's all I can.
It is submitted that inter-creditor agreement.
Paragraph 17, my lords. Yes, absolutely. It is submitted that inter-creditor. This is what I was submitting, my lords. What that paragraph says is, it is submitted that inter-creditor agreement is mandatory only in cases where lenders decide to implement a resolution plan. In all other cases, signing of ICA is not mandatory. So therefore, there's no question of all lenders coming together to sign an inter-creditor agreement unless there is a decision to implement a resolution plan. Then, my lords, may kindly see paragraph 18, in fact, clarifies what I was submitting. The RBI said that these guidelines have since been withdrawn and has been considered, as this of course may not be applicable because all of this preceded these new guidelines. Now, my lords, this is important. Kindly see page number 11, paragraph 20, my lords. In fact, the unnumbered paragraph just below paragraph 20. My lords, has that in view of the above, the unnumbered paragraph. In view of the above, it is submitted that RBI has put in place appropriate framework and issued necessary directions or guidelines to the regulated entities on the subject matter involved in the writ petition. Banks are required to put in place board-approved policies within the contours decided by RBI and take commercial decisions with respect to matters concerning recovery of NPA and provision of OTS. It is further submitted that there are no regulatory prescriptions prohibiting, kindly mark this, prohibiting banks to engage in recovery without exploring restructuring. Then, of course, he says, therefore, the petitioner is entitled to any relief against RBI. That covers RBI's. So, therefore, specifically, the bank says there is no bar. In fact, which is what this clarifies what I was submitting earlier. That SARFAESI, my lords, gives the banks or any secured creditor for that matter an independent statutory right to proceed against a secured asset. That cannot, my lords, in my respectful submission, be curtailed by any requirement for a pre-resolution plan. My lords, resolution plan, there is IBC. Let us say, my lords, someone files an IBC a petition under the IBC, section 7 or section 9. Then, my lords, can the borrower then say, no, you should have first come up with a resolution plan yourself. Therefore, why have you come to the NCLT to now appoint an RP or so on? It can't be, because that's an independent statutory right, which is what the RBI has recognized, which is why I was submitting was RBI's affidavit, the manner in which it was read was rather self-serving. It doesn't, all it says is all lenders must have policies. There is no affidavit required for that. Paragraph 9 itself says all lenders must have board-approved policies.
This is a note affidavit that is filed.
I can just read one last paragraph before that, Manoj, just one last paragraph. Okay. Paragraph 24 also, Manoj. Then I'll come to that affidavit.
Yes.
Paragraph 24. Therefore, it is respectfully submitted that there has not been any inaction on the part of the RBI with respect to representation dated April 19, 2025, submitted by the petitioner. However, as the representation had alleged, certain non-compliance of RBI directions by the banks regarding misclassification of the borrower account as NPA before the due date, provisions for intercreditor agreement, issuance of notice under SARFAESI, etc. The representation was reviewed from a supervisory angle and no supervisory concerns were observed. So RBI, my lords, I said, we don't find any supervisory concerns. As the regulator, I have seen your representation. Your representation alleged that there was misclassification of the borrower account, provisions for ICA were not followed. We have examined it. We don't find any, which is why, my lords, now my lords may kindly see that affidavit. That affidavit doesn't, in my respectful submission, doesn't say anything more than what the regulations themselves state. Paragraph, I think 3 is what my learned friend read. I humbly submit that clause 9 of the said prudential framework of stressed assets would mean that once a borrower is reported to be in default by any of the lenders, all lenders shall undertake a prima facie review of the borrower account within 30 days from such default, that is review period. During this review period, lenders may decide on the resolution strategy, including the nature of the resolution plan, the approach for implementation of the RP, etc. I'll just pause here, Manas. This is nothing but really a paraphrasing of what para 9 itself says. Para 9 also says all lenders, but which is why I was reading, Manas, how that must be read in the context of paragraph 9. Then, Manas, paragraph 4. It is further submitted that in cases where RP is to be implemented, all lenders shall enter into an intercreditor agreement. Yes, Manas.
The same clause.
Same clause. So therefore, of course, now the moment there's an intercreditor agreement that is required, it goes without saying that, of course, I can't say there's an intercreditor agreement only within the consortium. I will keep Deutsche Bank out, or Deutsche Bank will decide or choose to stay out. Intercreditor agreement means intercreditor agreement. But each one should have a plan in place, then come together and say, okay, let's enter into intercreditor agreement if there is a decision to implement the resolution plan. Now, what has happened here, Manoj, is the consortium has taken a decision. In fact, they came up, as my learned friend read out, Manoj, the petitioner proposed a plan. The consortium met and said, see, this plan is not going to work out. It's financially not feasible.
Consortium rejected, but third respondent, the one of the lender, is not there in that.
They were not there in that. And my respectful submission is they were not required to be there even as per para 9 or as per this affidavit. It is only, Manoj, if we propose that, yes, let there be a resolution of this. And again, Manoj, I preface that with saying that even assuming that there is an infraction of those regulations, RBI, which is why, in fact, in the framework, in the guidelines itself, RBI has provisions to take action against me. But does it amount to, in other words, Manoj?
There must be a purpose behind it. That
certainly there's a purpose. But if taking the argument as far as what the petitioner has propounded, I would respectfully submit this, Manoj, that every case of SARFACI, any section 17 application filed, or whether a writ petition is filed before this honorable court, if this resolution plan is not in place, then the entire superstructure would fall as per what the petitioner is submitting. Because that could never be the intention of the RBI. Otherwise, Maharaj, it would tantamount to a regulation superseding a statutory right. And it goes without saying, Maharaj, there's no question of regulations curtailing a statutory right.
No, for example, there are about 7 banks.
Yes.
In the meeting that is held, as for the resolution plan is concerned, 3 of them want to go ahead with the resolution plan, and the remaining do not want.
Right.
And what would be the scenario?
I'm sorry, Maharaj.
Out of 8,
yes,
4 want it and 4 do not want to go ahead with the resolution plan. Then what is the?
Which is why I think there's some requirement of 75% or so on, which is why I think 75% have to agree. Then they have to go ahead. Then it's. I think the majority, rather than not just majority, but 75% have to vote in favor of that. Only then it has to go ahead. So there is a.
In that case, the presence of all the parties is all the banks necessary, all the lending banks.
No, it wouldn't be.
Huh?
That's
my lords, I appear for RBI in this matter, my lords.
1 minute. Huh?
I'll point. Let my learned friend complete.
Yes.
So, which is why submitting was essentially on the first, as far as prayer A is concerned, 2 limbs. One is, my lords, the RBI guidelines do not, in my respectful submission, require that the moment there is any, it uses the word stressed assets, not a non-performing asset. The moment there is any stress in any asset, how many, as your lordship pointed out, 8 lenders have to immediately come and sit together and then come up with a resolution plan, which is a mandatory pre-requirement for any of the lenders to then proceed under their statutory rights under the SARFACI. That, my lord, that interpretation.
Let's please come back to this
affidavit.
The federal.
My lord, if I may clarify, I appear for RBI in this matter.
No, 1 minute. We'll come to
you.
My lord is seeing the.
Come to the circular.
Circular, yes.
B speaks about implementation of resolution plan. According to you,
I'm so sorry, madam. My lord is seeing which page? I'm so sorry.
No, this the RBI circular.
Correct, madam. Correct.
Starts at page 120.
Yes, madam. My lord is seeing paragraph
9.
Paragraph 9. Yes, madam.
It starts with implementation of resolution
plan.
Correct,
correct. So all lenders must put in place board approved policies for resolution of stressed assets, including the timelines for resolution. Since default with any lender
The
is
Reserve Bank is not referring to an independent, each lender.
Yes,
It must be
correct,
the
absolutely.
group of
All
lenders.
it can't be. There are various cases. In this case, there happens to be a consortium, which is why I was submitting. Let us assume there was no consortium. Canara Bank was separate, SBI was separate, Kotak Mahindra was separate. What this requires is each of the banks, being independent lenders in their own right, must have board-approved policies for resolution of any stressed assets, including timelines for resolution. That's what it requires. In this case, there happens to be a consortium.
So why would this word all lenders
Correct,
will
Manoj.
be used?
It is,
If it is, need not be all lenders, lenders.
yes, Manoj,
All lender banks.
very well, Manoj. In my respectful submission, all lenders it essentially means that any lender, all lenders must have in place. It doesn't mean all lenders together sitting in one room must have a plan. All lenders means if there are two lenders, all lenders, two of you have plans. If there are five. All lenders does not mean that all of us sit together and essentially, let us assume, my lords, there is only one lender. What these guidelines say is all lenders, which means that even if there is one lender, that lender, if there's another borrower, that lender, all lenders must
Facts
have.
and circumstances of this case,
Correct.
there are several lenders.
There are several. There are essentially two, because there's a consortium that is a part of one. That is, it can be counted as one lender.
To implement a resolution plan.
Correct. That
coming
is
together of all these people is necessary.
to implement the resolution plan, Manoj. And again, Manoj, let us assume, Manoj, that yes, what the petitioner is advancing is
Because
correct.
as you're saying, to implement a resolution plan, that's 75% of.
Correct.
So there also, it has, that significance of meeting together is also important.
I'll just, my learned fellow pointed out, I think he's more prepared to answer that question, Manoj. But then, within any event, now assuming, my lords, your lordship does form the opinion that the petitioner is correct, there is an infraction of paragraph 9. Now, that I would respectfully submit would, if the argument advanced by the petitioner is taken, then that would cause complete violence to the scheme of the SARFAESI Act as well. Your lordship knows very well there is no question of any delegated legislation curtailing or whittling the powers that are conferred by a statute. The statute confers every secured creditor a right to proceed against secured assets subject to the provisions of the SARFAESI Act and the rules. Now, Manoj, in fact, paragraph 9 also clarifies that the plan can include proceeding against the assets. These are separate secured assets insofar as Deutsche Bank and the consortium is concerned. We have decided, Manoj, that yes, I don't think there's any question of resolving this. In other words, Manoj, what exactly the petitioner propounded? In a nutshell, it is another form of an OTS saying that please allow me to restructure, please allow me to pay this much amount, please allow me to pay the remaining amount in a staggered manner subsequently. In other words, that's what the resolution plan was propounded. The lenders, Manoj, in their financial wisdom said this is not going to work out. Otherwise, Manoj, every OTS plan also will fall within the scope of this. It's possible. It's possible that that argument can be advanced. So therefore, Manoj, even assuming that there is an infraction, but SARFAESI would, that right cannot be whittled down, or it cannot be said that that right is predicated by compliance with these regulations. These regulations, if violated, which the RBI says we have not violated, will result in, assuming there is a violation, will result in regulatory action against me. I'm answerable to RBI. It is my regulator. But can the petitioner, Manoj, take advantage of that? I would respectfully submit no. If there is any violation, then I have to answer to, there will be possibly a penal provision that I have to face at a subsequent stage. But these regulations, which I was submitting, the object was not to benefit a petitioner. The objective, which is why I read out the objective right at the outset, page 129. Object was to provide a framework for early recognition of stressed assets. That is for the benefit of the lenders. The lender should not end up in a situation where we are sleeping. Finally, one fine day, we find that there has been large-scale defaults, and now we don't know how to resolve this at all. Which is why, for the benefit of the lenders, the RBI tells us, please have a plan in place. If we don't do it,
the second prayer.
Means insofar that second prayer is concerned, my lords, we have, if my lords would kindly see our objections, there is, I can't deny the fact that there is a letter that was issued on 8th of February 2024.
Within 90 days.
Yes, but
It
kindly
is
see,
NP.
it's a mistake, Manoj. It is I think in fact, on the instructions I'm submitting, in fact, we've clarified that at paragraph number 9 of our objections, the SBI's objections. In fact, my lords, it was, I think, one of the payments, I'm told, was made on a particular date, but there were other payments. Why that was said, I'm not in a position to defend the bank's actions. But I kindly see, which is why on affidavit we've clarified at paragraph 9. I can't improve upon what we've said in our affidavit. But even otherwise, before I read paragraph 9, these are possibly issues that the lordships in various other cases have also left it open to approach the DRT. They could always approach the DRT. If it's a factual question as to when the default actually occurred, that letter itself, my lords, would not, in my respectful submission, cleanse the entire account itself. It would still require a factual determination as to whether there was a default. Paragraph 9, if my lords has, it is submitted that. The SBI's objections, not the petition. I think our copy was there.
Yes, it is submitted.
It is submitted that so far as the account of the petitioner is concerned, as on 27/11/2023, an amount of rupees 1.13 crores was irregular in cash credit, GECL and FITL accounts. The petitioner has not regularized the accounts despite regular reminders. Hence, all the accounts slipped into NPA on 29/11/23. Thereafter, on 17/1/24, upon repayment of overdue amount.
So according to you, on 17/1/2024, it is regularized.
Correct. No, I just pointed out, was declassified and regularized. As such, respondent number 4 had issued letter on 8/2/24 to the petitioner, keeping in view that the account has been regularized on 17/1/24. However, I think that letter for some reason does not clarify. There was an installment due after 17, that is on 31/1. The account was classified as NPA on 34. So as on 17/1, it came to be regularized. There was another installment due at the end of that month. That once again, there was a default. That 8th of February letter, yes, I can't improve upon that. It should have.
Even if there is there was an installment due on 31/1/2024.
3 months from there, correct. Then it'll be exactly 3 months. 30th April with 90 days. So that if it's 31/1 that the default occurred, which as we've stated on affidavit had occurred and they have not refuted it by way of a rejoinder, then 90 days would be 30th April. So which is why 30th April it came to be classified as an NPA.
Yes. Yes.
And as far as point number 3 is concerned, I think that again, those are issues that could be best left to the DRT.
Yes.
I'm grateful.
May I just point out a few more aspects? I appear for Kotak Mahindra Bank, which is a part of the consortium. It's, first of all, good to see my learned friend, Mr. Datta. May I draw the court's attention to page 128, and I'll take a little more time and try and elaborate on what my learned friend, Mr. Vilgol, has pointed out already to the court. I'll address this, and then I'll probably go to what the petitioner submissions are, or a few other aspects which my learned friend has not covered.
Yes.
Please be kind enough to take page 128 annexure H. This is the prudential framework for resolution of stressed assets. May I just start with the introduction? In exercise of powers conferred under the Banking Regulation Act and the Reserve Bank of India Act, the Reserve Bank, being satisfied that it's necessary and expedient in public interest to do so, issues the directions hereinafter specified. They are called as prudential framework, etc. Applicability, it applies to us. No quarrel about this. Please come to purpose at para 4. These directions are issued with a view to providing a framework for early recognition, reporting, and time-bound resolution of stressed assets. 5. These directions are issued, please mark this, without prejudice to issuance of specific directions from time to time by the Reserve Bank to banks in terms of the provisions under Section 35AA of the Banking Regulation Act for initiation of insolvency proceedings against specific borrowers under the Insolvency Bankruptcy Code. I pause for a minute. RBI essentially is a regulator. It is not a micromanager. It will, though there are instances where with a given borrower, if the amount is way too high or whatever, which is why my learned friend pointed out that 15 billion rupees and above those aspects, when the Insolvency Code first came out, they were at first around Super 12 and then another about 30 companies which are identified. and the banks were encouraged to file insolvency proceedings against them because they felt that otherwise it will just become very, very difficult. And ultimately, if some other person, some other corporate is able to pump in money and take over that company, it will benefit everybody. That was the logic. So my respectful submission in the first instance is that this is really meant as a tool or a guideline for banks to operate. It does not really confer any significant right to a borrower, other than the fact that if there is any deviation from this, that the RBI notices, of course, it's up to the RBI to point out that we have made any mistake. But fortunately, in this case, the RBI has given the banks a clean chit. It has done so in its statement of objections, which my learned friend pointed out and adverted to. I also wanted to refer to the very same paragraphs. They have said that they are acting as a regulator, they are in supervisory jurisdiction, and they've seen the papers and they find that there is nothing wrong. This, I think, is a complete answer to whatever my learned friend points out as far as prayers B, C are also concerned. Be that as it may, because ultimately there is today an acceptance amongst everybody that the RBI is today the regulator. RBI has taken this position on facts as a regulator and has said that what we've done is not correct. This is not incorrect, and that is one aspect of the matter. Please permit me to read a little further. May I draw the court's attention to para 9? I know it's been read out 2-3 times, but please permit me to read it once more, possibly more for my satisfaction than for throwing any further light. Please mark this. Actually, before that, I will just point out one other small aspect. Para 6 and 7 indicate the nature of classification, etc., but that may not be immediately relevant, other than to show that there is a time-bound mechanism within which, if there is any default, any crisis, for example, suddenly there is a bank where entire board resigns on account of some audit classification or an audit, the auditors have raised some red flags and therefore the entire board is, I'm just giving a hypothetical example. Even in such a situation, we may have to get alerted as banks. RBI is telling us, banks, look, don't sit and twiddle your thumbs. Please take action. Don't sit idle. That's essentially the tenor of these guidelines. Now, may I draw the court's attention to para 9? All lenders must put in place board-approved policies for resolution of stressed assets, including timelines for resolution. I pause for a minute. The board-approved policy that is mentioned here is the board of directors of each company, of each bank. One must not forget that each bank is itself a company under the Companies Act. It's a banking company, and therefore it is operated, regulated or whatever, overseen by its own board. So each lender, that is me, him, every other lender, has to have its own policy, which is board approved. Since default, I pause for one further minute. I'm sorry, I should have pointed this out. Obviously, and it goes really without saying, the board of SBI operates independently from the board of Kotak or Canara Bank or Deutsche Bank or any other bank, and we will not operate with reference to one another. In other words, my policy may be at some variance with his policy. That is theoretically possible. Though I must also point out that most banks have a sort of standard formula, so it's not likely to be extraordinarily at variance. May I just read further? Since default with any lender, any one of us, is a lagging indicator of financial stress faced by the borrower, it is expected that the lenders initiate the process of implementing a resolution plan even before a default. In any case, once a borrower is reported to be in default, please mark this, by any of the lenders mentioned at 3ABC, lenders shall undertake a prima facie review of the borrower's account within 30 days from such default. This is the review period. I pause for a minute. This review is undertaken by each bank separately, and I'll tell the court why. Often what happens is that in the given case, there is a consortium, but as my learned friend rightly pointed out, it could be a scenario where some banks are operating alone and some banks are operating in consortium, or all banks are in consortium. Various combinations are possible. In any event, payments have to come to each bank because the loan facility is from each bank, though the security, the reason for consortium typically is also that the security is consolidated in one place and one person takes an action. Therefore, the review has to be at my instance. For example, it could be a situation that though payments are being made, Kotak has got a little less money than SBI or vice versa. That can theoretically happen. That is why this indication that each bank has to undertake that review upon any bank finding out. During this review period of 30 days, lenders may decide on the resolution strategy, including the nature of the resolution plan, the approach for implementation of the resolution plan, etc. The lenders may also, please mark this, choose to initiate legal proceedings for insolvency or recovery. We may choose to either implement an RP or we may choose to recover. We can do one of two things. Now, here my respectful submission is, I will just suppose with the case of the petitioner. What is the case of the petitioner? The petitioners would have this court believe that they have a right in law to say that they have asserted that they want to implement an OTS or to offer an OTS, and that we have a mandate in law to accept it. I respectfully submit this is fundamentally wrong. What is it that they have a right to do? They have a right to say that I want to offer an OTS if such OTS scheme is available. There is no right in law to offer an OTS when no scheme is made available by a bank. Suppose as a policy, SBI, I'm just taking SBI as an example or Kotak as an example, choose and say that they don't want to do OTS at all. Then there is no obligation on me to even accept that OTS. But if the RBI says, look, because of COVID, please consider if OTS offers are made for the next 2 years, then we all are bound to consider it. Are we bound to accept it? The answer to that is no. So therefore, really the mandamus that is sought at best is a very limited mandamus. This is the second submission I wanted to make. Now, please therefore permit me to draw the court's attention back to this part of para 9. Therefore, I can do one of two things in the 30-day period. I can either look at the RP or I can look at recovery proceedings or insolvency. These are the 2 or 3 broad options that I have. Para 10 comes in the case where a resolution plan is to be implemented. In case where the resolution plan is not to be implemented, in other words, if I choose to proceed with SARFAESI proceedings, as is indicated in para 9, para 10 just falls away. It does not come into force at all. If the banks or bank decides to go in for a resolution plan, then if you are a consortium, then an intercreditor agreement is necessary for the reason that we should not be acting at cross purposes with one another. And may I just read para 10 to just point out how this works. In case where RP is to be implemented, that is the predicate of para 10, all lenders shall enter into an intercreditor agreement during the above said review period to provide for ground rules for finalization and implementation of the RP in respect of borrowers' credit facilities by 60% of the lenders, the numbers binding on the lenders. Additionally, the ICA may inter alia provide for the rights and duties of the majority lenders, duties, protection and rights of dissenting lenders, treatment of lenders with priority in cash flow, differential security interest, etc. In particular, RP shall provide payment not less than liquidation value for dissenting lenders.
In this clause number 10.
Yes.
Again, the word used is all lenders.
Absolutely right.
Into an intercreditor agreement.
Absolutely right. But it is only when the RP is being implemented. And this is right.
So all lenders that is used in clause 9.
That's right.
Is referring to any one lender or all
no,
lenders?
No, I, with utmost respect, I'll point out.
To 10.
Yes.
Again, it is all lenders.
That is absolutely correct. I will just break down para 9 in this fashion. Please permit me. The court is absolutely right in saying both para 9 and para 10 use the word all lenders. But the context in which they are used are completely different, and I'll point that out. In para 9, it starts with the word all lenders or words all lenders must put in place board approved policies. That means each bank, whether I've lent 1 crore or 100 crores, I have to have my policy in place, which my board of directors have approved. Without that, I can't take advantage, or anyway, it's a norm, so I have to follow it. This is the first aspect. What is the obligation in each and every bank? The obligation is that each one of us has our own policies in place. Do each one of us have it? The answer to that is yes. Do I need to know what Deutsche Bank's policy is? The answer to that is no. Now, please see the next part of para 9. In case, that's around the 5th line from the top. In any case, once a borrower is reported to be in default, the lender shall undertake prima facie review of the account. During the review period, lenders may decide on the resolution strategy, etc. Here, the word all lenders is not used. So each lender can do it. Of course, if you're in a consortium, you're likely to do it together. Here, the one important aspect is that there are 3 or 4 banks in the consortium and 1 bank that's standing outside the consortium. Is there anything wrong in that in and of itself? Absolutely nothing. Therefore, as a group, the consortium did this exercise. As an individual, that bank must have done its exercise. I am not speaking for Deutsche Bank, and therefore I will not make any remark about what they've done or not done. And if they haven't done it, it's up to the petitioner to point out, but they have not pointed that out. Therefore, the question is, I ask myself, do all the lenders here have a board approved policy? The answer to that is yes. Were all the lenders obligated to meet together and decide on what to do next? The answer to that is no. The reason that the four banks in the consortium met is that they were a consortium already. Once we met, we agreed, after having undertaken the prima facie review of the account, that the way forward is to undertake SARFACI proceedings. That is what our decision was. At that point in time, and in fact, if I'm not mistaken, in the sequence of facts and events, the OTS offer comes after we've initiated SARFACI. It doesn't matter. So therefore, the decision to approach, or rather to choose to initiate proceedings for recovery has already been made by me. They come up with an OTS offer, has no meaning in law, has no obligation on me in law. Nonetheless, the four of us considered it in a consortium meeting and we said not good enough. And here is the important point. The dues at that point, and whenever this was considered over a year and something ago, was about 75 crores. They offered around 30 crores. We said absolutely not acceptable and we rejected it. Is there anything wrong in our having rejected it? Absolutely nothing. RBI did not find anything wrong in our rejecting it. They said so in their objections. Now, was there at all a resolution plan that was to be implemented? The answer to that I respectfully submit was no. If the answer to that is no, para 10 does not apply at all is my submission. In any event, to answer the court's question, if the banks were to move ahead with a resolution plan implementation, the court is absolutely right in its observation in saying that all of us should have met together. At that point, I could not have kept Deutsche Bank out and said, look, sorry, you figure it out yourself. We are part of a consortium. We have the cricket bat. We will not let you pay. We can't do that. At that point, all of us have to play the game together. Not earlier than that. But that occasion never arose is my respectful submission. This is to answer their entitlement in law, which I respectfully submit they have none. Then, my learned friend already referred to paras 11 and 12, therefore I won't point that out again. May I just quickly respond to 2-3 other points that my learned friend made? I ask an important question to myself. All right, your whole case is predicated on the fact that for whatever reason, when we took the decision not to go ahead with a resolution plan, but instead go ahead with recovery under SARFACI in terms of section paragraph 9, Deutsche Bank was not in the room with us. This is their case. How does it prejudice them, I ask myself. After all, whether you pay individually to the consortium, individually to Deutsche Bank and collectively to the consortium, or collectively to all of us, each one of us has to be paid. It is not as if in that meeting, you're going to say, all right, Deutsche Bank, now that you're in, I will pay you zero. It is not that, it's not going to happen. Ultimately, each one of us has to be paid. And we are the majority. The consortium stood in the majority. The consortium rejected it. Deutsche Bank's loan contribution is a very nominal amount compared to the larger exposure. If that is so, in any event, if they don't meet that 60% threshold, what prejudice were they caused? I ask myself. No prejudice would have been caused. So even assuming we are, for the sake of compulsion, to go through with this without prejudice to my submission that it was completely unnecessary and there is no obligation, there is no useful purpose served because the majority in its wisdom, and my learned friend Mr. Datta knows this better than all of us, even in the insolvency code, the creditors committees or the commercial wisdom of that creditors committee is normally never questioned, including all the way till the Supreme Court. When that is so, I ask myself, the majority of us, no, in fact, all of us in this consortium who formed the majority of the borrowers said, no, we don't want to go ahead with this OTS proposal. With that, in my respectful submission, that's the end of the matter. Now, whether we did it with Deutsche Bank in the meeting, whether they were served coffee or tea is of no consequence to the borrower is my respectful submission. Because it doesn't move the needle, it doesn't change the situation. And even if they were in the meeting, it would not have made a difference is my submission. Then,
no, at the time of clause number 9,
yes,
all of you have met.
No, my respectful submission is there is no mandate to meet.
No, then how will you go? How you will take an independent
yes,
decision?
Each one of us can individually look at it.
Whether to go with a resolution plan or not.
That is right, because that is the whether or not I go with a resolution plan is predicated on my individual policy, which is approved by my board, not by his board, not by anybody else's board.
Not in a consortium, and independently, 4 of you think that you will go with a resolution.
I have one minor modification to what is falling from the court. Normally, yes, that what is falling from the court is correct. But in our specific case, because we were a consortium, the 4 of us met. And we said no.
No, let us assume 4 of you are in consortium and the other Deutsche Bank is in consortium with another 4.
Possible.
And you only met and you only, as far as you thought you will go with the resolution plan, they thought it is not, they do not want to go. Then what should happen?
The answer is very simply this. Then we go by what the rules say, what the norms say, which is that 60% of the lenders have.
For that reason, consensus is required.
It is unnecessary. I respectfully submit for 2 reasons. One, that is at a later point.
Norms say about this percentage and all.
I will point it out. I'll point it out. It is very much there. I'll just point that out. Please be kind enough to turn to paragraph 10 may please be seen. I'll just point out when 10 applies. 10 applies only when the RP is to be implemented. So therefore it reads like this. In cases where RP is to be implemented, in other words, there could be cases where RP is not to be implemented, such as ours. All lenders shall enter into an integrated meeting. So at that point, I can't keep Deutsche Bank out. But we were not implementing it. Then please see further. During the above said review period, to provide ground rules for finalization and implementation of the RP, and 60% of the lenders by number shall be binding on all lenders. So 60% of us had to have said yes. We are 5. 4 of us have said no. In any event, even assuming 10 would have applied, which it does not, it never stood an occasion to arise. Even if it were to, 5 of us versus 1 have already said no. Now, therefore, whether Deutsche Bank says yes or says no is of today an academic question, is my respectful submission. Of course, it appears they've also said no. That's a different matter. It appears they also did not accept what was proposed by the petitioner, because they're suggesting virtually 50% or less, which is, I may also point out, there is this concept of liquidation value under the insolvency code, which the court is familiar with when matters from the NCLT come. Even that, possibly it was not meeting. And of course, in order to meet the liquidation value, one has to go through many steps. I'm not even getting into that aspect of it. Therefore, if 4 out of 5 have already said no, it's of no consequence, is my submission. That is what I meant by there's no prejudice. I may just very quickly point out 2-3 other aspects. So 60% is contemplated in that. Yes. Then I may just point out 2 more aspects which my learned friend pointed out. He says that virtually, he says, look, if you don't meet these norms, I'm entitled to come in a writ petition, and please see the prayers and the interim prayers. He asks for a stay of all recovery proceedings, including SARFACI. In other words, there is now a super legislation over and above the SARFACI Act that is sought to be implemented. And please see the consequence then. If there are 2 or more lenders, then the court will be flooded with writs. They'll just file a letter. They may owe 100 crores. They'll file a letter saying take 40 crores. I will say no. He'll say, but you did not meet him, you did not have a cup of coffee. And therefore, we have to stall your SARFACI proceedings. This will cause a complete breakdown of the SARFACI proceedings and the manner in which it is contemplated. And it would, I respectfully submit, be an invocation of 226, which is completely unfounded, is my respectful submission. Not for a minute saying that the jurisdiction is curtailed, but to point out that there is no right. Then the next aspect is that there is an aspect of the petitioner's conduct also, which I must point out. What they do is that when the petition was being heard, unfortunately, there was a change in the roster setting, if I'm not mistaken. And the matter was where we had pursued further with the 14, the consortium. SBI is the lead. So they have filed a section 14 application before the magistrate. They came here and told the court, look, the matter is coming up tomorrow, but the writ is to be heard after a few days because there's a change in roster. Can you please do? We, in good faith, my learned friend gave us made an oral submission that we will not proceed with the 14 for the time being. They take advantage of it and file an application saying, oh, they gave an oral undertaking. Now, in breach of that, they're proceeding with SARFACI. This court has rejected that application. That shows that their conduct is anything but bona fide, is my respectful submission, and therefore such a person can't be given a remedy in a writ petition. Then also I would submit that this submission that my learned friend Mr. Datta made to say that if there is a non-compliance, there is a right that inures to their benefit. I would respectfully submit that it doesn't for this reason. Here there is no non-compliance, and the RBI has said so. It is not that I am saying anything contrary. My learned friend read out at some detail the affidavit, the additional affidavit of the RBI, it is not that the RBI in that additional 2-page affidavit says, oh, I made a mistake in my statement of objections, I'm retracting that. There is in fact a violation on facts. They simply once again summarize the whole thing. Nothing has changed. The statements made by RBI on facts remain in the statement of objection, and therefore the petition deserves to be dismissed. Very good.
Anybody else?
Manoj, I appear for RBI.
Yes.
Manoj, if I may take my lords to the affidavit, the latest affidavit filed by me on the last date of hearing.
So what exactly does the RBI wants to say?
Yes, ma'am.
by
So
this
if I
affidavit?
read para number 2.
Oh, yeah, I have read.
submit that.
I have read. No,
Yeah.
I have read.
So, the last line of para number 2, hence, in the instant case, the term all lenders used in para 9 would refer to all the banks who have exposure to the borrower. This would include all the borrowers. This is my only submission.
So according to you, as per clause 9, all of them have to meet.
Yes.
Yes.
Your Ladyship, just to rebut 2-3 points that my learned seniors have pointed out. From the petitioner side, Your Ladyship, Mr. Datta is on his leg in some other court. I'll just try to fulfill those points.
Just
So
before
the
Mr.
Reserve Bank
Datta,
stand
I
is-
just want, yes.
No, Reserve Bank stand is, it should be all the lenders.
Can I put it without embarrassing anyone? That seems to be the Reserve Bank's advocate stand contrary to their own affidavit. If that is the stand, let them state on affidavit that they are taking regulatory action against the banks.
They have
That's not the.
Yes, Mr.
You please don't answer. You're not
One
answering.
minute. Yes, Mr. Man.
Yes, ma'am. Well, these are the instructions given by me, and I've filed my affidavit based on the instructions given to me.
The affidavit doesn't say that.
No. In that case,
No,
you
para-
find it. No. I have heard it. There is nothing much to be heard now. So what you will please file it. Your submission is that as per clause 9, all lenders means all of them have to meet according as per your instructions.
Your Ladyship, that's already answered. In fact,
Lord's
that's
will for the
just
petitioner. He
just
can't be
just
anything.
May I just take 2 minutes to point out paragraph 5 of the RBI's affidavit, sir, second affidavit. Please have that with me. This the entire argument of my learned senior friends, which I've been listening to patiently, my lords, is contrary to the regulator's affidavit. And I'm a little surprised, whereas 2 licensed regulated banks can take a stand contrary to the regulator's affidavit. Please have para 5 with me. Please see
Para
the
5.
language. Yes, in the light of the above. Ladyship has that?
You are referring to the latest affidavit filed by them?
Yes, that was a clarification where the bench sought the clarification, asked the RBI to file a better affidavit. This is the affidavit. I'm showing the second affidavit, para 5. And that answers every issue, my lords, which, my lords, my friends have been arguing.
So just to clarify, since my learned friend was not there, bench never asked.
May I just?
Insisting, and that's why they are RBI.
May I just? Very well, whatever it might be. The regulator has taken a stand on affidavit.
No, just now I've seen that. Yes.
Please see para 5. And answers every argument that has been made. In the light of the above. Ladyship has that?
Yes.
In the light of the above, the Reserve Bank of India. So what is above is, my lords, the language of the provisions. The interpretation of the RBI of its circular is paragraph 5. In the light of the above, the Reserve Bank of India, in the instant case, respectfully submits that the above framework envisages a coordinated and collective process. This was not read.
Yes.
What was explained was the earlier paragraphs of the affidavit only, my lords, use the language of the provision. This is the RBI's interpretation.
Yes.
Coordinated and collective process where all lenders to a borrower are required to come together. These are not empty words. This is regulator interpreting its own circular. Come together and undertake a review of the borrower's accounts within the review period to determine the appropriate resolution strategy. In case a resolution plan is to be implemented, signing of ICA is mandatory for all lenders. The ICA shall provide that any decision agreed by the lenders representing 75% by value and 60% of the lenders by number shall be binding upon all the lenders. Additionally, ICA may inter alia provide for rights, etc. So, Milords, the first three sentences. The first three sentences are the regulator's, Milords, interpretation. They say, Milords, a coordinated. Because what my friend has said, everyone sitting in their offices can take an independent decision, and then that independent decision will, Milords, represent a collective decision. That's the argument made. Because that is contrary to the plain language, Milords, of Milords, the circular, and Milords, the first three sentences, Milords, of RBI's affidavit, Milords, which explain how their Milords circular is expected to work. Please see the language. A coordinated and collective process whereby all lenders are required to come together. What is the meaning of this? That means they have to come together. All lenders, not just consortium lenders. They have to come together and undertake a review of the borrower's account. Independent review sitting in each other's offices, Milords, is completely impermissible. That's the language, Milords, of Milords, the scheme.
Yes, yes.
And therefore, Milords, I am saying.
I just wanted to, before, since my learned friend.
Two things. Two, Milords, these circulars, these guidelines have statutory force. Not, Milords, the Honorable Supreme Court had repeatedly, Milords, emphasized this fact. So Milords, there are two judgments, and I'll just hand over the copies to your ladyship. One is 2009, volume 8, SCC 257, Sardar Associates versus PNB, Punjab and Sindh Bank. Paragraph, Milords, 12 and 13 of that. The second judgment, and there are many, there are many, is, Milords, 2002, and I'll hand over the copies, Milords. 1 SCC 367, Central Bank of India versus Ravindra and others. Paragraph 55, subparagraph 5. Each of these judgments say, Milords, the second aspect, and just give me 2 minutes. My friend says an intercreditor agreement has to be, Milords, signed by all lenders. Of course, undoubtedly. But the decision, which has to be a collective decision as per the Reserve Bank of India, is to, Milords, either restructure and implement a plan or initiate recovery action. So therefore, the decision to, Milords, initiate recovery action equally has to be a collective decision of all the lenders. As, Milords, I am not saying this. I am reading the plain language.
Come to this judgment. Which
Yes.
you're relying on. This Sardar Associates.
Yes, Milords. Please have, Milords, with me, paragraph 12.
But C3 and 4 on facts test.
Yes.
Reserve Bank of India is a statutory authority. It exercises supervisory powers in the matter of functioning of the scheduled bank. The matters relating to supervision of scheduled banks is also governed by the Reserve Bank of India Act 1934. For the aforementioned purpose, the Reserve Bank of India is entitled to issue guidelines from time to time. Parliament also enacted the 1949 Act to consolidate and amend the laws relating to banking. That's the Banking Regulation Act. Section 5L of the 1949 Act defines Reserve Bank of India to mean Reserve Bank of India constituted under Section 3 of the RBI Act 1934. By reason of the aforesaid provisions of the 49 Act, Reserve Bank is empowered to control and supervise the functioning of the scheduled banks. Now, Milords, please see paragraph 15. A bare perusal of Section 21 would clearly show that the Reserve Bank of India is entitled to formulate the policies which the banking companies are bound to follow. My learned senior friends have said these are banking companies. Subsection 3 of Section 21 of the 1949 Act clearly mandates that every banking company shall be bound to comply with the directions given to it in terms thereof. Section 35A, which was inserted by the Banking Companies Amendment Act, empowers the Reserve Bank to issue directions inter alia in the interest of the banking policy. And then, my lords, paragraph 19.
Yes.
The respondent bank, in this case, my lords, the Punjab and Sindh Bank, concededly is a public sector bank. It was therefore bound by the said guidelines. The salient features of the RBI guidelines are as under, my lords, those are the guidelines in that matter. So, my lords, clearly, what the Honorable Supreme Court says, and the same words are echoed in 2002, Volume 1, SCC, page 367. I'll just give the paragraph and indicate it. But, my lords, the argument, my lords, therefore, is what prejudice is caused to a borrower. My lords, these, my lords, guidelines, these circulars are issued by the RBI to benefit, my lords, borrowers, so that, my lords, restructuring is undertaken before a recovery, my lords, steps are taken. That is evident from a reading of the circular itself. So to therefore say no prejudice is caused to me, my lords, by not following statutory guidelines by the Reserve Bank and India, my lords, cannot be, my lords, an answer, my lords, by scheduled banks who are, my lords, bound by, my lords, the instructions of their regulator. If your lordship just has with me, my lords, the circular itself, please have ink page 128 again. It is, my lords, issued in public interest.
Yes.
I'll read everything. Please don't worry.
Anything you want to add?
No, I just want to clarify.
Lord, 4 short aspects. Sardar Associates was a case where, I'm sorry, I thought my friend had completed. I'm so sorry.
Yes, I have, but I thought that was the rejoinder. That's what I was saying.
Yes, but you brought in new material in the rejoinder.
No, I didn't.
Sardar Associates was a case where OTS was accepted and then the bank sought to renege on it. Supreme Court says, no, you can't do that because the RBI circular says so. So therefore, that cannot be applied here. Point number 1. Point number 2, my learned friend says RBI's that paragraph 9 means all of us have to meet together. Completely incorrect. That is what the affidavit says, which is contrary to the regulation. RBI's affidavit, I may also point out, as served to us, does not even disclose the name of the deponent to us. And so also, in their statement of objections, the verifying affidavit has not been served on us. So I am more surprised than my learned friend, Mr. Datta, is.
I'm a little shocked now. I'm not just surprised, I'm a little shocked.
I'm grateful. If he's shocked, then I'm even more shocked.
That a bank can take a stand
He's
against its own regulator.
He's always had a way with words, and I'm very grateful to him.
I'm amazed.
The last aspect I wanted to point out is that ultimately my question on prejudice was, if 4 out of 5 have said no, whether or not the 5th person meets is of no consequence. That he has not been able to answer.
One submission.
Prejudice is no answer to a statutory provision.
Eventually, your lordship, as Mr. Nandakumar pointed out, irrespective of what that affidavit, as ambiguous as it might be, or as I don't want to go into reasons, eventually your lordships, exercising 226 jurisdiction will have to interpret the context in which all lenders is used in paragraphs 9 and 10. Now, my lords,
No, that's the only limited.
That's the limited question. Now, just to have it might be a very bad example, Maras. Kindly see how all can be interpreted in different manners. Your lordships may put a notice outside saying all advocates shall mention the matter at 10:30. Does it mean everyone enrolled here has to come at 10:30? No, that is contextual. All advocates shall pay a welfare fund per year. That means everyone, and so which is why the same. All advocates is used outside your lordship's court. All advocates is used in the bar council rules also. But kindly see how context makes the world of a difference. Which is why what Mr. Nandakumar's point is absolutely right. Board approved
all
policy.
lenders used in 9 and 10 doesn't appear to be so simple.
No, that's what it might be. But
no, it doesn't.
Context matters. Which is why he said board approved. This board is different from my board. It cannot be a meeting of minds for board approved policies.
Can I also say all borrowers are expected to repay their loans? If they did that, we wouldn't be in court.
No one is talking about a common policy. No one is common for a common policy. Policies are independent, but a decision has to be collective. That's what the RBI says.
One last
they increased their offer from 33 to about 50, and then subsequently, even those.
I'm ready to give a proposal. If they are willing to abide by the circular, I am ready to give a proposal. Let it be considered in a time-bound manner.
Even during the writ petition, proposal has been received.
The lordship may indicate a mandatory timeline.
1 minute, Mr. Senior Counsel. We are the second limb of the argument with regard to the NPA.
Correct.
Now, once declaring the particular asset itself as an NPA is bad, Everything goes back.
That's true. But actually, my lord, which is why I pointed out on affidavit, we pointed out that even though that letter seems to give the impression that as on 8th of February, everything is regularized. 31st January, there was, in fact, it dates back to 17th January, following which 31st January, another default happened. Let them state on affidavit, my lord, that the 31st January, they did not default. So just merely relying upon a mistake made by the bank in one stray letter cannot inure to their benefit to say that it cannot be classified as NP. They haven't filed a rejoinder to our statement of objections, where on affidavit have stated that there has been another default on 31st January.
Senior counsel, what do you say on that?
But there are also defaults
They
to
can't
us,
deny it.
other banks. That's not been even mentioned by them. I'm not given a clean sheet. I'm
Because-
also part of the consortium.
Yes.
Because the SBI's NPA declaration is, SBI is the lead bank of the consortium. Point number one. Point number two, if the declaration by the lead bank of NPA is bad in law, ultimately, Millard, the other banks follow the lead bank. The answer is simple. Three, assuming, Millard, that there is a valid declaration of NPA, Millard, still there is no adherence to the circular. NPA is only one facet. The declaration of NPA invites, Millard, a collective decision to be taken jointly by the lenders under, Millard, the circular. That's what the RBI says. It has said so in court. It has said so on affidavit. So therefore, what am I saying? Just a minute, please. Therefore, Millard, what am I saying? If, Millard, I am right in my interpretation of the 2019 circular, and your Lordship will just note one very important facet of the 2019 circular. Just make a note, Millard, I am not asking leadership to read it now. I think we have taken more than enough time. Para 29. Every other form, Millard, of circular has been recalled and withdrawn. This, Millard, is it. This, Millard, is the only existing guideline, Millard, on the date it is issued for Millard's resolution. And Millard's paragraph 4 of Millard's, with my friends asking me to read, I'll be very happy to read it. Millard's, these directions are issued by the RBI with a view to providing a framework for recognition, reporting, and time-bound resolution of stressed assets. That's the objective. Now, if there is no, the time-bound resolution of stressed assets is to be done through a collective process. And that means there is complete failure to therefore to bring an argument of prejudice to Millards try and defeat a statutory non-compliance, Millards, that too by banks who are bound by the instructions of the regulator, Millards, in my respectful submission, cannot be countenanced.
Now, if the court holds that the declaration of the account as NPA by the State Bank of India is bad, what will
Yes,
happen
Millards.
to surface proceedings?
Millards,
Will they, 1 minute, will they take it forward, the other banks independently, because now the consortium is leading it?
No, correct.
In fact, can I answer it like this? Insofar as NPA, insofar as default, he wants only the lead bank to say anything. But insofar as everything, the prudential norms, etc., he says, no, everybody should be there. Please say this.
There's no answer.
The answer is yes. To answer the court's question, the answer is yes. In the hypothetical situation that the court finds that the NPA declaration itself is bad, then everything goes, that much is correct. Of course, we may be entitled to restart, that's a different matter. But the question is, that is not something that they pointed out. Why, having given an OTS offer, it doesn't lie in their mouth now to also say that the NPA declaration is wrong. Also, I may point out, the day on which the NPA declaration is made, writ is filed almost a year thereafter. So therefore, this delay is also not something that's been explained by them. And after having filed the writ, there was no interim order to protect them. So today, to try and set the clock back by this technicality does not apply, for the other reason that admittedly there are defaults to other banks. So he can't now say, I've complied with one loan of the lead bank, therefore everything is regular. That's simply not correct.
Even otherwise, like coming back to answering specifically your Lordship's question. Yes, your Lordship is right. If your Lordship were to hold that the declaration of NPA was bad in law, yes, the edifice would fall simply because the genesis of the entire proceedings would be erroneous, assuming. But my lords, again, I reiterate, there is a stray letter. I can't deny that stray letter. On affidavit, we have come before your lordships and said there was a default on 31st January, which till date remains unrefuted. Therefore, my lords, a stray letter which the petitioner has received on 8th of February, saying that your loans are regularized, cannot inure to their benefit to say that the NPA declaration is wrong, which is why my lords have submitted. Then it requires a factual determination for which DRT is the appropriate forum. On 31st January, I have made a statement on oath saying that 31st January, there was a default. 90 days from then would admittedly would be 30th April. So therefore, if my statement were to be taken at face value, which I've stated on oath, then there's nothing wrong with the declaration. But to rely solely upon that letter and not refute my statement would be blowing hot and cold, would be my respectful submission to your lordship's question.
Yes.
Grateful.
Heard, sir.
I'm so grateful for a patient.
Grateful. Very grateful, my lords.
Lord.
Yes.
I may be permitted to appear because it is my matter, my lord. I may be permitted to argue. This is my personal matter, my lord. My lord, list is not between bank and borrower. List is between third person, myself, who is last 25 years in possession of the property, of which the owner is the retired court officer of this honorable court. Second respondent has nothing.
Pass over. Yes, next.
May I seek my some now the second respondent had approached DRT. He is paying the amount of NP.
We'll hear it. We'll hear it in the afternoon.
Allah, now what I request, my lord, I'll get the information. Let it be called after vacation. And NP is being cleared by second respondent. Whatever loan he is obtaining, he has
Which
been
model is there?
Next week it may be posted. Yesterday only copy was sold.
This is a matter on 16th of April.
16th April.
16th April.
Yes, next.
May this request, my lord. I can't get the information of the DRT DT.
You can get the information.
He
What
is not
happened
in file wakalat.
Who?
Ex bank.
Yesterday they have served copy on me. This court has directed to serve a copy on
Find out what is a lien counts for the respondent bank by the next date of hearing.
Why is I served the copy?
Submit before the court. What is the status of the case before the DRT?
Published.
Yes. His name is there.
The name is not shown. I'll file my wakalat. Just yesterday evening copy was served.
KB Lokesh takes notice on behalf of the respondent.
Let him serve the objection in
Undertakes
advance.
to file the wakalat. File your objections also by the time. And shall file the objections by the next date of hearing. Yes, 11.
Injection order may be extended.
But interim order kindly be extended.
Interim order only granted is extended 10.
I agree for the petitioner.
Yes.
This is the.
This also pass over. Yes, 11.
Lord, I appear on behalf of the.
Yes.
Well, a matter arises under the Karnataka Protection of Investors Interest of Depositors Act. My lord, notification has been issued, my lord, with respect to the petitioner under section 5. Now kindly see section 5. We are challenging that notification. My lord, of course, there is a challenge to the certain provisions of the statute. My lord. I really don't think I'm going to trouble you a lot with that.
Before my learned senior counsel, but since they have left out the prayer number 1, they have not pressing it. Mr. Budiyal has to appear for the competent.
No, what is the prayer they say? Please come to the prayer.
My lord, yes, my lord. Prayer, your lordship may turn to page 44, my lord.
44.
43.
43, my lord.
3.
Your lordship may kindly turn to page.
Yes. Declare section.
Yes, my lord. If your lordship will kindly see, my lord, page 43. Declaring sections 22, 24, 362E and 62F of the Karnataka Protection of Interest of Depositors.
You're
in
not
Finance.
pressing on this.
My lord, at this point of time, I don't think I want to trouble your lordship to do that. But of course, my lord, your lordships may, if I am right in my submission with respect to the challenge to the notifications, my lord, and I succeed on that, then my lord, I really don't think I want to press.
No. Now, if it is notified and a special court is constituted.
My lord, no, my lord. This is a notification issued by the government. If the notification is valid, then kindly see these provisions of the statute. I am now challenging, my lord, the very application of the statute which is on the basis of the notification. Your lordship may kindly see the notification, my lord, which is at 82, page 82 and 104.
Act. Give the act.
My lord, yes, my lord, your lordship gets the act at page 115. We have put it along with the petition. Your lordship may kindly see section 5, my lord, for a minute. It is this notification issued under section 5, which is now being called in question before your lordship.
Yes.
May I read your lordship section 5, my lord.
I think we'll ask him who is the counsel appearing. We'll take it up in the afternoon. Let him come.
Who the advisor?
So and so.
Oh, yeah, I'm not.
Inform him.
2:30, madam, we'll be here.
Because there are so many matters today, or else I'll take tomorrow.
I'll be, whatever.
No, if it is passover also, it's fine, because I won't be able to take it at 2:30 because I have Dharwad matters also.
Then, my lord, you'll have to be posted tomorrow.
Tomorrow.
Tomorrow I'll be,
Yes.
I'll be here.
Yes, well.
My lords, may I have it on the same stage? Same stage, madam.
Yes, same,
Yes,
same, same. Yes, great.
Yes, well.
Appearing for petition. Senior is in dispensary. Petitioner.
13, I'm appealing to the respondent, my lord.
Petitioner, your lord. Senior is in dispensary because of his has throat infection. Week 1 week.
This is matter on 24th. Look at it if interim order is there, extend. Yes, 13.
24th.
I'm appealing to the respondent.
Yes.
This matter I'm for petition.
Lord, the cop, whatever IA they have filed, they have not served it to me, my lord.
What is this extension of time?
Lord,
My lords, the writ petition filed earlier was disposed of, directing us to pay 1 crore 81 lakh to the bank, my lords. There was little delay in payment, my lords. Therefore, I approached to the bank and with the DD and all, my lords. They are not,
The order passed.
my lords, the three installment, I have to pay 1 crore 81 lakh, my lords, to the bank. But they are not accepting.
disposed of on 18/12/2025, my lord. That they had agreed to pay on or before 31/2/2026. The entire amount, that is the OTS amount, we had given it to them. 1 crore 81
They're
lakh.
supposed to pay by February.
February.
28th
They have
February,
not
my
paid.
lords.
When did they come back? When did they
Lord, that I
approach
am
the
not
bank?
aware.
6th
When
March,
did you
my
approach
lords.
the bank?
6th March, I have approached the bank, my lords, so by making a representation, my lords.
What they have filed, they have not
Give
given.
it to
what
her,
we-
we'll take it up tomorrow, get instructions. Anyhow, whatever is
sir.
from that day, council, from
Please,
that
Lord.
day, if the last day is 24th, till today, whatever is the interest that accrues on that, we'll direct him to pay.
Yeah,
Get
we are-
instructions from the bank.
We are ready, my lords.
Yes.
I'll just ascertain.
When
with
do you
the
want?
bank. On Monday, my lord?
Yes, Monday is a holiday.
Oh, sorry, my lord. Wednesday.
This is a matter on 16th.
Please.
By the time when council appearing for the bank, she'll get instruction.
Serial number 11, the interim order may be extended.
It's already extended. Yes.
Have it as 15th, my lord, because other cities also there. There are two discrepancies in the accounts. Set right, my lord.
He has contested the
Well, in
way.
one statement, they said 2 crore 75 lakhs. Last day, they have given a statement of there.
Why this court is looking at all these discrepancies? That's not the business of this. court.
There was a
Why we
direction-
said 2
there
crore
was a
75
direction-
lakhs was on a
I'll
contractual
make
obligation.
make a submission, because there was a direction from this court to look into that apartment that was not looked into by DRT. That's why, my lord, this decision has come. My lord, 15th, my lord.
He has contested OA, he has contested SA, and the SA final order has been challenged here.
What kind of fifth list the matter on
16th,
on not 18, on 24th.
plus interim order is operating against.
24th, finally, whatever it is, I will decide it on that day.
For the petitioner's counsel, my lord.
Hmm.
In this matter, my lord, I am an agriculturist and I am a retired police constable. My retirement benefits I have not yet received. The matter is pending before the court. I borrowed 26 lakhs for
I
construction.
heard this matter earlier, I think.
Yes, my lord.
I heard this matter earlier.
Yes, my lord. 23 lakhs I have paid. I was directed to pay 8 lakhs 50,000 last time. That has been paid. I have produced the receipt. Now, my lord, the difference is now 20 lakhs rupees. According to the Reserve Bank of India, which the other matter was argued by Mr. Nandagopal, all this one-time settlement scheme, the government is going to come up with a new policy. This is what the information I got from Delhi. No,
Not consider
my
all
lord,
that.
my lord. Your
What is the
lordship.
present position is
No,
what
the
we are
present
concerned with.
position is this. The offer that was given by the bank was for 23 lakhs rupees, 2350 lakhs I have paid. Now they cannot close the loan because one-time settlement scheme is not in practice now. It has been lapsed last year. It is going to come in this month's last week. So we have to wait for some time. Your lordship may kindly call this matter after vacation.
We'll hear the bank.
No, my lord.
Where is Mr. Muttana?
No, my submission is only this, it may posted on 16th, my lord. Today I have some inconvenience.
Yes, this matter on 16th, on the day I'll hear the matter on the merits, no adjournment.
Interim order may be extended.
Interim order is extended, it is made clear that on the day the matter will be heard on the merits.
Please.
Yes, 16. No representation for the respondent bank. Is 16?
I prefer respondent. My lord.
Petitioner,
This
Lordship.
infectious, my lord, is a challenge the action notice in 2025. That day is not action.
The writ petition is filed against the respondent bank, which is not a nationalized bank in the
Lordship,
light
there
of
is
the
inter-
judgment of the Honorable Apex Court in so
I'm
and so.
filing memo for withdrawal in this both matter, Lordship. 15 and 16 and
17.
17, Lordship.
Withdrawal.
Want to withdraw?
Withdraw and I want to approach
The
DRT.
memo is filed seeking to withdraw the petition in the light of the law laid down in so and so. The writ petition is not maintainable against the respondent. The respondent, accordingly, the writ petition is disposed of giving the.
There is an interim order, Lordship. I maybe have an
No, no.
benefit, Lordship, until I approach DRT, Lordship.
Appropriate remedy before the DRT. He has an interim order in this.
Yes, my lord, but
Interim order
is a
is-
fake document is annexure C.
Petition has the benefit of an interim order. It shall continue for a period of 4 weeks. Petition shall have the benefit of section 14. Yes, next. Yes. Yes,
Same, then.
adjourned 19.
17 also same, Lordship.
For respondent, my lords.
The
Not maintained.
petition is filed against PNB Housing Finance Limited. There is no representation on behalf of the petitioner. The writ petition is filed against PNB Housing Finance Limited. The writ petition so and so is not maintainable in the light of so and so. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to prepare the appropriate remedy. He shall have the benefit of section 14. Yes, next please. 20.
For respondent number 1, my lord. My lord, on the previous occasion, I was directed to file memo regarding the payment what the petitioner has done. Filing memo, my lord. My
Have you
lord,
given him a copy of it?
copy also given.
Give him a copy, pass over. Yes, 21.
Obliged, my lord.
My lord, this was the matter with the DD that we needed in the name of the original.
Yes,
My lords,
I think you have received the amount from a particular account. To that account, why can't you transfer it?
no, the demand draft was on the, even your lordship, if your lordship pursues the order on the day interim order was granted. The demand draft was given by the petitioner to the Golden Gate Properties Private Limited. That's the petitioner's name itself. The amount has been deposited to petitioner's account only.
My lord,
Now they are demanding to some KA Home who is a completely third party. KA Home has not paid.
Show that, where is it given? DD that is mentioned in the order?
Yes, DD copy is there.
Take that DD copy.
Do we have a copy of the DD or anything?
No, DD copy.
What was originally issued? Photo again.
This is our DD which we have bought to
No,
hand it
not
over.
your DD. Where is their DD according to you, which is given on somebody else's name?
They'll have to produce that.
We'll just produce it. It may be passed
Passover,
over.
yes, next. Appear if after in the Passover, when the matter is passed over. Yesterday also you were not there. We would have clarified it yesterday itself. It's Passover. 22.
Yes, appear for please.
Yes.
Last time when my lord directed to file objections by the state government.
Not objections,
Give that.
directed to
Give the
take
file.
instructions, my lord. I have instructions. This is
The DG
cut
shall
and
get
trim.
specific instructions.
Yes, the cut
What
and
is-
trim of the tarmacs.
Tamarind
Tarmacs.
trees.
Lots
yes.
of recollect that, on the road.
Tamarind.
The issue is that, we have not given any license to anything. If he is interested, he can participate in the auction proceedings and he can, if he's a highest bidder, he can get it. He doesn't have any rights over that particular trees, where he can claim a right over the
Is
trees.
this matter after vacation? Yes. Passover.
Petition, your lordship.
My lord, any DD next week, my lord, we will file our objection.
This is the matter on 24th. Yes.
24th, the matter is agenda 24. There is a civil court order not to alienate. In spite of that, petitioner is not at all an owner.
Which
So,
case?
He's only, and the DRT order is go to civil court. I am ready to go to civil court. But still they are
I've made it clear that we will not interfere when
No,
when there is an order, you please get it implemented.
No. My lord, DRAT cannot intervene in this case because there is a civil.
Not DRAT. What is the relief? Please come to the relief.
My lord, but DRT order is there.
Certified the
I produced
final
the
order
DRT.
dated
DRT order is, my lord, so when DRT order is there. DRT directed me to go to civil court. Kindly see the DRT order, my lord.
So why it should be set aside?
My lord,
Why it should be set aside?
my lord, the petitioner is not the owner of the scheduled property. He is the co-owner. There is a will executed by his father that after the death of mother, he will get the share. He has not got the share. Mother is still existing. In spite of that, one bank takes his guarantee. There is a fault at the bank to taking the guarantee of this person who is not an owner. Well, now auction sale is issued. Well, there are 8 persons. They are fighting in the civil court for a partition, 2019 onwards, and there is an order not to alienate in that the suit. Well, these persons taking the guarantee by this person. Well, bank has committed fault.
For Baroda, who appears? Vignesh Shetty is directed to
Well,
take
have it
notice.
on 24th. Well, another case is there.
She'll get instructions. List the matter on 24th. Yes.
My lords, if I may just, in item 25, we found the DD, my lords, it's clearly in the name of K. I'm not sure what my learned friends.
You will see when the matter comes. Yes, 26.
I filed memo for undertaking, my lord.
Memo of undertaking.
Undertaking for Ranjan
Why
Kelkar.
bank is filing memo of undertaking?
My lord, I appear for bank, my lord, filing memo for undertaking for bank. Respondent number 1, my lord. Ranjan Kelkar. Appearance undertaking.
Why are you giving this to the court? I don't understand. You don't get instructions. You have instructions?
No, my lord.
Then I'll pass orders. Yes, so you argue.
My lord, in this particular case, the respondent has filed a symbolic possession notice, my lord.
But what is the
me.
prayer?
My lord, the prayer is to set aside the symbolic possession notice issued to the petitioners to Annexure A and Annexure A1.
Pass the notice bearing
My lord,
dated issued by the respondent. What is this notice 13 to notice?
My lord, it is under 13 subclause 12 notice, my lord. It is under Surface Act. I have taken a loan, my lord, an OD, and subsequently, my lord, my products, the OD is still existing, and now they have issued me 13-2 notice, subsequently 13-12 notice, my lord. Lord, in this particular case, they've also initiated a DRT proceedings against me. And I've also filed a consumer complaint, my lord. The district commission has allowed the consumer complaint because on the OD there is insurance claims, and the main aspect is through the bank only we have taken the insurance also, my
No,
lord.
whatever it is, go before the DRT. Why should this court interfere?
My lord, while the proceedings they have initiated before DRT, they are repeatedly issuing symbolic possession notice, my lord.
They will do
While,
it. They will do it. You go before the DRT and obtain
Well,
orders.
we are before DRT also. It's not that we are
Ask
not
for the relief
DRT.
before
my
the
lord.
DRT.
Well, but however, we are also before the consumer court, my lord. In state commission, they have challenged the order before the state
But we
commission.
can't. Why? One matter in the consumer forum, one in DRT. No, the High Court will oversee what is happening in DRT and consumer forum.
Here they have only challenged because, my lord, they are repeatedly harassing us. There's only one property
That
which
you
we
can
have.
ask DRT also. Why should this court look into that? That's what I'm asking.
Because the only reason is because they have multiple times they're issuing
Please get
symbolic
instructions
notices, my
from
lord.
your client. We will not entertain this petition. This is matter on the day after tomorrow. Yes. Canara Bank, Divya Purandari is directed to take notice on behalf of the petitioner. And counsel has the copy on the counsel for the respondent. Is 27.
Sorry, because I challenge the position notice, my lord, under section 13(4). The Lordship may kindly see annexure 29, page number 29, my lord. Actually, the respondent bank, my lord, given sanctioned loan for a sum of rupees 42 lakhs. Out of that, my lord, only 34 lakhs was disbursed to the petitioners. And thereafter, my lord, the government of Karnataka has given
Krushi Bhagya subsidy of 14 lakh 80,000 rupees, my lord. That also they were deducted in 2006.
What is outstanding now?
Now, ma'am, according to them, when they have issued, my lord,
What was the loan granted?
a poly house construction loan, my lord.
What was the loan initially? What is the amount?
42 lakhs. Out of 42 lakhs, actually, they have paid only 34 lakhs. And so government has given 14 lakh 80,000 out of that subsidy also. They have taken directly to the bank. Now, my lord, 29/1/2026, my lord, they have issued demand notice for 78 lakh. I don't know what is the.
You should have asked them if they
Because,
have given a demand
and
notice.
moreover, you lordship, kindly.
If they have given a 13-2 notice specifying a particular amount, you should have given your reply.
One submission. You lordship may kindly look into page number 29. They have given in 14/8/2025, my lord, they have offered OTS to the petitioners. They offered OTS, my lord, and they have collected 8,30,000 out of 38,000, my lord. 38 lakhs. Out of 38 lakhs, my lord, they have taken 8,30,000 in addition to that subsidy. And again, my lord, what basis they are claiming 78 lakhs. So
All
that
those things this court will not answer, Mr. Counsel.
Yes, my lord.
Why this, how this court is concerned with all that?
It is violation of principles of natural justice and RBI
No
guidelines.
principles of natural justice. When they've given a notice under 13-2, you should have asked them. Even now also you can ask them on what basis you have arrived at this figure.
But now they have issued 13-4, my lord, threatening to take position.
Yes.
But I may be permitted. They have challenged the position notice 29/1/2026. Because of there is a technical issue, we have withdrawn all the notices and we have issued a fresh demand notice on 29/3. That is the last month. And the entire proceedings challenged before this honorable court becomes infructuous. We are placing the record and we are communicated to them also. There is no.
Have you given him a copy of it?
Yes, sir.
My lord, one submission, madam. They cannot go on issuing demand notices one by one after the other.
While seeking the following prayer. In this writ petition, the petitioner has questioned the position notice dated 29/1/2026 and also raised several grounds. Then counsel appearing before the bank, placed before the court, has submitted that they have withdrawn all the notices earlier. They have withdrawn all the earlier proceedings initiated against the petitioner, and they've issued a 13-2 notice on 2/3/2026.
They still have an option of 13. They still have option of replying to the particular demand notice, Lordship.
The petitioner has so far not given any reply to the same, considering the fact that the impugned notice is withdrawn by the petitioners. Nothing survives for consideration in this petition. Accordingly, this court is passing the following order.
My lord, on submission, my lord, on submission.
Disposed of.
Till such time, my lord, let there be interim order.
They
my
can't
lord.
take any action now. It's only 13-2 notice.
Please, I understand.
Accordingly, the petition disposed of giving liberty to the petitioner to give reply to the 13-2 notice dated
2/3/2026.
2/3/2026. Yes.
My lord, I have filed the objection with the bank, respondent bank. They have not yet given reply. And 2nd April, I have filed with them. And I have filed a copy of that objections in the registry of the counter there. The matter is extremely urgent, Your Honor.
But I have already expressed that you can't have any relief from the court. But you are insisting the matter is adjourned.
I have filed the objections, Your Honor.
Let's see, this matter on 25th of April. Yes.
Component in this petition is not maintainable since the respondent is a private financial institution. And prayer seeking in the relief petition is also not maintainable because infructuous.
What is that?
The physical position of the secured asset has been taken on 4/4 of this month, last week, my lords.
Position is already taken.
Already
Now,
taken
they have
and
questioned the auction notice.
Sale also not materialized.
The present writ petition is filed. Seek the following prayer. The respondent is Hero FinCorp Limited, which is a private finance company. Against such a writ petition is not maintainable in the light of the law laid down in so and so. Further, when counsel for the respondent submits that the auction could not take place as per the notice dated 24/2 2025. And accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy for the DRT if any action is initiated. If he is agreed by any of the actions by the petitioner back. No representation that you write for the petition. Yes.
For the petitioner, my lords.
Private bank, lords.
Lords, I have filed challenging the sale auction notice, my lord. The sale is scheduled for tomorrow, my lords. My lords, here in, my lords, substantial payments have been made by the petitioners, my lord. Petitioner at the time of availing loan, my lords, please,
it is not a nationalized bank.
yes, my lords.
The writ petition is filed against so and
My
so.
lords.
The writ petition against the respondent is not a nationalized bank. Hence, in the law laid down in Mr. Bharati, the petition is not maintainable accordingly.
My lords, may I make a submission, my lords? Earlier, my lords, on the sale auction notice in 2022, my lord, a writ petition was filed, my lord.
Maybe.
My lords, may I just submit? It was filed and interim prayer was granted, my lord, and they had complied with it. Even today, my lords, the petitioners are willing to comply with the conditions, my lord. As the auction is
shall have the benefit of section 14. Yes, next.
Lord, interim order, my lords. Auction is tomorrow, my lords. They are ready to undertake and they are ready to deposit 20% as on today itself, my lord. Kindly, my lord.
No.
My lord, the petitioner is currently aged 79 years, my lord. Considering her.
When you have when you have the remedy of going to DRT, why should you come before the court? Because earlier a court has entertained the writ petition, that doesn't mean that it has to be entertained.
Yes, my lords. Due to the urgency, my lords, and the age of the petitioner, my lord, they have requested.
We can't, please, Mr. Counsel, please don't
my lord,
make these
one submission, my lord. One submission, my
not
lord,
entertain on that ground.
My lord, auction is scheduled for tomorrow, my lord.
Let it be. Yes, 32. Admit, post for final hearing.
32, sorry, 32 to 35.
Yes.
This is the matter that no notice was not ordered on the.
Where is he? Where is Mr. Passover? Yes, 37.
Yes, my lord, in 37, I am appearing for the petitioner. My lord, actually, this petition is pending since 2022, but till now, no objections have been filed by any of the parties.
My lord, for the respondents, there's an identical matter that was dismissed in 2022.
No, my lord, there are various judgments of this Honorable High Court and other High Courts on the COVID-19 reliefs. And our case is also fully.
Please come to the court. List this matter.
My lord, grant a 1 week adjournment. I will appeal physically and I will submit everything.
On 22nd. Look at it if interim order.
My lord, can be the date much earlier, either on 16th or 17th, because I am coming from Delhi. So there are some other cases listed.
Yes, 38.
Grateful.
I'm for the petitioner in this case.
My lord,
Petitioner is.
the sale is not taken place and the writ is not.
Give that. The writ petition is filed, questioning the e-auction notice dated 9/2/2023. The writ petition is filed with the following reliefs. One of the relief is question the e-auction notice, and also the second relief is to extend the moratorium benefits, and the third relief is to clarify the hidden charges by the bank. Then counsel appearing for the respondent bank submits that the e-auction as per the e-auction dated 9/2 e-auction. The notice, the auction has not taken place. Hence, the first relief, the petitioner is not entitled to. First, nothing to be adjudicated on that. Then coming to the B and C, the petitioner can approach the bank accordingly. The petition is disposed of, giving liberty to the petitioner to approach the bank. Yes.
But 39 appearing for the petitioners. On the last date, Maharaj's petitioner, I was directed to serve a copy on the respondents. But I said that the learned AG to take copy for R1 and R2. However, he informed he is not the correct authority to take the notice. It appears in the connected petition, the AG has taken notice for R1 and Mr. Joshua has taken it for R2. I may be permitted to serve both of them.
For R1?
For R1 AGM.
AGA.
AGA.
For R1, AGA takes notice, and for R2?
Mr. Joshua Samuel, it says.
Write in the paper and give so and so is directed to take notice. Delete the name of Mr. Shanti Bhushan. Yes, list. Any urgency in this matter?
That's not
Sit after vacation. Is 40.
So the interim order may be extended, my lords.
It's
Order earlier granted. Look at it in which matter it is that you extend. Is 40.
This is regarding fishery rights. Fishery rights, where he said that the work order was not issued. Work order is already issued. I have a copy of it.
Awesome.
Yes, ma'am.
41.
Correspondent, my lords. Since many hearings, they are not appearing before.
Pass over, we'll see. He's not appearing. List this matter for dismissal tomorrow. It's already 140. Pass over. This 42. Pass over.
Appearing for petition, so they are withdrawing. Liberty may be given to go to DRT. Also.
Who moved the memo?
We moved the memo. We moved the memo.
We have challenged ACM court order, Your Lordship. We have challenged ACM court orders, and the payment.
Matter was disposed on Monday, madam. Similar matter.
Pass over. Let you ask Dinesh Shetty to come.
Please, madam.
Respondent, Madam, I'm filing objections. Copy is served to other side. It's
The
a private
petition is
company
filed
bank.
against Piramal Capital and Housing Finance Limited seeking the following prayer. Same in the light of Vishwabharati, so and so. The writ petition is not maintainable. Accordingly, disposed of giving liberty to the petitioner to file the appropriate remedy. For the
Objections may be
DRT,
taken
section 14. We shall have the benefit of section 14. Any interim order in this?
But not to precipitate was the order.
The interim order earlier
Lord,
granted.
in this matter, I am
You
for the
correct.
petitioner, my lord, 44. Kindly pass over the matter, my lord.
Pass over. Yes.
The date can be given, can be.
No
posted.
date. No date. If you want pass over, I'll grant. Yes, 47.
My lord, serial number 45, my lord.
Morning they sought for time.
My lord, they are not intimated me, my lord. They have to supposed to file an undertaking affidavit, my lord. In
But he
terms
said
of order
tomorrow.
dated,
Huh?
my lord.
22nd they have asked for. Yes.
Please,
47.
My lord, they are taking contention that that is an agricultural
Yes, pass over.
property. It is
48. All these final hearing matters give a date. Yes.
For petitioner, Lord, kindly pass over the matter. Great.
No, don't call this partnered matters. We'll hear it. Yes.
Pass over. 51.
My lords, in that item 21, the check we can show, my lords, there's absolutely no reason for my learned friend to be denying that, my lords. I don't understand on what basis he's made that submission.
Lords.
It's a very simple thing. We just want the check reverted back
Kindly,
to the
Lordship,
account from which it came.
Lordship, may kindly check the check. The check was issued on the day of right in granting of interim order. This demand draft was shown to seek an interim stay for the sale, which they successfully stalled the sale after proceedings.
That is what is recorded.
As against the
in order,
payment
my
of
lords.
10 crores, they did not say this demand draft is coming from third party. They did not say anything before this court. It was represented in the way that the petitioner, let me complete, madam, please. Let me complete. It was represented to this court that the petitioner is handing or giving that 10 crores. Now they are coming when the refund.
Have they accepted it or not, my lords? My learned friend might let us know.
No.
Have they deposited that DD?
Now
And can that same
Let
DD
me
be
complete,
issued
Lords.
back?
Now the situation is.
There's absolutely no reason for something
The
like this,
situation
my
is
lords.
that, my lord, the demand draft is been now deposited in the account of Golden Gate Properties in the petitioner's name. Now I'm giving the demand draft in the name of the petitioner itself. Now if there's any order of this court lost to, because again that comes under banking.
We'll pass an order.
Oblige
saying
me,
that,
oblige.
Like in whatever manner it is given to the same name, you give it back.
Please, my lords.
Oblige.
Please
Should be order of this.
They may agree to do that, my lord, so that on the next date we can close the matter out, my lords. Deeply obliged.
ಮೇಡಮ್ ಸೀರಿಯಲ್ ನಂಬರ್ 46 ಬೆಳಗ್ಗೆ ಅರ್ಜೆಂಟ್ ಮಾಡ್ಕೊಂಡು ತೊಗೊಂಡಿದ್ದೀರಾ?
ಮೇಡಮ್ ಅದು ಐಟಮ್ ನಂಬರ್ 21 ಯಾವ ಡೇಟಿಗೆ ಹೋಗಿದೆ ಮೇಡಮ್ ಇವಾಗ? ಇವತ್ತೇ ಕೇಳಿದ್ರಾ? ಓಕೆ ಓಕೆ. ಸೊ ಫಸ್ಟ್ ಧಾರವಾಡ ಬೆಂಚ್ ಮೆಟಲ್ ಇದೆಯಾ ಅವರಿಗೆ?
ಆ ಕಡೆ
ಹಾ.
ಆ ಕಡೆ.
Thank you.
Court officer, ma'am. Hello. Court officer, ma'am. Hello. Court officer, ma'am. Hello. ಮ್ಯಾಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರಾ ಅಥವಾ ಪಾಸ್ಟ್ ಓವರ್ ಮ್ಯಾಟರ್ಸ್ ಕರೀತಾರಾ? ಥ್ಯಾಂಕ್ ಯು.
ಇವ್ರು ಯಾರು ಕನೆಕ್ಟ್ ಆಗಿಲ್ವಲ್ಲ ಧಾರವಾಡ.
Madam from Dharwad bench.
You are connected?
Yes, yes, we are connected.
Wait, man. Wait.
Okay, okay.
Is it Dharwad matter?
The matter pertains to Dharwad for being spoken to.
Appear for petitioner, my lords.
I appear for impleading.
Now, in this matter, you have filed your objections, Mr. Chandrasekhar.
Please, my lord.
Please come to your objections.
Objections, my lord.
Yes.
Please, my lord. That is, my lord, return submissions, my lordship is saying.
No, 1 minute, 1 minute. Come to paragraph number 8.
Please,
Paragraph number 8 of your written submission.
please, my lord.
Hmm.
As per the circular that a technical bid is supposed to open within 48 hours. Accordingly, same was opened on 20th 9 2025. From then, evaluation of technical bid will be completed on before 30th day. And accordingly, evaluation completed 20th 10 2025. By oversight, synopsis appears as 21 10 2025. Please.
Then? After?
Thereafter, that after 20th 10 2025, opening of final bid is supposed to open on or before 35th day, and accordingly 35th day would be on 26th 11 2025.
No, it is not. That is what is the mistake. 30th day or 31st day, from 20th 10 2025, you are counting 21 days, 35 days. How can it be?
There are two aspects, Millars. Opening of Millars that
Whatever it is, once the time starts running, it runs continuously. At one point of time, you say take a particular date. From there, you are saying 35 days. And the court, I have also looked at that, and I said it is within time, but it is not within time.
No, it is within time, Millars. It is within time.
How can it be? No, please come. Please come to that circular. Come to the circular.
Please.
Issued by the government.
Please, Millars.
Where is it? They filed along with the writ petition.
It's, document number 1, Millars, 29 11 2021.
Page number.
Page number.
Page number 96 to 97, my lord. At annexure in the writ petition number 110063 of 20.
Give the 110063.
Please, my lords.
This is 108830. That is a serial number?
My lords.
You said 11?
110063 writ petition number.
Yes, 1.4. Last one. Last writ petition. These are all batch.
At annexure E, page number 96, my lords. Government circular.
96.
96, my lords. At annexure E.
Yes. Yes, Mr. Chandrasekhar, as per this, please give the dates.
Please, 1 second. 1 second.
So when was the bid? When was where? Opening of the technical bid is within a 48 hours. Which is the date? Which is the date?
1 second.
It was opened on 29/20/25. The evaluation of technical bid to be completed on or before 30th day. That is completed on 2010. After 2010/2025, the opening of financial bid is supposed to, before, that is on 35th day. 35th day is when it is on 25th, 2510. There, that's what you have taken it as 2611.
Please.
That is the mistake.
No, my lords, I have made my lords synopsis submissions. In the synopsis,
In
my
the
lords,
synopsis only I'm saying. Now you please forget about your synopsis. Now,
Please.
as per the circular, opening of the technical bid was on 29. Evaluation of the technical bill to be completed on or before 30th day. That is on 2010. Opening of the financial bid on or before 35th day. 35th day is 25/10/2025. Evaluation of financial bid to be completed on or before 50th day. That is another 15 days. That would come to 10th.
not
10,
10th.
then
My lords,
10/11/2025 or 11/11.
the evaluation of technical bid minutes as per circular minutes, 21/10/2025 minutes. Page
It is
9.
the 50th day. 50th day is from the first day you have to count that 50th day. So
It has
35th day is on 25th. Then when will be the 50th day? That is
On or-
another 15 days.
no, the technical bid minutes 30th day will minutes on or before. It is going to be completed on 21/10/2025 minutes. And opening of final bid minutes is concerned is as per the circular minutes. It is to be completed on or before 35th day minutes. Accordingly, 35th day minutes will completed on 26/11/2025 minutes.
Yes.
Thereafter, minutes, the writ petition order minutes wherein the stay was granted on 24/11/2025. So, writ petition order minutes.
Why do you have to look at the date? Right, look at this circular at page 96 and start calculating. In that calculation only, I found fault with that. That's why the matter is posted for being spoken to. Who appears for the petitioner?
I appear for the petitioner, my lords, on behalf of Mallikarjun Swamy B. Hiramat.
Yes.
My lords, may I request for tomorrow, my lords?
Tomorrow, please come up with a table of dates,
Please, my lords.
whether it is as
Yes.
per the circular or not. As per
Yes,
his
my lords.
written documents and as per what he submitted, that's why I allowed
Yes,
the
my
writ
lords.
petition. While again
Yes.
looking at the dates, I felt that this is not correct.
Please, my lords.
I will
I
make
shall
it
prepare a chart and
Tomorrow.
file it
Please.
along with the memo, my lords. Great, my lords.
This is smarter tomorrow. Yes. Hmm? What is that?
List number 1, serial number 2.
How much time all of you require? Already today morning, one matter has taken about 2 hours. So the entire list is, I'm yet to complete it. You yourself?
But I would say, my lord, that we have complied with all the my lord, statutory requirements. Sale, my lord, has already taken place. The purchaser has got implemented. They are waiting for the sale certificate. This is, my lord, they are saying, my lord, vague things that, my lord, that notice is not issued. We have the valuation is not made. We have the entire thing, my lord, valuation is made. Now they are giving a counter offer where only 21 lakhs is more, my lord. So, my lord, actually there is nothing in the matter. It should not take such a long time. If your lordship wants to take it tomorrow, day after tomorrow, my lord, I will be there.
I will have to, because I will have to point out the irregularities in the sale notice. That's why I'll take an hour. Maybe my learned friend has nothing more to say.
16. Don't put it at 2:30. 16th.
But I'm not here on 16th.
You're not there. When? Then?
25th.
25th. Saturday working day.
Yes, my lord, sir. Can it not be on 25th?
24th then.
24th is all right.
24th, my lord.
24th.
Yes.
Great.
24th, don't say 2:30, just 24th.
Or is it, my lord, sir, 23rd? My lord, I'm so sorry. 23rd is all right.
There are so many matters. Yes, call the list. Pass off.
Matters. Number 1, serial number 7. Sanjay U. Prabhu, Vignesh Shetty for respondent.
Yes. What is
The interim orders will have to
what is,
continue, my lord, from the previous.
interest for
The interim order.
Interim order
Please.
will be extended. Yes.
Please, my lord.
What is the interest for the savings bank?
My lord, in saving bank, 2%.
How much?
2%.
Please come.
No, 1 second. But with regard to the order, my lord, interest part is concerned, my lord, I had filed an appeal at that time, the order copy may be low. The ink page, annexure B, my lord, ink page,
Page number.
page number 16, my lord.
Hmm.
Before that, my lord, I filed a being spoken to before the previous page, my lord. Then, my lord, ink page 15, my lord. Learner counsel for the petitioner has moved a matter seeking direction on the score that at the time when the matter was disposed on, out of inadvertence, the mention about the interest on the amount being returned to the petitioners was omitted. The omission was led to the filing of this application. This is ostensible that the amount was lying with the bank, which belonged to the petitioners, as it was an excess amount after the sale proceedings being appropriated by the bank towards the loan. If the excess amount belongs to the petitioner, it was incumbent or is incumbent on the bank to buy interest at the bank rate. At that, they would charge on any deposit with the bank.
No,
Therefore-
unless and until the amount is fixed is kept in a fixed deposit, we can't direct the bank. That's a settled law to pay the interest on the fixed deposit. Whatever is the interest, that's why I asked them. They said it is 2%, that we will ask them to give.
My lord, for that, my lord, it is further written, my lord, in the order itself.
I've seen it, but there are
This particular
judgments.
case only.
There are judgments contrary to this. I've gone through that. Now, if the amount is fixed even if you have asked, okay, pending litigation, please keep it in a fixed deposit, then you are interested for that. No, we can't say that why the bank is not keeping the money idle, they're using it. Those are all not open.
Lord, I'm not the person, my lord, where I'm not asking with any stranger. The bank has utilized my money, given it to some customer as a loan, and
It's not so
may
easy.
not got an
We
interest.
can't assume that,
Where-
we can't
no, my lord,
assume.
it's not assumption, my lord. Bank is doing only lending business, and my lord.
That I'll record, that you have made the submissions on the
Please,
last occasion.
Please, my lord,
I'll
because my
record.
lord, the present situation is, I stood as a borrower with them, and they have charged me heavily when I stood as a borrower. And when I lost my property,
Yes.
the property, my lord, excess amount, maybe there was a dispute between sister and brother, my lord, both joined together and filed a petition. And the court, my lord, when the order came to be passed by the, my lord, there was a very clear direction that it is fixed deposit amount, not the amount of the bank interest.
The petition is filed seeking the following prayer. The case of the petitioner is that the petitioner had availed a loan from the respondent bank, and the property mentioned in the schedule was given as security. The bank had sanctioned the loan for an amount of rupees 20 lakhs in the year 2006. The petitioner and who has availed the loan? Father has availed the
Father,
loan.
my lord, not 2.75% interest.
The father has availed the loan, struck a father. The father has availed the loan from the bank in the year 2006. When he died,
My lord, I mentioned in the my lord, my statement of operations.
after the suppressive proceedings
After starting
concluded,
suppressive proceedings.
as the father was not paying, was not regular in paying the EMIs, the account was declared as NPA, and the bank has initiated the proceedings. Then the mother of the petitioner, what is this wife of the petitioner?
No. Brother and my lord sister, legal heirs of my lord, my borrower approach this honorable court.
Correct, then where is the wife of brother of what or?
She was a guarantor, my lord, and
That's
her name
true. Whose wife is she?
the petitioner's wife. My lord.
Petitioner is the legal heir of my lord, deceased borrower.
Now, here the petitioner is, my lord, petitioner's wife had challenged my lord essay because her name was mentioned wrongly by the banker.
Who is the principal borrower?
Principal borrower is the father, my lord.
Where did you say so? The petitioner had availed a loan from the respondent bank and the property in the as security. But he is not the borrower, you are not the borrower.
It was a construction company.
Huh?
One firm, my lord, for which father was later on father, my
No,
lord.
no, it's not
died.
so, my lord.
Thereafter, my lord.
One Subramanya Naidu is the my lord borrower. He is having some property concern, and my lord, during the my lord, in the year of 2015, my lord, we initiated the action under Surface Act. He died, my lord, deceased during that time, and my lord, we issued the 13-2 and 13-4 against their legal heirs. They came before this honorable court. In fact, my lord, 2016 or 17, we took a position of the property. They came before this honorable court. They, my lord, in multiple writ petition, my lord, that is 7 to 8 writ petition. Whenever I am putting property for auction, my lord, they used to come.
At least you file your objections in this. To know the facts.
Must have been, my lord, I filed it, my lord.
Where is it? Let's see.
On the day one. My lord, if my lords take, my lord, objection, I think it is not filed. I think green copy with me only. My lord, in one memo which I filed, my lord.
Where is that?
That dated, my lord, 13 November 2020.
There is no such memo in the file.
13 November 2024. Court seal is there, my lord.
Look at it. Where is it?
My objection, eh?
23rd November.
Memo. My lord,
23rd.
23rd November 2024, correct.
23rd November 25.
24. My lord.
You have a copy?
Yes, ma'am.
Passed on.
I served a copy to the state. They are also having. My lord, objection not filed. Objection not filed.
Well, the difficulty of the court is facts or not on record.
I understand, my lord. May make one, my lord. I'll place it today itself, my lord, after making one note.
Please give the facts.
And,
Without the facts, how
I'm
can?
so sorry. I apologize.
This is matter day after tomorrow.
Grateful.
Number 10. 10 pass over. Mukesh S. Katare.
I appear for the petitioner.
Mukesh Kumar.
Appear for
Yes.
respondent, my lord.
You were relying on some judgment.
Yes, my lord. This is. Please.
Yes. Which paragraph?
It is page 331 of the judgment, my lord. F. And all the points have been covered, especially pertaining to
Yes, yes.
125 and HMA Act and also DV Act, my lord.
331,
my lord. Here the question before the honorable court raised, the interim of
relevant, whatever is relevant to your case, that you please come to. Which paragraph? This is the head note which you are referring.
Yes, ma'am. Para
Come
80,
to that relevant page.
80 to 83, 90 to 95.
Para 82.
Para 80 to 83, my lord. 80 to 83, my lord.
80 to 83. Please read. Yes.
On the other hand, the financial capacity of the husband is actual income, reasonable expenses for his own maintenance and dependent family members whom he obliged to maintain under the law. Liabilities, if any, would be required to be taken into consideration to arrive at the proper appropriate quantum of maintenance to be paid.
We are not on that point. We are not on that point.
Because here there are three petitions are pending, my lord. I have filed the 125 CRPC.
No, here we are on the point. When you file an MC in the year so and so, and you file an IA 3 years later,
yes,
whether the maintenance will be paid from the date of the IA or from the date of your MC?
Petition,
That's a
petition.
simple question.
Yes.
Where is it answered in this
Because
judgment?
they have filed another writ petition. Another writ petition is pending before this honorable court, my lord. That is.
That's why he is seeking review. First of all, on
there are-
that aspect, you please
No,
point
there are
out.
two writ petitions, my lord, arose out of same cause of action. And earlier, my lord has insisted to tag this RP petition along with the writ petition number
That I'll hear,
24806.
that on the other day, the matter is, review is only on that ground.
No, no,
For
because,
that you have to
because
show.
the writ petition also same ground, my lord, another petition. 24806 for 24.
What is the ground?
There's also, they have sought same from the date of
So
petition.
please, you clarify that from this judgment, where the judgment said that you are entitled from the date of the MC.
Yes.
Where is that?
Because by filing this review petition, one CMS appeal is pending before the district court Hassan, my lord. That is 125 CRPC has been disposed. They are not paid maintenance from 10 years, my lord. 1 rupee they have not paid. And it was from the date of petition till the date of, from the date of petition, they should pay the maintenance, my lord. And they are seeking, showing this RP petition before the first appellate court Hassan, and they're telling that we are, this matter has to be concluded. Because this fact is different, that fact is different, madam. Because they're trying to take the shelter.
Whatever are the facts, I'm only asking you one legal question that you answer. Remaining, I will dictate the order.
Well,
On that I have explained this.
that also should be clarified, my lord. Because,
I'll clarify. First you tell this.
because otherwise this order,
Review is filed by him, not by you.
I agree, but because review after lapse of 300 days they have filed, my lord.
So,
And also they have filed writ petition 24806 on 24.
so I have to presume that there is nothing in this judgment to deal with that.
No, no, it is there.
Can you please come to that? Please don't waste the
Here.
court's time. Straight away come to the paragraph. Only that you point out, not other things. Where is this? Where is the paragraph?
The maintenance, the 81, my lord, a careful and just balance must be drawn between all relevant factors. The test of determination of maintenance in matrimonial disputes depends on the financial status of the respondent and standard of living that the applicant was accustomed to his matrimonial home. The maintenance amount awarded must be reasonable and realistic and avoid either of the two extremes. The maintenance award to the wife should be neither so be extravagant, which becomes oppressive and unbearable for the respondent, nor it should be so meager that drives the wife in penury. The sufficiency of the quantum has to be adjusted so that wife is able to maintain herself at reasonable comfort. Section 23 of HMA Act provides statutory guidance with respect to the criteria for determining quantum of maintenance. Section 23 of Hindu Adoption and Maintenance Act providing the following factors which may be taken into consideration: position and status of the parties, reasonable wants of the claimant. If the petitioner is living separately, the justification for the same, value of the claimant's
I think you are wasting the court's time.
because here
Where is that question answered? Why can't you come to that paragraph?
just a minute. Here regarding maintenance is concerned, here there is no judgment to tell it should be paid from the date of application.
That's
If
why
I may make-
that's why I'm saying.
If I may make one submission, my lord.
Yes.
Of the same judgment at paragraph number 111 and 113, the
100?
question 11 and 113, which is at internal page 379.
Yes.
The question of from when maintenance is liable to be paid has been adjudicated.
You also read and point out.
At paragraph 111, the rationale of granting maintenance from the date of application find its roots in the object of enacting maintenance legislations, so as to enable the wife to overcome the financial crunch which occurs on separation from the husband. Financial constraints of a dependent spouse hamper their capacity to be effectively represented before the court. In order to prevent a dependent from being reduced to destitution, it is necessary that maintenance is awarded from the date on which the application for interim maintenance is filed before the court.
The present.
Here one submission, ma'am, because another petition connected to same is there. It may be heard both. I'm ready to argue for that.
My lord, that the other petition.
So does this court have a roster to hear the other matter?
Because earlier it was connected to that matter. This on.
No, it is not. Only RP is before me. I'll pass orders on RP. You argue it before the other court.
But because one submission, my lord, here, this order should not affect my 125 CRPC.
It will, whatever is the law, that
Because,
would affect.
because that is order from the date of petition, my lord.
Hmm?
They have, the trial court has ordered maintenance from date of petition for me, and they are not paid from 10 years.
No, criminal miscellaneous is a different aspect. That is only filed for maintenance. isn't it?
Yes, ma'am.
So how will this affect your right?
Because there they are submitting like that way that RP is pending. And appeal has been appeal is pending there, my lord. And they are not trying to.
We should all talk like.
Please, please. Ma'am.
As a legal professional, you can't, what the parties or all say, that's not the concern of the court. Now, criminal miscellaneous is only filed for maintenance.
Yes.
So that will relate back to the petition date, final. Interim order will relate back to the interim
Yes, ma'am.
maintenance
Yes, ma'am.
application. Now, in a MC which is filed for divorce, when the IA is filed for maintenance, accordingly it will be. How it will have an impact on that case?
Because their ground of appeal is that only, my lord. In that case.
I'm sorry, the present petition is filed, seeking review of the order dated 19th July 2024. When counsel appearing for the petitioner submits that this court has disposed of the writ petition, directing the husband to pay the maintenance within 1 week from the date of receipt of the copy of the order. No, the court has passed an order on 19 July 2024, wherein directed the wife to file the details of the amount that is received by her within 1 week from the date of receipt of the order, and the husband, if at all, wants to file any objection, he shall file the same within 1 week from thereon. If the arrears are cleared by the husband, MC shall be disposed of within a period of 2 months from the date accordingly the writ petition is disposed of. This is the writ petition.
Yes.
When counsel appearing for the petitioner submits that the MC is filed in the year
2016, ma'am.
2016 and the IA for maintenance is filed on
23.
2023. January 2023.
January 2023. It is submitted that now as the order earlier passed by this court is silent with regard to the date from which the wife is entitled to maintenance. Now it is calculated from the date of filing of the MC. It is submitted that in the light of the settled law, the interim maintenance will be granted from the date of filing of the application, but not from the date of filing of the maintenance case. When counsel appearing for the respondent submits that the wife had filed a criminal petition seeking maintenance, and from the last 10 years, they have not paid any maintenance. It is submitted that if any order is passed in this case, it would have an impact in the other case, where in that case, the court has ordered maintenance from the date of petition. If any order, any view is taken by this court, it is going to have an impact on the recovery proceedings in the execution.
Already recovery is pending. Huh? Recovery is pending.
Recovery proceedings. Next, having heard the counsels on either side, what is the material on record? This court has not interfered with the order of maintenance passed by the court, but it is true that it is not mentioned from which date the wife is entitled for maintenance. When the MC is filed in the year 2016 and the wife files an IA in the year 2023, she is entitled for maintenance from the date of application, not from the date of the MC that is filed by the husband. This clarification, as the order does not contain so in the considered opinion of the court, that clarification is required in the order. Accordingly, the order dated dated 19 July 2024, it is clarified that the amount of maintenance is from the date of application filed by the wife seeking maintenance, but not from the date of not from the date the MC is filed.
One observation, my lord. Another petition is pending 24806. They have questioned same point in that case also.
Then it will be allowed. That also will be allowed.
They are told that we have no income at all. We are unable to pay any money.
That's false.
Next.
Much obliged.
Pertaining to CMI's recovery is concerned, my lord.
That is, whatever is the law, court will know.
Cell number 20.
Yes, 20.
In person.
My lord, memo is being filed. My lord. My lord, the petitioner has preferred to challenge the section 14 order, and my lord, the respondent number 2.
Form C not yet issued to him, to the party in person. Where is he? Was he there in the morning?
Yes, my lord. The copy is also served to him. Since the writ petition.
This is matter after vacation, no representative.
My lord, writ petition has become infructuous, my lord.
Anyway, he's not there.
Obliged, my lord. My lord, this memo may kindly be taken on record. Please. Obliged, my lord.
Yes.
Cell number 21. 21.
My lords, I have a copy of the DD.
Take that.
Your lordship may verify it with the order sheet where the handing over of the DD was countersigned. The DD number is also mentioned.
Where is that order?
My lords, it's in the order sheet,
No,
my lords.
the last time I dictated the order. Where is the draft?
My lords, my only request is tomorrow if they bring the DD in the name of this entity, then I will withdraw the writ petition, my lords.
The
My lord, my lord, if there's an order, we'll transfer, we'll bring DD in name of this. They have given a memo by name Kia Homes RERA designated account. If there's an order of this court, my lords, it would be convenient.
My lords, today your lordships can pass an interim order directing them to bring the DD in the name of this entity. Tomorrow if they bring the DD,
How many times this matter will come?
my lords, my learned friend is
dispose
not.
it of directing them to.
My lords, my learned friend is not cooperating. My lords, he gives us the DD, he doesn't take the details. Today he objects. Today he could have brought the DD in the
petitioner
afternoon.
has, as per the order passed by this court, had given a DD for an amount of rupees 10 crores 53 lakhs, 53 lakhs, and the said amount is drawn. Where are the details?
My lords, your lordships will find below the name Kia Homes RERA designated account.
This DD is.
We've also got a memo, my lords.
This DD is given in the
We've
name of
shared this
Kia Homes RERA. What is this? Kia Homes. Kia Homes.
My lords, I have the details.
We've already served that same memo on the other side.
Take that.
It's this one. Details are mentioned in that.
Kia Homes, KEYA, Homes RERA designated account for TGE. Account number 502 00091591761 HDFC Bank. The land counsel for the bank submits that they will issue the DD in the name of the petitioner.
My lords, in this name, my lords, in this Kia Homes.
That's its submission.
Very well. I'm sorry.
The
No, my
land
lord,
counsel.
in the name of this. Obliged,
He
obliged,
said
I'm obliged.
My lords,
I'll issue in the name of.
recommend.
It is submitted that the respondent that they will issue the DD in the name of the petitioner. When at the time of as per the interim order passed by the court, a DD is given to the bank for an amount of rupees 10,53,000
10 crore
in the name of the Kia, the Kia Home so and so. In view of the same, the respondent bank shall return the amount by way of a DD or oblique by account transfer to Kia Homes RERA, the same, whatever is the details just now dictated in the name of so and so, immediately, accordingly, the petition is disposed of.
My lords, your lordships may
Giving
keep.
liberty to the petitioner. They are giving liberty to the petitioner to avail the appropriate. Already, everything is there. Only this paragraph now I have dictated. You incorporated it. It
My
is
lords,
done.
tomorrow if he brings, I'll withdraw the writ, my lords.
No, they will. Why?
My lords,
why
I'm
again
concerned,
tomorrow?
my lords, they may not, your lordships have said immediately, they'll say there's no timeline, this, that, my lords, I'm in a difficulty. Your lordship may have it tomorrow, my lords.
We'll do it by tomorrow. Maximum we'll do by tomorrow morning. We'll try to do it today itself.
I understand, my
How
lords.
many times we will hear the matter?
My lords, your lordships may indulge me, my lords, because tomorrow if I have to file a contempt, they'll say this order is vague. I'm stuck with this.
They have got the DD today itself. So why not they do it tomorrow?
My lords, they can do it tomorrow. I'm only requesting the matter to be called tomorrow, so that the DD can be handed over in the presence of the court.
Yes.
Obliged, my lord, no problem. Obliged. We'll
Tomorrow,
absolutely.
tomorrow, whatever it is, I'm going to dispose it off. Yes.
Please, my lords, I'm deeply.
Yes, next.
Cell number 23.
Yes.
Cell number 23. 22. No?
What is this?
23.
Caste certificate.
Huh?
Issuance of caste certificate.
Oh.
Last time lordships heard that they have made a irregular, unnecessary parties and.
Issue shall address arguments on the maintainability on the next date of hearing. No representation for dismissal tomorrow. Yes.
Cell number 20. 36. Cell number 36.
Yes.
Small inconvenience, my lord. Senior is held up in another court. Senior is held up in another court.
How many times you will ask adjournment?
Next week, any date, my lord.
No, they should be reasonable in asking adjournments also. How many times the court will adjourn the matters? This is matter after vacation.
Grateful.
Yes, next.
Cell number 40.
40, I am appearing for the petitioner.
You called 36 now.
Oh, 40. Next pass over.
I'm sorry, mother. Next week, mother. I'm today inconvenience.
Give the fine.
And tomorrow, mother. At least tomorrow, mother. Some other.
Why?
Tomorrow I will. I'm sorry, mother. Tomorrow, mother.
Why tomorrow?
If today is a personal inconvenience, mother.
To whom?
Myself, mother.
You're here in the court.
Please, mother. But
It will take only 5 minutes. We'll send you. Argue the matter.
Last time the contention was that work.
on 23/2022, mother.
Yes.
Tender notification has been issued, mother.
Yes.
And 6/9/22, mother. The petitioner has participated in the tender, mother.
Yes.
And on 6/9/22, he has made deposit, mother. The initial deposit 2,10,000, mother. And 19/9/2022, the tender was allotted to the petitioner as a highest bidder, mother. And accordingly, he has made
That is
deposit.
for how many years?
That 5 years, mother. 5 years, mother. On 21/22, first that 21/22, 26, 27 is the last, mother. And he make deposit rupees 10,46,804, mother. After depositing the amount, mother, the respondent has not issued any work order to carry the fishing work, mother. Not issued any work order, mother. And subsequently, mother, in the as per the annexure D, your lordship may kindly see. I produce the annexure D at page number. That renewal notice has been issued subsequent year, mother. 23/24 to issue renewal notice to make deposit 13 lakh, mother. Without issuing the work order, mother, this petitioner can't able to renewal that subsequent year, mother. They have not issued any work order, mother.
So.
And also subsequent years they have not.
Are you exercising the fishing rights that are granted to you or not? Is the question I asked.
I am exercising, mother, but.
No, you will exercise the fishing. You will exercise the rights as per the tender conditions.
Please,
now on one pretext you come to the court, and when is the order, interim order you will enjoy from 2023 without
Interim
paying
order
any
is
amount.
enjoyed only in so far as the annexure D is concerned, mother.
Where is annexure D? Come to that.
Annexure D, your lordship may kindly page 22, mother.
Yes.
That may I read, mother? It is in Kannada version, mother.
Read.
ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತುಮಕೂರು ಜಿಲ್ಲೆಯ ತುಮಕೂರು ತಾಲೂಕಿನ ಸೋ ಅಂಡ್ ಸೋ ವಿಲೇಜ್ ಮೀನು ಪಾಸುವಾರು ಹಕ್ಕನ್ನು ಉಲ್ಲೇಖಿಸಿ so and so that they have issued renewal notice for the period of 23/24. Your lordship may kindly see top of the period, mother. That 21/22 tender was allotted, mother. First year, mother. 21/22 for the.
Not able to understand what is the top.
What happened, mother? Tender period is for period of 5 years, mother. That 21/22 is the first year, mother. First year that tender was allotted, mother. For period of 5 years, out of that 21/22 is the first year, mother. That was the highest bidder and tender was allotted to the petitioner, mother. It is continue 5 years, mother. So 21/22 after depositing the amount, mother, 10 lakh so and so, they have bound on duty to issue work order to carry out the fishing work more that. But they have not issued any work order more that. Without issuing the work order, subsequent year they have issued notice to the renewal or 23, 24. I am not carrying the work more that. Till today they have not issued more that. Yesterday I will,
Let me understand the facts.
that yesterday I will give one representation more that.
If the work order is not issued, he continue to enjoy his fisher rights, first aspect. Insofar as the contention is that work order is not issued, I'm placing the work order which was issued way back in 2023. And he says that he's only enjoying the interim order only in respect of Annex D, that it's completely wrong because he has not paid the fees, renewal fees of 2023, 24, 24, 25, 25, 26. There is almost 15, 16 lakhs rupees that he has to owe us. He has to pay though the period was for 5 years, he did not pay a single rupee. Till today he is enjoying, just because there is an interim order in respect of Annex D, he continued to not to pay any amount.
Look at it. Look at that. What is that?
Today I will issue more that. Tomorrow more that I will get inspection. So far as the work order is concerned.
Is this matter
Tomorrow.
as first matter tomorrow?
Tomorrow, madam.
Tomorrow is the first matter.
Please, madam.
Sagar V. Shastri for petitioner. Shivakumar.
Yes.
Hearing for petitioner, Your Lordship. Lordship, the petitioner has been owning the land of survey number 245 and 245, so on, mentioned in the petition, Your Lordship. But after that, there was a notification in the year 1968, Your Lordship, that land survey
Crashing
number.
the proceedings initiated by respondent number 3. Who is respondent number 3? Estate officer. Who represents the estate officer?
Please, my lord. Oh, my lord, this.
Where is Mr. Shivkumar?
My lord, am I audible, my lord? I am online, my lord.
Yes.
I am representing the estate officer, my lord.
What is under challenge is that, my lord, the proceedings initiated.
My lord, one submission, my lord. They have been just served the notice to appear before the estate officer, my lord. So they should produce all these documents what they rely upon before the estate officer for adjudication. Instead of appearing before the estate officer, they have preferred the writ petition.
What is the impugned order?
Lord, they have issued a show cause notice. We have challenged the entire proceedings under the Public Premises Act on sole ground that I am not an unauthorized occupant.
No, all these contentions they can raise before the estate officer, my lord.
No, my lord.
Oh, why can't you submit? Submit to the respondent? Why should you come to this court?
No, my lord. I was under the threat of dispossession at the moment. Well,
Now you are not.
My lord, by virtue of interim order, my lord.
From the last 2 years enjoying the interim
Please,
order, and
I
nothing is going to any logical end. Go to the
60 years back.
Whatever it is, let them decide.
Acquisition took place is what they say. After that, my lord, they have not taken physical possession to this date.
No, any order is passed by the estate officer.
There is no order passed as of now, my lord.
They will pass. They consider all this. There is no point in keeping the writ petition pending.
I've sought for prohibition, not.
What prohibition?
Lord, after lapse of 60 years.
How a writ of prohibition lies, you tell
Lord,
me?
because, my lord, after.
No, first of all, on the ground, this writ petition should be dismissed.
That's
When a writ of prohibition will
that's
lie.
only an alternative prayer. So, that's a second prayer. What I essentially.
Alternatively also, when a writ of prohibition lies.
My lord.
A show cause notice, is it an order of any judicial order or a quasi judicial order?
Lord,
that a writ of prohibition will lie.
This estate officer is from the railways, Southern Railways. So.
You can't file a writ petition like this.
No, my lord, after 60 long years, they cannot dispose.
Whatever it is, let them decide.
May make this submission.
Will this court decide all that? When are you in position? What is he doing?
May make this submission, my lord. Until there is a decision, my lord, my possession may be protected.
Yes, Mr.
My lord, my lord, when the proceeding is before the estate officer, we will not take any action, my lord.
Yes.
We will not precipitate the issue.
Petition is filed. Seeking the following prayer. Because you are seeking prohibition, it becomes a writ of prohibition. The writ petition is fetching the following prayer. The case of the petition, that petition and his brothers are the owners of the land in survey number 245/1, 245/2, and 243/2 of Maluru Town, Kasaba Hobli, Kolar District, total measuring 1 acre 17 guntas. It is a case that the property was purchased with the father of the petitioner from one Sita Ramaya by registered sale deed dated 16 to 1962. And also it is stated that how the flow of tide and how the vendor has purchased the property. The name of the petitioner father is mutated in the revenue records. Later, the father died on 18/8/2015 intestate. The land devolved upon the petitioner and his brothers. It is stated that the government of Mysore issued a notification dated 31/10/1968 stating that the lands in the schedule, which includes survey number 245, was likely to be needed for public purpose for formation of approach road to railway overbridge under section 582 and 1A capital A within brackets small a of the Land Acquisition Act 1894 as amended by Mysore Act 17 of 1951. However, no action or development had taken place. The petitioner's family is in continuous possession of the land for more than 60 years and they have been cultivating mint leaves and other vegetables all along. While this being so, the respondent number 3 initiated the proceedings under section 4 of the Public Premises Act 1971 that the land in question is treated as unauthorized occupation and hence called upon the petitioner to show cause as to why eviction should not be initiated. It is stated that on receipt of the said notice, the petitioner has filed his detailed objection along with the documents on 2/8/2024. However, respondent number 3 have not issued any endorsement or reply to the said objections. Hence, the petitioner, as there is a threat of dispersion, petitioner has come before this court by filing the incident writ petition. A coordinate bench of this court a coordinate bench of this court on 1/10/2024 has granted an interim order as prayed for till the next date of hearing. That interim order has continued from time to time, is extended from time to time. Land counsel appearing for the petitioner submits that the petitioners have purchased a property by way of, the petitioner's father has purchased a property by way of a registered seal deed, and ever since they have been in possession of the property. And the respondents have no authority jurisdiction to issue a show cause notice stating that under the Public Premises Act, it is submitted that when the respondents have tried to dispossess the petitioner, petitioner is constrained to approach this court, and the petitioner has argued, has submitted on the merits of the matter. The land counsel appearing for the respondent submits that it's a show cause notice and it's always open to the petitioner to reply to the same. And after considering the petitioner's reply and all the relevant documents, they will pass appropriate orders. It is a premature writ petition, and on a show cause notice, the present writ petition cannot be entertained. It is further submitted that as long as the proceedings are pending before the respondents until they pass a final order, they will not interfere with the position of the petitioners. Next para. Having got the counsels on either side, there is a material on record. When the proceedings that are impugned before this court, the proceeding impugned before this court is a show cause notice. When a show cause notice is issued to the petitioner ought to have replied to the same. And if any order is passed for the respondents, they could have assigned the same before this court. As rightly argued by the learned counsel for the respondent, the writ petition is a premature writ petition, and the same cannot be entertained. The petitioner has sought for a writ of prohibition. A writ of prohibition do not lie, and the prayer as sought for by the petitioner cannot be granted. Next part. Considering the fact that this is a show cause notice, protecting the interests of the petitioner, as it is submitted that they will not be taking any further steps till the final order is passed. This court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to submit his reply to the show cause notice dated so and so, and the respondent shall pass orders in accordance with law. Number 2, till an order is passed for the respondents, no coercive steps shall be taken.
Number 43,
Much obliged, my lord.
Rajendra MA.
40.
Petition also, 43, my lord.
What is this?
Section 14 order, my lord, assailed. My lord, order, my lord, at my lord, page number 13, passed in the year of 2022, wherein they filed this present writ petition in the year of 2025.
So there is one more petition.
That, my lord, nothing to do with, my lord, my secretary is concerned, my lord.
Some tag this petition along with 5349.
That is correct. That is, my lord, there's some my lord, assignment agreement is challenged. And my lord, maybe.
He is the borrower.
He's a borrower.
The present writ petition is filed, seeking the following prayer. The petitioner has an effective alternate remedy before the DRT, and he cannot come before this court. No grounds are urged seeking interference of this court. In that view of the matter, this court is.
There's an interim order in this.
The writ petition is disposed of, giving liberty to avail the appropriate remedy before the DRT. He shall have the benefit of section 14 of the Limitation Act. Yes, next.
Cell number 44, Sridhar K. S. Lakshmi Narayan.
Lordship, this matter I will raise time for a week, my lordship. My lordship, senior is not there, my lordship. He had been for the medical.
Even
checkup.
if your senior comes, it is not going to make any difference because no arguments. This is a private financial company. Where is this? 44. Pyramid Capital Housing Finance. The writ petition is filed against so and so. Which is a private finance company, and in the light of the law laid down in so and so, the writ petition against a private finance company is not maintainable. Accordingly, writ petition is disposed of, giving liberty. Same section 14. Suvarna, section 14 of the Limitation Act. Yes, next. No, which filed by whom? Not necessarily give it to him.
They have filed the objections. my lord.
Served the copy.
We are not taking the objections
Please.
on record. Yes.
Cell number 47.
Appearing for petitioner, my lords, I'm filing my memo for withdrawal.
Take that.
My lords, liberty may be granted to approach DRT.
Memo is filed seeking to withdraw the writ petition to avail the appropriate remedy before the DRT. The memo is taken on record. This is withdrawn. Section 14.
Great.
Yes, next.
Cell number 51. 51. Arun Govindraj.
Madam.
Reshma K.
Yes. Have you seen those medical records? It's saying that he's not able to walk, talk.
Lordship, it would be a medical phenomenon if somebody is getting 3 stents in 1 month, back to back. I've never heard of that at all. So I think it's quite unbelievable. And we asked our own sources in Bombay to verify, and I've told that he's absolutely fine. So, Your Lordship, this is again another, and I'm told, Your Lordship, that the husband is not the main, he would much rather pay, but it's the father. The father has taken it as a challenge that I will not pay her, I will drag it in court however long. It's only when warrants are issued that they want to come
The
rushing.
petitioner's father has disowned him. He has absolutely no way. Point is, now my learned friend says that such a thing can't happen in medicine. I don't know. I placed these records before your lordship. maybe my knowledge of medicine doesn't extend to that. Yes. All I'm saying is, my lord, I'm just looking at it very pragmatically, my lord. Okay, I defaulted. Mistake. I'm not even discounting. Instead of 10, I paid 15. But by putting him behind bars, what's going to happen is, as it is, he's trying to pull together. We'll try and possibly try and settle the matter. If it is the daughter's future,
No, why not instead of keeping it pending, let me pass order finally.
Please.
Whatever you want to
Please,
do,
please.
you can do.
Please, please, please.
Yes. This
Yes,
is
only on this issue which they have raised, the technical aspect that above 18, once she crosses 18 under 125, it's not possible. Supreme Court judgment very clearly
I've
goes
said
on
the other
that.
day.
Please.
Because instead of filing an application again under the Guardianship and Works Act,
Correct.
the same can be granted.
No, and it's a 3-bench judgment of Supreme Court which says we have to interpret it as to which are the provisions that give in Hindu marriage or even under Muslim Divorce Act.
All are before the family courts.
Yes, and in fact, Supreme Court says there needn't be multiplicity of proceedings, so they don't touch that order. And in this matter, everything is over, all done, Your Lordship.
No, what I'll do is I'll pass orders on this
Please,
matters.
please.
When do you want? When?
Leave it to your lordship.
We'll have it on 24th.
Very well, my lord. But the warrant, maybe at least I can go to some place where I can get treatment.
That is.
More stents.
My lord, one more submission
I have
is,
stated, I have already said that I'll not interfere with that. Or if you want, I can give a shot today. But no, I will not give again that order of not to take any coercive steps. I can take it up on 16th.
I'll leave it to your lordship.
16th.
16th, Your Lordship.
16th.
Please.
This matter on 16th.
Obliged.
Cell number 52. 52, Shruti P.
I'm for the respondent number 2, 52.
What is the maintenance and welfare of parents? Where is the petitioner?
Time may be given.
You are not represented on the
Yes,
last
yes,
occasion?
yes.
No, he is not there today. No representation for the petitioner. This is matter for discussion tomorrow.
Number 53. 53. Siri R.
May I seek a short passover minute? Senior is on his legs. We'll address arguments today. We're ready. Short passover.
Unfortunately, this matter is undergoing so many adjournments.
I completely understand. On the last date of hearing, I came on record.
Not only last, like it is going on like this.
I bow down to my lord.
Times he has taken
He's
it
on his legs. We'll address arguments today. I've filed my.
So what I do is after I'll take it up at the end of the list.
Please, ma'am. End of the list.
If your senior is not there, then also I'll hear them on pass on.
Please, ma'am. Otherwise, I will address arguments.
Yes.
Please.
Yes.
54. Amendment Indian for
Give that
petitioner.
file. The writ petition is filed, questioning the is filed, seeking a writ of mandamus directing the DRT to consider the application and exure D pending before the DRT. This writ petition is filed in the year 2021. An interim order was granted on 16/12/2021. Thereafter, on 22/2025, though the matter was called twice, there is no representation on behalf of the petitioner. On 18/3/2026, a retirement memo filed by the council is allowed, as The notice is served on the party on 14/3/2026. The matter was directed to be listed on 7/4/2026. 7/4/2026, when the matter is placed, when the matter came up, there is no representation. Hence, the matter was directed to be listed and the caption dismissal. Today also, there is no representation. Accordingly, the writ petition is dismissed for non-prosecution.
55, Saraswati for petitioner.
I'm appealing for the respondent in this case, my lord. Yesterday also I have made a submission, my lord, that they have given a requisition for the refund, then they have filed petition here seeking for a flat possession, my lord. They have given a requisition before the respondent number 2 seeking refund of the money. Then they have come before this honorable court seeking the possession of the flat. It may be dismissed, my lord. And here they are not.
The petition is of the year 2022. This is filed seeking the following prayer. What is the representation to you?
They have not given any representation
For
to me,
saying
my
this
lord.
one,
In
you
my
said so.
statement of objection, my lord, page number 7, they have given a representation, refund of the money.
Then there is no representation. This matter, when it is filed in 2022, it has come up only on 2 occasions. One on 6/4/2026 and the other on 7/4/2026. On both the occasions, there was no representation, and the matter was directed to be listed under the caption for dismissal. Today also, there is no representation. When counsel appearing for the respondent submits that before the respondents, they have given a representation that the amount shall be refunded when it comes to the writ petition. The prayer is for possession of the property. The this petition without even being listed from 2022 is pending till 2026. It appears that the petition is not interested to pursue the matter, accordingly dismissed for non-prosecution. Yes.
Second matter, connected matter also same, my lord.
55 also same.
Same, my lord.
One.
There are 2 matters, my lord.
Yes.
2 matter also, my lord, the same issue.
Cell number 56.
Look at it, 55.1, the dates that have come up, same dates or not.
Cell number
Separate order you read, but 55.1, when they have come up before the court, see the dates. Yes, 56.
Cell number 56. Madhukeshwar, Rajivar.
The writ petition is filed against Aptus Value Housing Finance Limited, which is a private financial company, private finance company, and the writ petition does not lie against the same in the light of the law laid in Vishwabharati. When the matter came up on 7/4/2026, there is no representation. As the matter is listed today for dismissal, today also, there is no representation. In the light of the law laid down in so and so, the writ petition before this court is not maintainable. Accordingly, dismissed. Accordingly, the petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Don't say about section 14.
Cell number 57. Harish MD. Cell number 57.
This is a repetition of 2022. And so far, the notice is all not served on the respondent as the petitioner has failed to pay the process. The matter came up before the court on 7/4/2026 and there was no representation on behalf of the petitioner. An interim order was granted on 19/5/2022. As the petitioner has failed to come up has failed to represent before the court, the matter was directed to be listed in the caption for dismissal. Today also, there is no representation. The writ petition is filed seeking a prayer to stop the process of taking possession of the petitioner's property and sale the same by holding e-auction on 25/2022. When the bank has issued a e-auction notice, the remedy available to the petitioner is before the DRT, but not before this court. Considering the same, the writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy. And this also, no section 14.
Cell number 58, Vikas M.
The petition is filed in the year 2022. There is no interim order in this writ petition. And the matter came up on 18/3, no representation saying this was for non-prosecution.
Cell number 59. 59.
What about this?
Aditya Ji.
This is regarding seeking mandamus for them to redeposit the pre-deposit in the tender matter. That is not permissible. That no, but there was an interim order of this honorable court where they were supposed to collect, there was a direction dated 8/11/2022, my lord. May I permit you to read that? Third learned senior counsel so and so, so and so. The petitioner is before this court seeking direction to respond number 2, permit him to re-deposit the bid amount which was not deposited on account of
What
certain.
happened after this interim order?
After this interim order, whether they had approached or not, my instruction is that, my lord, it is not permissible in lieu of 12(1) of the KTTP rules. Once the bid.
True, but what happened after this? You have to comply with the order, isn't it?
No, they did not come forward.
That's what I'm asking. They have not come forward.
My instruction is they are not come forward.
Get specific instructions on
Section. Yes, my lord.
tomorrow,
Not tomorrow, Friday.
Thursday. Yes, list on Thursday. Yes, 16?
My lord, tomorrow is Thursday.
No, next
Next.
Thursday.
Next.
Yes.
In full. Cell number 60.
60.
Yes.
First, my sincere apology, I have not been present yesterday. But you kindly see the order dated 9/3, Lordship. There is direction to file objection to the respondent.
My
They have
lord,
not filed it, Lordship. Order dated 9/3. The issue that Lordship, the suo moto,
Then counsel for respondent number 1 and 2 shall file their objections and place the same and shall serve the copy of the same in advance.
This is pursuance of the judgment. Whether it's conduct of rights, they are claiming a compensation where they have lost certain properties in the rights. I have received certain instructions that is in bulky. I'll place it before your lordship by next week, my lord.
This is matter also on Thursday.
Thereafter only your lordship can direct it because.
we are not seeking any compensation. My learned friend is making wrong submissions. We are seeking a directions as per the suo moto, as per the judgment of Honorable Apex Court. The Honorable High Court has to take a suo moto action to ascertain the damages caused during
Ultimately,
the
what
political rally.
compensation only.
Then it has to be recovered from the.
Let him get it.
So, my lord, we have also respond number 1, my
This
lord.
is matter on 23rd.
Obliged.
By that time, both the respondent 1 and 2 shall file their objection and shall be served on the counsel for the petitioner in advance.
Yes.
Obliged.
Number 61. 61, X Suresh.
Seeking 1 week's time for complaints of office subjections.
Hmm?
Seeking time for 1 week for complaints of office subsection.
2023 writ petition, we have to
Remaining 2 writ petition is also same filing pending. my lord.
hear. First we'll hear this, then we'll to consider the representation as per annexure M and N and thereby issue pass
Yes.
certificate.
Yes.
What is this? It has come up earlier.
No, he has not come.
No, it has come up before me, I remember.
Before your lordship come up, not in terms of others.
No, before me.
It has come up. It has come up.
What is this representation?
Only 1 week time.
No, that. What
Caste
is this?
certificate cannot be issued based on the representations, my lord. And he has not served the copy also, notice also not at order from 2022.
Let him approach the respondent.
Yes, my lord.
The present writ petition is filed. Seeing the following prayer. Is a case of the petitioner that petitions of the residents of Majra, Tatanahalli, Ramalingapura village, Margon Deep Post, Kasaba Hogli. The petitioner had studied primary at the said village and studied 6th standard at Tatanahalli. And my wife is uneducated and the children are studying now. Petitioner, who had learnt the sign and also read and write in Kannada, filed an application to the headmaster lower primary school to issue documents pertaining to school. And the school had issued fee receipt and admission extract dated 2/8/2021, which reflects the caste as Dasari in the said certificate. It is stated that for all practical purposes, the petitioner requires a caste certificate. The petitioner filed an application before the third respondent, Tehsildar, at Bangarpet to issue the caste certificate. He has filed the said applications were rejected, stating that the documents so produced along with the application do not have a valid and relevant proof to show that their caste is Dasari. Hence, the said applications cannot be considered for issue of caste certificate as sought for by the petitioner. This should have been questioned, that rejection.
No, yes, I do.
That is 5/3/2022.
Notice also not issued, copy also not served. I don't have anything even to say.
Where is this 5/3/2022? Annexure D, E, F. Come to that. What kind of petition you have filed?
Milord, annexure.
He has not passed any order.
Annexure, Milord.
D.
D is only an application.
No, some endorsement is there on that.
That they have received the application.
That's what it reads.
Yes, Milord.
No, this is what is endorsement on that. Something is written. What is this?
This is a form, Milord. Namune B is a form.
It's an endorsement.
Milord, their caste is comes under class 1, and his caste in the school certificate is different than the application what he has sought.
You don't find that endorsement on an exhibit?
It is there. Milord, his caste certificate. The caste which is mentioned in the school certificate is different than the what he is seeking now. That cannot be.
No, is it an order?
It is only endorsement. He should have challenged it before the district caste verification committee under 4A of the scheduled caste and scheduled tribes.
Is there any? What is the limitation for that? Any limitation for that?
Oh, sir, 30 days.
Let him question it.
Let him question, Milord.
Do that. And he wants adjournment for this. What he says applications are kept in abeyance.
No, it was not kept in abeyance. It says that it cannot be. ಆದ್ದರಿಂದ ಅರ್ಜಿದಾರರು ಕೋರಿರುವಂತೆ ಕ್ರಮವಹಿಸಲು ರಹ ಇಲ್ಲದ ಕಾರಣ ಕಡತ ವಿಲೇ ಮಾಡಬಹುದು.
Had not taken any action. Hence, the petitioner submitted the representation to the second respondent, Deputy Commissioner. And by letter dated 9/6/2021, had directed the third respondent to verify and issue caste certificate. Annexure G.
Annexure G is the Deputy Commissioner letter as addressed to Tahsildar.
Saying what?
Saying what to issue caste certificate, considering the papers.
Then let me ask him to do it.
Tahsildar may be directed.
I directed the third respondent, Tehsildar, to verify and issue caste certificate as Dasari by letter. What is the sound? It is a grievance of the petitioner. In spite of the said communication, the Tehsildar has not considered the same, which made him to come before this court. What is, it is submitted that. Yes, Mr. AGA, you will consider it in accordance with law.
Yes, ma'am.
Then AGA appearing for the respondent submits that in the light of the letter dated 9/6/2021. Tehsildar is the third respondent.
Third respondent,
The
madam.
third respondent will consider the case of the petitioner in accordance with law. Accordingly, this court is passing the following order.
I take notice for R1 to 4.
R1 to?
Notice is not at order. I take notice.
AGA takes notice to?
1 to
Notice
4.
on behalf of?
R1 to R4, all respondents.
R1 to?
R4.
R4.
Yes, ma'am.
Next, accordingly disposed of, directing the third respondent to consider the case of the petitioner for issuance of caste certificate
In
the light of the letter dated 9/6/2021 within a period of
3 months.
within a period of 3 months from the date of receipt of the copy of the order. Yes, next.
62.
What are the other matters you said? What are the other matters?
Which is pending, madam.
Where are they?
Objections.
Filed a memo for moon.
What is that?
No, objections, he has need to comply. There are certain office objections still is coming on that note.
What are the other two numbers? Give the number to the court officer. List those matters next week or thereafter. I said already. Yes, next.
Cell number 63, 62. 62.
Yes.
Shashikant Prasad.
Section 14 order is under challenge minutes. The subject property is already sold in public auction. We have delivered the possession to the auction purchaser as well, minutes.
The writ petition is filed. Questioning the order passed by the magistrate under section 14 is a borrower
Please, minutes.
by the borrower,
Original borrower is no more, is the LR of the borrower.
LRs of the original borrower. Land counsel, there is no representation on behalf of the petitioner. And the matter was directly released on the last occasion and on 7/4/2026. And the matter was directly listed today on the caption dismissal. Today also there is no representation. The land counsel appearing for the bank submits that they have conducted the auction and they have given possession of the property to the auction purchaser. Sale certificate is also
Yes,
issued,
minutes.
and they have issued the sale certificate in view of the same. Now, nothing survives for consideration in this writ petition. The petitioner, hence the court is passing the following order. The writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy before the DRT if he is aggrieved with any action that is initiated by the respondent bank.
Cell number 63, Sangamay Sharpi. Is it received for respondent?
I beg to appear for the petition. Which I'm sorry, yesterday I could not appear, Milords, I was held up. Milords, this is a case where, Milords, the petitioner
What is the prayer?
Milords, the prayer is to set aside, to quash the
Order dated
Order passed by the-
1/5/2023. Let's go to that order.
1/5/2023, Milords. Annexure F, Milords. Annexure F is an order where my application to set aside the placing me as ex parte is rejected, Milords.
When were you placed ex parte?
Milords, the
10/9/2020, I believe.
may I read, Milords, Annexure F for a moment?
No, you can give the dates.
Yes, Milords.
When were you set ex parte?
Milords, 10/9/2020, Milords.
10/9?
2020.
When did you file this application?
Milords, 21/1/2022.
Where is that IA?
IA Lords will find it annexure E, my Lords.
Page number?
Page number 35, my Lords.
Let's see.
But even the service of notice that the
That's what
DRT
we'll
holds
read.
against me
What did you say we'll read?
is on the basis of a paper publication.
No, let's see it.
Yes. I, Srimati so-and-so, aged about para 2, may I read, my Lords? Page 36, my Lords. I submit that the applicant has filed the above case for recovery of alleged loan dues. That on the earlier
It is
date,
not that, it is not about notice. You have appeared. You have appeared before the tribunal.
I appeared, my Lords, and sought for setting aside of the
No,
place.
no, no. Before that, paragraph number 2.
Yes, my lords. Pleased to issue
Tribunal
summons
was
and
pleased to
I'm
issue the
fixing the
summons.
date for on the day due to my ill health, hence I was unable to
You are
represent.
aware, not that you are not aware.
But my service has been held sufficient on the basis that I was served on paper
You
publication.
have appeared before the court. That's what your own affidavit is
Yes,
saying.
yes, yes. On represent the case through the present
On the date
advocate
due to
on
my
behalf
health,
of me
I am
subsequently
unable to represent the case.
absence of my presence, this court tribunal placed ex parte. Further, our company is not doing any business and our
So,
in-house advocate.
you are aware of the case as on 10/9/2020. You are supposed to appear, you didn't appear.
May I
So
take your lordships?
why you have not appeared, you have not filed an application till 2022 for a period of more than 2 years?
I will take your lordships to the impugned order for a moment. How things have happened. Para 6, your lordships may kindly come. Page 39.
No, no, what is relevant is what the court has.
But all that I am
said.
seeking now, well, let me come to the point directly. All that I am seeking now is only an opportunity to defend myself. Because, my lords, for
Given to
this
you,
reason,
who will answer those 2 years? Thereafter.
those 2 years, my lords, I will
Another
explain.
3
I will
years.
explain. I will explain.
Total 5 years, who will answer?
It's that I will explain. My lords. All that I am saying.
Let's just stay in this.
Please, madam. From 2023 to till today, in fact, we adduced our evidence. Matter is supposed to be, my lord, argument, final argument, and posted for orders. That time, my lord, this honorable court passed an order. However, my lord, my limited submissions are this. One is, my lord, in fact, they are aware the proceedings pending before the DRT. Later, my lord, in fact, my lord, 1951 says within 30 days from the date of, my lord, I may permitted to read the, my lord, provision under the, my lord, under section 1951. The defendant shall within a period of 30 days from the date of service of summons present a written statement of the.
No, you have seen all that. Now what is to be done?
My lord, either, my lord, the order passed by the DRT has to
3
be.
years stay and then the bank is, have you moved any memo? Have you
In
filed your
fact, it's
objections?
a matter of fact, my lord, we moved some memo.
Then you no objections of that nature. So we'll impose some costs and we'll fix a time frame of 3 months.
I'm agreeable, my lords.
My lord, in
But
fact,
that's
I
the
led
way.
my evidence, everything, my lord. My lord, we adduced our evidence and, my lord, pleadings completed.
Whatever happened from the last
I'll leave it to Mr.
6 years, you are happy here.
But only thing is, my lord, it's a board shell, my lord, employed in
There are
the
so many
statute.
shell for you and for them also.
In fact,
We
lords,
have to read the shell is, was,
may I make one
as per the
submission?
situation.
May I make one more submission, lords? How the bank is at an advantage, even in this situation, lords. Lords, the liability as claimed to the bank is 1
You
crore
can't,
26 lakhs.
being not vigilant, you can't raise any.
I will stop here, my lords. I understand.
Yes, please come.
I'll stop.
Agreed with the order passed, the present petition is filed, seeking the following prayer. The petitioner, who is a borrower, was set ex parte by the tribunal. Then the petitioner has filed what is the IA number?
My lord,
Has filed an application under section 22H and F of the Recovery of Debts due to the Banks and Financial Institutions Act 2002, for short act, seeking to recall the order dated 10/9, 9 or 20?
Please, my lord.
Huh?
10/9/2020.
10/9/2020. That came to be dismissed by order impugned. Where is the order impugned?
annexure F, my lords, page 38.
Came to be dismissed by order impugned, whereby the tribunal has observed that under the circumstances, the reason stated with the petitioner for non-appearance of its counsel on 10/9/2020 cannot be easily accepted. And the argument of the learned counsel to the respondent applicant bank that its attempt is to protract recovery of amount due from it cannot be lightly brushed aside. If defendants are allowed to remain absent when cases come up for return of summons and get ex parte orders set aside on flimsy grounds like this, and that too even after the applicant bank had adduced its evidence, they can protract the cases against them as decided by them, which in effect would defeat the very objective of expeditious recovery under the Act. Hence, dismiss the petition. When counsel appearing for the petition submits that the petition has no intention to protract the proceedings. If an opportunity is not given to the petitioner, It would cause a lot of hardship to the petitioner.
It was a COVID period also. It was a COVID period also. It was
It
peak.
is during the COVID period, it is at ex parte. It is submitted that if a fair opportunity is given to the petitioner without delaying the matter, he would proceed with the same. When counsel appearing for the bank submits that right from the year 2023 till now, the petitioner is enjoying the interim order. In fact, in the OA, they have completed the entire, their evidence is completed. Now, if this writ petition is allowed, in fact, the prejudice would be caused to the bank. The OA is filed in the year 2016 until even after 10 years also, the bank could not realize the amounts. Next para, having got the counsels on either side, there is a material on record. Whenever an application is filed seeking recall of the order, the court would necessarily consider the reasons for the said, the reasons while recalling the order. As rightly observed by the court, the reasons that are stated by the petitioner cannot be the grounds on which the earlier order can be recalled. But this court is looking at the substantial interest of both the parties. The OA is filed in the year 2016. Then till 2023, the matter was pending. Again in 23, the petition has come before the court and obtained an interim order. And from 2023, the proceedings are stayed by this court. In view of the same, this court has reviewed that an opportunity is given to the petitioner. It would be in the interest of both the parties and it would put a quietus to the litigation. Accordingly, this court is passing the following order. The order dated so and so, passed in OA number so and so, is set aside. And the petitioner, you didn't file your written statement, your objections.
No, my lords, I have to file the written statement.
Written statement or objections it's called?
The basement. The written statement.
The petitioner shall file the written statement within 1 week from the date of receipt of the copy of the order.
A date should be fixed by them within that week.
No,
Your lordships may say the next
for the
date.
court order you can file.
The next date of my appearance.
No. Within one, I'll fix the dates now.
Very well.
Within 1 week from the date of receipt of the copy of the order. From there on, the DRT is requested to, as it's a old matter, the DRT is requested to conclude the case within 4 months within 4 months from the date of receipt of the copy of the order.
Yes.
You will get it tomorrow itself.
Very well.
From the date of receipt of the copy of the order, the petitioner shall not protract the proceedings. Even if any adjournment is sought, the court shall not grant unnecessary adjournments to the petitioner. Yes.
Very well.
Disposed of.
In fact, lords, one more fact I would highlight to lordships is they have an attachment order of my almost 10 properties worth more than 100 crores.
Yeah.
The liability is only 1.2 crores.
No, 5.61 crore, I think, wrong instruction.
The original claim is
The
1.2.
charge is
As on
100 crore.
5.6.
Properties, but then why anybody is mortgaging 100 crores property?
Because
for
I
1
have
crore?
placed ex parte and at the first instance on the date of filing, they have obtained an ex parte of attachment, my lords.
At least this case, you should have expedited.
In fact,
the
this is a
case.
claim without any mortgage. And they have attached so many of my properties. And it is an excessive attachment to the extent of more than 20-30 times of what is the claim, lords. So I am actually suffering, my lords.
That's why. No,
But
you're
nevertheless, that
no,
may
your
not be a
suffering will
point
come
for
to an end within
consideration
4 months,
at
provided
this
you
stage.
cooperate.
Very
Yes.
well, very well. I am highly obliged.
Yes.
54, Radhananji Shastri.
My lord, to appear for the petition in this matter, my lord. Yesterday, my lord, I was in the neighboring court, my lord, I was not able to be
Yes, yes.
present.
My lord,
No, my lord, what has happened in this?
A copy of the statement of objection, my lord, which I placed before this honorable court yesterday. But I'll make only one submission. Sale
He has
took place.
questioned the section 14 order.
Section 14 order.
Kindly come to your lordship's order dated 11/12/2025, my lord. Lordship has passed detailed order regarding the matter. But I'm neither the borrower nor the guarantor, my lord.
Seal certificate, my lord. What registered?
Yes, what are your?
My lord, here, my lord, sale took place. Sale certificate issued in respect of sale conducted by the bank under surface action.
No, no, not sale conducted. Is this a registered mortgage?
Mortgage in registered mortgage in my favor.
So
Sale,
property.
I'll make only one submission. Why, my lord, I'm making the submission. Now already third party, my lord, having sale certificate in respect to the property, which my lord, my friend is claiming. Altogether, my submission is the property itself different. Unless and until, my lord, the petition before this, my lord, the auction purchaser, which I already issued a sales certificate on dated, my lord, 23/1/2025, almost one year back. No, my lord, if he's seeking, my lord, some order, my lord, he should be present before this honorable court. Let him take a hand summons, so some, my lord, sales certificate also I produced before this honorable court. Let him also be
You
present.
made him a party.
I've already made him a party, my lord. Respondent number 2.
Please issue notice.
Only interim order may be extended, my lord. I'll take.
Extended, why will not?
Ready with my submission.
In fact, my lord, they have forged the entire document.
Where is he? Which respondent here?
Respondent number 2, my lord.
The notice to respondent number 2. Business matter after vacation, interim order earlier granted is extended.
Only I would like to
Delete
take
from
your,
for dismissal.
I would like to take a lordship to running page number 23 for a moment, my lord. What happens is.
No, we will see in his
Very
presence.
come.
Yes.
I pray for my lord respondent.
Yes, 65.
Grateful.
Sangeeta, Sangabanava.
My lord, here I have one proposal, my lord. If my lord will honor this, it would be grateful, my lord. My lord, 3 months' time is what the borrower is seeking for.
File an affidavit.
Yes, my lord, I'm ready to file an affidavit.
Essay pending before the DRT. Today, essay pending before, see, my lord, what had happened, sale SL before the DRT. My lord, in fact, they made a submission, we are going to pay the entire money. DRT granted some limited indulgence saying that subject to payment of some money.
Oh, that's an order question.
Same thing. In fact, today, my lord, they filed an application to implement the auction purchaser. My lord, that is, my lord, pending for consideration and DRT given. My lord,
where is the DRT?
My lord, I'll have to make the auction purchaser as a.
No, not necessarily. Do everything before the DRT. Where is the DRT order?
My lord, it is at page number 145, my lord.
$145.
Please, my lord. Counsel for the applicant present. Counsel entered appearance through caveat to respond bank. Applicant charging the sale notice fixing the sale of the property on 26/9/2025. Applicant contends that there is a proposal for selling some other property belongs to the
What are
applicant.
these page numbers? I'm not able to understand.
Even I don't have the page.
165, 97.
My lord, the office had raised an objection stating that preamble of the essay is not filed.
At least
When
you
that
have
was
to, you have
filed.
to strike out the earlier number. Where is that number showing, please show?
My lord, here my simple submission, my lord.
No, let me look at the order of the passed with the DRT. Take his file.
Huh? 145 ಇದೆ ನಂದು ಪೇಜೇ ಇಲ್ಲ.
And how about the numbering the writ petition like that? With 2, 3 numbers
Here,
of page.
It's not there. It's not there. It's not there here.
It's not there.
Lord, I'll pass on my booklet.
My lord, this is the order that I have challenged, my lord. But the respondent is
talking about the previous
the
order.
impugned order.
This is the impugned order. The respondent is
Counsel for
talking.
both sides present. The sale notice issued by respondent and bank is under challenge. Objections reported. However, counsel for the applicant seeks an adjournment. In view of the above, the respondent bank is permitted to confirm the sale, subject to the outcome of the essay, and receive the balance amount, if any. Then what is wrong in it?
My lord, at the first interim order was granted, I deposited 15 lakhs as per the interim order. Later, to prove my bona fide that I will be clearing in within short time, the honorable tribunal asked me to pay another set of 20 lakhs.
Now the auction, once the auction notice is issued, in that too, this is a case where auction is already confirmed by the order. You will not have a right of redemption now, unless and until the sale is bad.
Sale is bad, my lord, completely bad.
That you agitate before the DRT. Whether
Yes,
it
my
is
lord, but
bad or
confirming
not.
is also bad. Why, I'll tell you, my lord, because, my lord, to prove my bona fide, I was asked to deposit another 20 lakhs. And I sought for a week's time just to make arrangements, and the honorable tribunal passed this order, my lord.
So now it is subject to the result of the essay or the OA that's pending
My
before
lord,
the DRT.
Even then, my lord, now subsequently another order was passed for selling, issuing sale notice for other properties which were pending, my lord. In that also they have sold undervalued.
That is not subject matter of this writ petition. We
My
can't
lord, this writ
consider all
petition
that.
is also, they have sold it undervaluedly,
come.
my lord.
The writ petition
Here,
is filed.
my lord, one submission, my lord. I'm ready to file an affidavit.
No,
3
no, no.
months time.
We can't accept the affidavit now for the reason already sale is conducted. So confirm. The writ petition is filed, seeing the following prayer. The tribunal has passed an order whereby the sale notice issued with respondent, the tribunal has permitted the bank to confirm the sale, subject to the outcome of the essay, and receive the balance amount, if any. All further proceedings will be deferred till next posting date. When counsel appearing for the petitioner submits that the bank, the tribunal ought not to have permitted the bank to confirm the sale. It is submitted that by interim order, he has paid an amount of rupees 15 lakhs.
35 lakhs. till
35
now.
lakhs. It is submitted that now the petitioner is ready to deposit, if 3 months time is granted, is ready to deposit the remaining amount. Then counsel appearing for the respondent bank submits that the sale is confirmed. Essay is pending before the tribunal. If the petition is agreed by, petition has already questioned the sale. And if there is any irregularity, as the confirmation of the sale is subject to the result of the OA, result of the essay, the same will be considered by the tribunal. At this point of time, they cannot accept the amount from the petitioner. Next part, having heard so and so. Once the bank has issued the auction notification, under the light of the amendment 13(8), the borrower will lose the right of redemption. The petitioner has questioned the auction proceedings before the DRT. Now, this order dated 1/31/2026 is subject to the result of the OA. If in the pending essay, if the pending essay, the court comes to the conclusion that the sale that is conducted by the bank is irregular, so the court would be passing appropriate orders in that view of the matter. This court cannot find fault with the order passed by the tribunal, and this court cannot permit the petitioner or direct the bank to receive permit the petitioner to pay and direct the petitioner to receive the amount. In that view of the matter, the petition is disposed of, giving liberty to the petitioner to avail or to agitate all the rights before the tribunal in the pending essay.
My lord, including the details of the sale, my lord, that is not, it was not permitted to, even though I had filed an application, it was not permitted.
That you have to do there.
My lord, an observation may be made, my lord, that they may be directed to furnish me with all the details regarding the purchase, my lord.
The bank shall.
Only they have given us the.
You are not losing anything. The bank shall furnish all the details pertaining to the sale to the petitioner.
This BAFNA statement which my lord in 13(8), it is recently, my lord, in the month of April, the Supreme Court one more judgment in the case of my lord Central Bank versus my lord Sri International. They have taken a different view.
What it says?
It says that if he's paying the entire money, if he's paying entire money, in my lord paragraph number 14.
Give
Even
the
though
judgment, let's-
I'll pass it on, my lord.
Tomorrow we'll see. What it says, then this matter also.
No,
tomorrow-
not this matter, it will not applicable. No, I don't have any problem, my lord. Somebody is paying money, 5.68, I'll be in the beneficiary.
So what they say?
They say is, in Bafna
No, that
judgment,
Bafna,
Bafna said, one sale conducted, sale, then redemption is lost, whatever money paid.
From the day, it says from the issuance of notices.
Notice. Here, my lord, they distinguished, Bafna also, my lord, they relied, and they said that even.
Bafna is how many judges?
2 judges. Justice Padiwala and Justice, this judgment passed by, my lord, Justice Dipankar Datta, and I think one more judge. This also, my lord, passed by.
And with a reference to Bafna.
Yes, my lord. And Justice Satish Chandra Sharma. 2 judges.
We'll see that. Tomorrow you please give it to the
If
court.
anyway it is going to affect me.
No, it will not have effect on your case.
If I'm in benefit, then it may be mine.
Yes.
I'll pass on to you. Grateful.
Obliged.
Yes, next. No,
The paper will
nothing is
respond.
tomorrow. No, I passed orders.
Number 66.
Yes.
Petitioner, my lord.
Yeah.
My lord, yesterday I was held up in another court, my lord, inside.
Yes, yes.
My lord,
Section 14 order is held.
our
You before this court questioning a 14 order.
petitioners are, my lord, ready to pay amount. Some time maybe petitioners are ready to pay.
What is outstanding?
My lord, 47 lakh 61.
When you will pay?
My lord, 3 months time may be granted.
We'll list it on Wednesday. By that time, file an affidavit. Wednesday, we'll list this matter. By the time you have to file an affidavit. Then counsel for the petition submits that the petition is ready to pay the entire amount, entire outstanding amount. Then counsel for
My
the
lord,
respondent bank shall
I will-
indicate.
My lord, you pay some partial amount to, my lord, within some partial amount you will pay, my lord, some time granted.
So that's what I'm saying. For you file affidavit, we'll grant 3 months time you are asking.
Not entire amount, my lord, some.
No. I'll not pass that kind of order. If you're not ready, then no order.
Please,
No
my lord,
partial
Wednesday.
amount.
Wednesday.
Ready to pay the entire amount. Though the order that is questioned before this court is section 14 order passed by the magistrate. However, as the petitioner is ready to pay the amount, there is this matter on Thursday. By the time, Thursday is next Thursday. The petitioner shall come up with an undertaking affidavit or else the matter will be heard on the merits of it.
Grateful.
You indicate to him what is outstanding, Mr. Vignesh.
I'll, please, ma'am. Grateful.
Yes, 53.
Serial number 53. Pass over serial number 53.
Lord, I have to appear on behalf of Lord,
The auction purchase.
FDM lots for the petitioner.
First matter 2.1.
Only give the petition, nothing else. And the order sheet. Give the order sheet. This itself is weighing. From how long these matters are being listed?
At least, my lord,
20
adjournment.
Order sheets itself are like they're weighing around 2-3 kgs.
My lord, in fact, detail order, they went to writ appeal, my lord. My lord, of course. My
Yes,
friend is
my
came
lords.
recently. No, I'll not comment.
Lords, the counsel earlier, my lords, who was representing this case, lords, since expired, my lords, we have.
Oh, this matter, writ appeal about.
Same matter, my lord, pass a detail order.
Roaster order, yes.
Please.
Yes. What is the writ petition about?
Lords, the writ petition, lords, is raising, my lords, the legal issues with regard to, my lords, the following of.
Come to your prayer. I'm looking
Please.
at WP number 25944.
Yes,
Yes, let's look at your prayers.
yes. Lords, that is at
Page 22.
page 22, my lords. Issue an appropriate writ order or direction to the respondent Canara Bank to restructure petitioner's loan accounts in obedience of the directions issued by respondent number 1 wide annexure C, being notification dated 29/5/2019, published in Gazette of India dated 29/5/2019, and further in obedience to the direction.
So
issued by
you're
the Reserve Bank.
seeking
Lords,
some the restructuring of the loans based on certain circulars.
Lords, this is a notification, Lords, issued under the MSME, Lords, Act. Lord, it is mandatory. Even, Lords, the Honorable
Yes,
Supreme Court has,
let's see
Lords,
that. Let's see what it is.
please. Lords, that notification.
So, when was your account declared as NPA?
Lords, please. Lords, may I just point out, Lords, with reference to the dates. Lords, I borrowed the loan, Lords, on 23/9/2016. Lords, this notification, Lords, came in on 29/5/2015 of the central government. Then, Lords, this loan, Lords, was declared as NPA, Lords, according to them, on, Lords, 30/3/2021. Then, Lords, the demand notices were issued on 7/4/2021 and, Lords, on 5/7/2021. Lords, here, Lords,
So,
I am not, Lords,
what are your
deliberating upon, Lords, the factual aspects. Lords, I am only raising, Lords, 5 legal grounds, Lords, on
One.
which, Lords, I rest my case. Lords, kindly consider, Lords, the first ground is, Lords, under this notification, Lords, at page number 39.
Notification dated?
Notification dated, Lords, at 29/5/2015. Lords, that is at page number 39. Lords, page number 40, Lords. May I just read, Lords, only 2 clauses, Lords, in that.
Page number?
Page number 14, Lords.
Ministry of Micro, Small and Medium Enterprises notification.
May I read, Lords?
You are reading
Exercise of the
page
powers
number?
conferred under Section 9 of the Micro, Small and Medium Enterprise Development Act 2006. The central government, for the purpose of facilitating the promotion and development of micro, small and medium enterprises, hereby notifies the instructions for the framework of for revival and rehabilitation of micro, small and medium enterprises, hereinafter so and so, which shall come into force on the date of its publication of the official gazette, namely framework for revival and rehabilitation micro, small, medium enterprises. Identification of incipient stress. Lords, one, Lords, is identification of by banks creditors before a loan account of a micro, small and medium enterprise turns into a non-performing asset. Banks or creditors are required to identify incipient stress in the account by creating 3 subcategories under the special mention.
Fall
account
under which
SME.
category?
Lords, they don't categorize at all, Lords. They don't follow this notification at all. Lords, even 4 also, Lords. After categorizing, Lords, the loan account, then, Lords, 4. When such a request is received by lender, the account should be processed as SMA 0 and the committee under this framework should be
You're
formed
reading where?
immediately.
You're
No
reading?
committee is formed.
You're
No.
reading?
Lords, serial number 4, Lords, in the same notification. Same notification. Lords, after constituting the committees, Lords, the serial number 4 is concerned.
Application to the committee.
Yes.
So where is your application to the
Lords,
committee?
Lords, they declare, Lords, NPA. Lords, this provision says before declaring NPA, Lords, they shall follow this.
Oh, no.
Kindly see, Lords, 1. 1, Lords. Once again, Lords, at the
Yes.
cost of repetition, identification by banks or creditors before a loan account of so and so is declared as NPA. They straight away, Lords, they don't follow this. The RBI, Lords, is issuing guidelines, Lords, one after the other. And, Lords, they declare the Lords, my loan account as NPA, and they proceed, Lords, to put the property on sale.
No, Mr. Vignesh Shetty.
Please, my lord.
Under this notification, before declaring any asset of an MSME as a NPA, for that there is a procedure. Is it there or not there?
It's not there.
It is
No,
there.
no, my lord, I'll-
Next subsection may kindly be seen, my lords.
Where?
In the same notification, my lords, next clause may be seen. The first clause is identification of incipient stress. The next clause, my lords, there is also voluntarily by the enterprise, they can also identify. That is subclause 2. Identification by the enterprise. Any micro, small or medium enterprise may voluntarily initiate proceedings under this framework if enterprise reasonably apprehends failure of its business or its inability or likely inability to pay debts and before the accumulated losses of the enterprise equals to half or more of its entire
No,
net worth.
I remember.
The application for initiation should be with
Somewhere I've
affidavit.
seen in the judgments or in the circulars that before declaring any MSME account as NPA, there is a procedure.
Lords, I produce, my lords, the Honorable Supreme Court's decision on the very same issue. Lords, this second one, my lords, is an option available to me. Lord, I can come forward. I can, my lords, voluntarily ask for, my lords, restructuring or constitution of the committee. My lords,
When they have issued a 13-2 notice,
yes.
have you
Lords, I replied, my lords.
saying that I'm an MSME, I'm
Yes, my
entitled
lords.
for the
My lords,
benefit?
yes, my lords. My lords, while
They say.
they did not reply at all. Lord,
I
even,
just
my lords,
pointed-
that is also an issue, my lords.
So, have you replied to 13-2?
13 to I given. Thereafter, multiple repetition, multiple essay, everything.
They have
I'll just
replied.
point out because yesterday, they're serving one document saying that we served one reply in the year of 2021. Yesterday evening, they served a copy. After given this honorable report given at least 7 to 8 adjournment only as a final hearing. They're given.
Whatever it is, the fact remains is that 13-2 they have given a reply.
Whether,
What
my lord-
did you do to that?
my lord, I-
And is it not your duty?
I have to find out whether I received it or not. In fact, other
That is you ascertain.
apart from that, whether that reply will applicable to this case, in view of the Supreme Court judgment, I'll point out. In Swami Samartha case, my lord,
That is,
even though
Supreme Court judgment MSME, you forget. Even if it is not MSME, any reply that is given to
God
13-2,
permits.
you are bound to give a reply.
My senior is relying there at one judgment for it. I'll just point out the judgment itself, my lord, one odd occasion, my lord, that notifications have to follow.
Forget, this notification is prior to this.
That I agree, my lord.
So, once a 13-2 notice is, a demand notice is issued, they have given a reply. Whether it is an MSME or any other person, you are supposed to consider. And even the judgments also says about the 13-2.
It bears, my lords, the seal and signature of the officer.
The application yesterday, this.
You have given them the copy.
Yes, my lord, it is filed.
Please come.
Yesterday.
It is
In
filed.
the course of argument, land counsel, the petitioner submits that they have given a notice under, when a notice is issued, demand notice is issued under section 13-2 of the act, they have given their reply on
6/5/2021.
6/5/2021. It is a contention that either they have failed to follow the procedure as contemplated under the Ministry of Micro, Small and Medium Enterprises notification dated 29th May 2015, or they have failed to follow the procedure as contemplated under the Surface Act. When counsel appearing for the bank submits the act, these the different petitions are pending from 2020.
2021. My lord, at least,
From
my lord,
2021, and for the first time, now they have today.
and they served a copy to my
Today
lord,
they have
yesterday
served,
evening.
yesterday night, they have served a copy on the respondent bank stating that they've given a reply in the year 2021 itself. He submits that he would get instructions in this regard. The petitioner, the respondent bank will get specific instructions on this matter on 24th.
My lord, connected petition can be heard. My lord, that's heard by judgment, my lord, please.
Yes, next matter.
1928.
Use the next matter.
WP number 1928.
There is an interim order, my lord, sir.
No,
I mean,
interim order earlier granted is extended in that. Yes, what about this?
Please.
It is also same lines.
No, it's not MSME.
No, it is
Let's
this
see.
MSME only.
Surface Act.
It's
NPA definition has been
definition
challenged.
14.1 is constitutionality of section 14.1 is assailed before this honorable court. Covered by my lord.
Let's see the prayer.
Prayer may be found at page 41, your lordship.
Declare that in your concept of non-performing asset is a value-based. So they have questioned the constitutional validity of 210.
Of the definition of non-performing asset.
Pure writ of seditious as a whole para. What is this?
This is the prudential norms of asset classification. my
Issued by
lords.
the respondent number 3, Reserve Bank of India.
That is also definition of NPA.
NPA. 2O and 2OI. There is a
Issuer direct the GCL referred so and so statutory demand notice.
They're indirectly seeking to strike down the surface.
come to my lord. The synopsis which we placed on 11/9/2025.
Your places.
Please, my lord. It complete, my lord, authorities. Where, my lord, the very same advocate, my lord, filed a writ petition and writ appeal before this honorable court that my lord, on 22nd March 2022, this honorable court, my lord, dismissed the writ petition holding that, my lord, 14(1), my lord, constitutionality is upheld. In fact, the Supreme Court judgment also which I put. My lord, kindly come to, my lord, the synopsis which I filed it on, my lord, 11/9/2025.
Where is that synopsis?
I across the bar, my lord, I submitted on that.
Must be in the file, see. WP 19289.
I'll give you
Yes.
one more.
Oh.
I have a synopsis if I may.
It's there.
My lord, the petitioner has filed the petition seeking several prayers, including setting aside the clause V of first review section 14(1) of the Surface Act 2002.
Where are you reading that?
My lord, first page, first my contention in the synopsis.
First page is judgment.
No, in fact, it's out for the bar. I'll just point out one judgment and I'll leave it.
Oh, yes, petition about various loans.
Please, my lord. My lord can find it, my lord, first. Let to one word. Same, no? Madam, just.
No, with all the judgments given like this.
Not judgment, I filed separately on synopsis also.
Oh.
Along with the
I'll give
judgment.
a copy of it. Take that.
We don't have a copy of that.
We'll just see what is it.
But if I may, Manoj, both are connected.
No, it's not connected. It's covered, completely covered. This on the court.
Yes.
But so far as the validity is concerned, Lords, probably we may have to examine, Lords, since the
But it's
petition.
already upheld. There's nothing to examine.
No, Lords, I'll
I'll
go through, Lords, this, because what we have done, Lords, is that both the writ petitions are, Lords, arising out of the very same set of facts.
No. The judgments or whatever now they're saying, I'll take it this matter tomorrow itself.
Please, my lord, please.
This is matter tomorrow. Interim order, look at if any is extended.
Could it be on Friday, Lords? Tomorrow, Lords, election
Tomorrow
petition.
is not possible. Friday is not possible.
Election petition, Lords, cross-examination is there. That is why, Lords.
Then list the matter on 15th. 15.
Very well.
No further adjournment.
Very well.
Yes.
List number 2. Number 2. Serial number 1 for orders matter.
Beg to appear for the petitioner, my lords.
We keep all this here. Ask him no. Yes.
Serial number 1.
Appear for the petitioner, my lords. Lords, this is a case wherein Karnataka State Women Commission, only on the ground that, my lords, the partners have a dispute, they are females. My lords, the chairman entertains a complaint, issues notice to the petitioner. Petitioner appears and requests for a copy of the complaint. Instead of furnishing the copy of the complaint,
I am furnishing the translated copy of the communication.
Take that.
Last occasion, my lord, this got directed to file the translated copy, my lord.
kindly see that translated copy, my lords. Only on account of pendency of this writ petition, the police have closed the case.
This communication says, my lord, after issuance of.
Let's see.
Please.
If they are not going to trouble me, I have no issues, my lords.
Nothing has taken place, my lord. In view of the interim order, nothing has been taken place, my lord. We have requested the Assistant Commissioner of Police, my lord, to close the case, my lord. Because in view of the interim order, my lord, there was nothing has been taken place, my lord, in the police station.
File a complaint to Karnataka in the complaint shall take. Oh, this is the one with regard to the
Yes,
dispute
madam.
between the partners.
Yes, ma'am, between
And
partners.
the Women's Commission issues a notice.
Yes, my lord. That is the issue, my lord.
Then we'll say that, we'll set aside that.
Yes,
The presented petition is filed. Seeking the following prayer. All are served.
yes, my lord. There are,
Please, ma'am.
no, my lord. Private respondents are not represented, my lord.
They have been served, they have filed application for vacating
They are
stay.
served. They are
The-
served unrepresented.
The presented petition is filed. Seeking the following prayer. The petitioner, along with respondents 5 to 7, formed a partnership firm. Is a case of the petitioner by name Sri Venkateshwara Agency on 10/9/2006 with the object of carrying on the business of oil agency and other businesses at number 147/7 Mysore Road near Sesri Circle, Bangalore. The respondent number 5 on 10/12/2021 has approached the respondent number 5 Respondent number 5 approached respondent number 2 with a representation signed by respondent number 6 and 7 also, alleging that after her husband demised 3 years ago, she along with her children, that is respondent number 6 and 7, were not receiving any kind of remuneration or monetary benefit from the firm. It is further alleged that they were not allowed to handle any kind of accounts maintenance of the firm, and the petition is not allowing them to monitor things. Basing on the same, the respondent number 2, by making file noting that the issue requires to be resolved through her, directed issuance of conciliation notice to all parties. However, the notice was issued informing petitioners that complaint was received by the commission and hence they were directed to be present on 27/12/2021 at 11:30 a.m. in person along with all documents. Petitioner appeared in person before respondent number 2 and submitted his representation, informing that without service of complaint, calling upon petitioners to appear for an inquiry was illegal. He requested to provide the copy of complaint along with accompanying documents, proceeding sheets, and further submitted that only on receipt of these documents, needful action can be taken in accordance with law. Respondent number 2 on 27/12/2021 passed an order without recording anybody's statement in the manner known to law, disposing of the complaint by advising the parties to settle the issue mutually. Strangely, in the said order, respondent number 2 has found fault with petitioners for having requested for copy of the complaint. On the very same day, after the petition number 1, I have left the premises of respondent number 2. Respondent number 5 to 7 gave another representation with inward number 3616 informing respondent number 2 that they were going to take control of petrol bunk and petitioners may object to the same. There was a possibility of threat from petitioner and hence requested for protection. Respondent number 2, based on representation, has proceeded to pass an order on 1/1/2022 informing him about the apprehension expressed by respondent number 5 to 7 and directed him to take action in accordance with law against the petitioners and report the same within 15 days to the commission. Agreed thereby, the petitioner is before this court. When counsel appearing for the petitioner submits that the second respondent commission has no authority to pass such an order. It is purely a dispute between it's a purely business transaction between the petitioner and the respondents. It is stated that the order that is passed by the commission is contrary to the principles of natural justice and to the provisions of the Act. The commission, the second respondent commission, has no authority and jurisdiction to enter into these kind of commercial disputes between the parties, and it cannot direct the respondents to provide protection.
Yes, ma'am. To register a case against the.
To provide protection and to resist, and also passed an order to register a crime against the.
And file a report, my lord, within 15 days, my lord. Based on that, my lord, notice was issued. That also stands before this court, my lord.
You issued the notice.
Yes, my lord.
And it is submitted that the police have no jurisdiction. Police cannot issue a notice.
Respondent number 4, my lord.
Respondent number 4 cannot issue a notice. And it is submitted that both the notice as well as the order that is passed by the Women's Commission is not sustainable. Though notices are served on the unofficial respondent, wakalat is filed. No representation on their behalf. Though wakalat is filed, there is no representation on their behalf. Learned AGA submits that pursuant to the orders, the interim order granted by a coordinate bench of this court.
21 to 22, my lord.
20?
21 to 2022.
21 to
2022.
2022. No action has been taken. In fact, they have given an opinion to close the
Oh,
complaint.
my lord. The petitioner appeared before the IO, my lord, and in presence of the IO, my lord, they have provided the statement to the complainant, my lord. Thereafter, my lord, we have requested to close the petition to the ACP.
It is submitted that.
Audit report
How you
was
have
furnished.
requested?
No, my lord. On the basis
Requested
of
whom?
on the basis of the notice, my lord, the petitioner represented before the IO, my lord, and furnished the copy of the statement, my lord, to the complainant. Thereafter, my lord, we are recording the same, my lord, we have requested the assistant commissioner.
What statement? Account statement.
Account statement, my lord, for the year.
So you have settled there is a dispute between
Just
them.
it-
It is submitted that after the notice, the petition has appeared before the IO and he has placed
Annual audit report, my lord,
annual audit report
to the complainant.
And basing on that, they have closed the complaint.
Requested the assistant commissioner of police, my lord, to close
Requested
the
the
petition, my lord.
assistant commissioner
To close the petition, my lord.
close the
Petition.
to close the
Since
petition.
the writ petition is also pending.
To close which petition?
Present writ petition, my lord.
This
After
present writ petition.
furnishing the audit report,
the
my lord,
writ
they approached
petition.
this court, my lord.
No, what happened to the you have issued a notice.
Yes, my lord.
Uh,
The petitioner represented
has
before the IO, my lord.
represented.
In the presence of, in the,
He has given the statement to her. Then
then we are requested.
you were requested the Women's Commission.
No, my lord, assistant commissioner of police, my lord, to close the higher authority, my lord, to close the petition since it was a dispute between the parties, my lord, it is pending.
And they have
for consideration.
requested to close the proceedings as this is a purely a civil dispute. Next, for having other concerns this side. There is the material on this one. On the face of it, the impugned proceedings before this court. That is, the order passed for the respondent number 2 dated 1/1/2022 and the notice dated 9/2/2022 issued by respondent number 4, or without any authority of law. The disputes between the parties are purely the commercial disputes. Commercial dispute between the parties, and the Women's Commission has no role to play The second respondent has exceeded the jurisdiction conferred on them and has interfered in these disputes and passed order dated 1/1/2022. In that view of the matter, the court is passing the following order. The order dated 1/1/2022 and the consequential notice dated 9/2/2022 are set aside and the writ petition is allowed.
Please.
Rajshekar for petitioner.
Petition notes are sought for mandamus notes to conduct investigation pursuant to the complaint note filed by the petitioner. Notes on the last date notes, respondent state submit notes, they have filed C report. Notes they have issued.
They have filed a B report.
C report. Now they issued notes, they have C report notes. With liberty to challenge that note, this petition may be.
When was that C report?
Notes on
22/6/2020, my lord.
the in their 2020 itself notes they were.
And he is not aware of that
But
report.
notes it was not communicated notes, I would not aware of the fact.
Communicated.
So it will be communicated. After communication, my lord, it will be filed before
No,
the
on the
magistrate.
B, on that report, his signature is there. Party signature is there.
It will be there.
No, what remains? 2020 we have C report, now questioning it. What will be available to them? The present writ petition is seeking the following prayer. Then HCGP submits that.
Submission notes. The petitioner has died, my lords. I filed application. That may be not restrict. Notes, the petitioner has been died, my lords, on 13/10. The 3 applications are still pending.
No, it is what will remain in this?
Please, my lord, that may be disposed of.
This the petition is filed. See the following prayer. It is submitted that the petitioner is no more. Land Council, then the CGP submits that they have already filed a B report on 22/6/2020. C report on 22/6/2020. Hence, nothing survives for consideration in this petition. Accordingly disposed of.
Then three. Gautam Devji Ullad.
Waste time filing objection for impleading application. Impleading application.
What is, first of all, let's see, what is this writ petition about?
Lord, one submission. The petitioner who filed the writ petition, Lord, has expired. What they did was, Lord, they filed a writ petition Read me as a respondent, not in the writ petition. Application writ petition is to consider representation to the police to provide police protection. I am deleted from the area of parties. The writ petition not is disposed of on the ground that police protection to be provided as per Lalita Kumari's judgment. After which, the contempt petition is filed. The contempt petition, what is done is the police officer is made to enter the witness box. I am not saying that no action is taken. You're saying this is civil remedy. The police, in fact, not a report is filed saying that there's a lot of dispute because not I also my vendor also has a decree against not the petitioner here. He gets a decree against the government that is by way of adverse possession. That is a virtual ex parte decree. Government does not contest, which goes up to the Honorable Supreme Court. Because of that, not on that basis, he also gets an injunction against not my vendor and is against me. My vendor has an injunction against him in respect of my property. What he does is all this not is not brought to the court notice, only direction to consider if this granted. On that basis,
We'll hear this matter. This is on 21st and all remaining other matters, give dates.
there is no other matter not it is.
No. I'm referring to the other matters in the list.
My lord, one submission. There is a writ appeal. Again, is that
Let's see, I have to hear.
22nd.
It's
Can
all
it be
other
on
matters.
22nd notes?
It can come tomorrow. Look at the
22nd
list. Basing on that, you adjust.
Can it be on 22nd notes?
Yes, 22nd.
Great.
My lord, kind indulgence, my lord. Serial number 7, my lords expresses because it is already BDS writ appeal and Supreme Court has upheld the order of the learned single judge in favor of the petitioner.
This matter.
Only my learned friend is also.
Petition is virtually infectious because this matter, list it as first. One more matter. This list as second matter tomorrow. Top of the list it will come.
My lord, serial number.
Tomorrow it will come on the top of the list.
Please. Sorry, my lord, yesterday I could not able to.
Yes.
Serial number 52. 52. Day after.
Serial number 7.
Ask, you can take the adjournment from the court officer.
My lord, serial number 11.
Please wait. Please. Ask them as per their dates to adjourn it. Till then.
Good.
No, ask her to show it to me and tell her.
Lords, if the
My lord, serial number 11, my lords.
Ask the court officer, she'll give the dates.
Madam, interim order is extended.
Yes, 22nd.
Madam. Interim order extended. Nale.
Madam, serial number 8 next week, madam. Date.
Serial.
One ನಿಮಿಷ sir.
Serial number 8 next week, madam.
After vacation.
Court officer, court officer, 2 weeks time. Court officer, court officer, am I audible? Court officer, court officer, court officer, court officer, court officer. One submission, please.
ಸರ್ ಹೇಳಿ ಸರ್ ಏನ್ ಬೇಕು ಹೇಳಿ. ಹಲೋ ಸರ್.
Madam, ನಮ್ದು madam, serial number 8, list 2.
ಲಿಸ್ಟ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 8.
ಹೌದು ಮೇಡಮ್, ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್ ಡೇಟು.
ಅಲ್ಲ ಸರ್ ಒಂದ್ ನಿಮಿಷ ಹೇಳ್ತೀನಿ ಕೇಳಿ, ಅಲ್ಲಿ ಟೈಮ್ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು ನಾಳೆಗೆ. ಅದು 21/4/8.
ಮೇಡಮ್ ನಾಳೆಗಾ?
21/4.
ಓಕೆ ಓಕೆ ಕೋರ್ಟ್ ಆಫೀಸರ್, ಥ್ಯಾಂಕ್ ಯು
ಮೇಡಮ್ 52 ನಾಳೆ ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ R2 ಗೆ.
52 ಇಲ್ಲ ಮೇಡಮ್ ಆರ್ಡರ್ ಆಗಿರೋದು ಇವ್ರೆ, ನಾವು ಅದನ್ನ ಮಾಡಕ್ ಬರಲ್ಲ. 50
52
51.
ಆ ಪಿಟಿಷನರು ಪ್ರೆಸೆಂಟ್ ಇರ್ಲಿಲ್ಲ, ನಾನ್ ಪ್ರೆಸೆಂಟ್ ಆದೆ, ಟೈಮ್ ಕೇಳಿದೆ, ಅದು
ನಾಳೆಗಿದೆ.
ನಾಡಿದ್ದು.
ಅಲ್ಲ ನಾವು ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ, ಡಿಕ್ಟೇಷನ್ ಆಗೋಗಿದೆ, ಅದು ಫೈಲ್ ಹೊರಟೋಗಿದೆ ಇವ್ರೆ, ಆರ್ಡರ್ ಶೀಟ್ ಸೈನ್ ಮಾಡಿ.
ನಾನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದೆ ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಅಂತ ಹೇಳ್ದೆ, ಬಟ್ ಲೆಟ್ ಅಸ್ ಸಿ ವಾಟ್ ಹ್ಯಾಪನ್ ಅಂತ ನೋಡೋಣ ಅಂತ ಹೇಳಿದ್ರು.
ಅಂದ್ರೆ ಆ ತರ ಡಿಕ್ಟೇಷನ್ ಆಗಿರೋದು.
देखो फिर